Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going to the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Sorry, folks. Sorry. It's a complicated business. I've had stuff to do today. I had a kid who got sick at school. I had to go and pick her up, and then she needed to be taken to the doctor, and the urgent care was totally full. And so then I had to make an appointment with her pediatrician. It was a nightmare. And then they couldn't get her in until 1. So my whole day was just taken up, just gone. So I'm sure she'll be fine. But those of you, but when it rains, it pours. Those of you who know my parents, please say some extra prayers for my mom. She's going through some terrible health stuff right now, and nobody knows what's wrong with her. She's been having absent seizures, 10 to 12 of them a day, that are just exhausting her. Neurologist is completely flummoxed. They have no idea. And she's just so tired. So those of you who pray, my mother's a praying woman, and she would really appreciate it. I know you guys have met. If you follow me on Locals, you know that my parents have been a part of my Locals channel, and I interview them sometimes, and we have a really good time with them. And I know you guys know that I was there in April when she had a really bad scare with sepsis, and she came out of that. And I believe that she can come out of this too, but it's just really hard. My parents are really suffering right now, so I would just appreciate it if those of you who do pray would pray for my mom and my dad, because they are really struggling. It is not fun to get old, and it's really not fun to be told that the best neurologists in the country have no idea what's going on with your brain. Yeah, it's not good. The good news is my parents have really good doctors, and they have some really good caring doctors there in Scottsdale, Arizona, at the Mayo Clinic where they go, and also other hospitals that they go to. They have really good, caring doctors who care and are trying to find out the answer, unlike Maya Kowalski, who does not have a whole lot of caring doctors in her life, or at least didn't. Um, and that's what we're talking about today. That's what we're talking about in this case. And I did want to say something about the way I cover this trial. All of you know I have a bias. I'm biased against the state. I'm biased against the hospital because I've seen too many of these stories. I've seen too many. I've covered too many. I've seen the playbook too many times. It's like once you've looked behind the curtain, you can't see it again without seeing what's behind the curtain. So that's why I come at it from the direction I come at it from. I don't believe that Munchausen syndrome by proxy is a real mental disorder. I believe that there's child abuse, and that's it. You're either a child abuser or you're not a child abuser. And I believe in this case, Johns Hopkins has not proven in any instance yet that there was evidence of child abuse that should have resulted in a call to DCF. I think they failed to care for their patient. They failed. And something I was thinking about when we went over Bonnie, I'm breaking out. I have this horrible blemish here that is really hurting me, and it's bright red, and I feel like it's just like wah, wah, wah. And I can't put anything on it. Anyway, yeah, pay no attention to the state behind the curtain. Exactly. And I just want to say, I was thinking about this. And Bonnie Rice, you know Bonnie, the nurse or whoever that was at Tampa General. Well, we've had our fun with Bonnie. You know this one, the mind reader. We've had our fun with Bonnie, but I did think that she was a better witness for the defense than most of their witnesses. But one of the things that stuck out to me about her testimony was the part where she talked about patients with conversion therapy. By the way, we're streaming on Rumble and on YouTube and on Facebook. So if you're at any of those places, welcome, welcome. Don't forget to hit the like button and subscribe. I liked what she talked about with the patients with what they call conversion disorder. We are going to learn a lot today in the trial today about conversion disorder. And it's not what I thought. It's actually something that could be neurological, your neurons in your brain causing the pain. So the pain is real, but it stems from the brain, which is why they consider it. It's not really even a psychological disorder, apparently, but it's a perhaps neuropathic. I don't know. We're going to learn more about that because there was a doctor, I think he was from Chicago, one of the Chicago hospitals, who talks at length about that today. But that made me think of Bonnie's testimony. And when she said, if you think I sound really down, I am a little down about my parents, but also I'm being quiet because my daughter, who is not feeling well, is sleeping back there. And she's in the same room as me. So I'm trying not to be too loud. So I'm keeping it down. We're going to have an ASMR stream tonight. So anyway, Bonnie's testimony about how to deal with patients with conversion disorder was very interesting. She said that you never confront a patient with conversion disorder. You just simply stay very positive and encouraging. I appreciated that part of her testimony. I actually thought, well, she sounds like somebody who's actually doing the right thing. Whether she got the diagnosis right or wrong, at least she wasn't torturing her patient. She wasn't doing bad things to her patient. She was trying to keep it positive. So I may have to take her off the munchie bunch on second opinion. While I do think she's a gossip, and I do think that she's CYAing for her friends at Johns Hopkins, she may not deserve the munchie bunch compilation that I've made. However, there are plenty more that belong there. This conversion disorder thing is very interesting. And we're going to learn more about that today. But I was wondering, and there's a poll in the YouTube chat, do you guys want me to start at the beginning of today, or should we go to the end? Because I just tuned in for a little while, and the judge is really going off on why don't we know what the hospital is alleging? Why don't we know whether they're alleging if Beata had Munchausen? They're playing very loose with what they're alleging. Are they alleging that she has CRPS or doesn't have CRPS? And the judge points out the very thing that I have been saying, which is the defense wants to play it both ways. Sometimes they're saying, oh, she does have CRPS when it comes to the damages. Well, she had CRPS before, and she's going to have CRPS forever. So, it's not our fault that she's going to suffer. While at other times, they want to lean on this conversion disorder diagnosis to say it wasn't CRPS. So the judge is calling them out. Do you guys want to start there, or do you want to start at the beginning and then go back? I mean, at the end and then go back? Because I kind of want to see what's going on there. I'm very interested in what's happening now. So I'll wait for you guys to kind of answer that. Right now, 69% of you want to start at the beginning, which is okay with me. Either way is okay with me. I just kind of want to know what they're doing. Let me see what Rumble thinks. Oh, you got your Tumblr, Jill Bell 70? Do you love it? Did you get the stainless steel one? Which one did you get? Did you get which one? Tell me which one you got. I want to know how that went. All right, what do you guys think on Rumble? Because I can't put a poll there, which is something they should really get on. Polls would be fun. I don't know why I can't ask a poll, but I would like to. Oh, mod powers worked. Yay. Okay. All right. So I finally have a mod on Crazy Warlock. Thank you for being a mod on Rumble. So Rumble is voting for the end first. Deb's voting for, and Rumble is voting for beginning. So now you're 50-50 split. All right. How's the poll going over on YouTube? We're at 37 start at the end, 63 start in the beginning. The morning was more interesting. All right, well, I'll just go with what the crowds want. The crowds want the beginning. But we may skip around because I do want to get to the end of today before I quit this stream, because it's not going to be a super long stream. It's Friday night. It's pizza night here at the Fox household, and I really want to go have pizza with my family when it's done. Okay. I have a new meme for you guys. Oh, this is another thing I wanted to say. So you guys know, those of you who've been here a while, you know how I am. You know my style here. And we have a lot of fun here. And we do a lot of mockery. I like to mock bad people. I think it's really good for them. Like this, for instance. No cake or Jesus for sick kids at All Children's Hospital. They threw Jesus in the dumpster. Yep, they did. And I think it's perfectly legitimate for me to meme them and make fun of them and mock them for. I ran this past one of my Catholic friends on PJ Media today. I was on a live chat with Stephen Cruiser, and I ran this past him. I told him what they did, and he was outraged. There was a non-Catholic on the panel who was outraged. It's an outrageous thing that they did. And if you ask me, I truly believe that bad people need to be ridiculed. When people do bad things, they need to be ridiculed. Now, that doesn't mean that I think you ought to be contacting these people. I don't think you should be emailing them or calling them or anything else. Don't contact them at all. That's a bad idea. Besides, we don't want to drag YouTube channels into this trial. Like, remember when Tug got called into the to the Johnny Depp trial? It's very uncomfortable when that happens. And then it lets NBC write hit pieces about LawTube, So we don't know. We don't want to do that. Wheezy says, I knew someone clever would make this for you. Well, that someone clever was me. Thank you very much. Because no one sent me it. I asked for it, but nobody sent it to me. So I did it myself. But I wanted to explain why I do things like this. I want to explain because sometimes, people will say it's insensitive. These are people too. Yeah, they are. They are people. They're people, though, who got together and did a really bad thing. Were they just doing their jobs, like others have said? Well, remember, they're just doing their jobs. Look, that didn't work for Hitler's boys. That argument didn't work at Nuremberg. And I don't think that it ought to work for hospital employees either. Each person has a conscience and free will. And you have the ability to see what's happening around you and to say, not me. I will not participate in this. I will not participate in taking a little girl's consecrated host away from her. I will not participate in taking holy water. I will not participate in keeping a priest from seeing a child who's sick in the hospital. I will not participate in that. Everybody has the ability to do that. And if you don't do it, and we catch you not doing it, we catch you going along with evil, cooperating with evil, which I truly believe this is. I think some people were just doing their jobs. Like, for instance, I think the ER doctor, for instance, this one in the middle row on the right, I think she's one of the least bad ones of this crew. I think the doctor in the middle bottom, also one of the least bad ones. Those two were doing their jobs. They didn't appear to have done too much CYA. They were doing their jobs. Um, there were some people in this who were doing their jobs. And then there were other people who went out of their way to make a family feel intimidated, to feel threatened, and to hold a little girl down while she was screaming and crying, to shove a tube down her nose and or strip her and take photographs of her. So no, I have no qualms about mocking those people. None. And I don't think I have actually studied Saul Alinsky's Rules for Radicals. And in Saul Alinsky's Rules for Radicals, this is a book that Antifa and people on the left have used over the years to get what they want and to agitate and do community organizing. You've heard the term community organizer. Well, this book is a very effective book. And the very first rule, I believe, is that ridicule is your greatest weapon. This book it's a fantastic book for anyone who wants for the Davids against the Goliaths, really. If you're a David and you're going against a Goliath, like a giant hospital with $1 million lawyers, you must understand that ridicule works. And what it says in the book is institutions don't hurt, but people do. So if you want to affect change, yes, this is why they hate memes, JD Buck. This is why they put people in jail for making memes, because they're effective. I actually, as I was making this meme, I was like, oh my God, am I going to one day get put in jail for this? That guy who made the meme about the election, about the oldest joke in the world, telling people that election day is a day later, got put in jail for 7 months. That's how effective memes are. That's how effective ridicule is. So, yeah, don't let anybody make you feel bad about ridiculing the government or their agents when they do bad things. Let me tell you something about Ms. Threw Jesus in a dumpster here, Nias. She worked for the state. She's a government jackbooted thug who took Jesus and cake from a child. And if you think I'm not going to ridicule that, you've got another thing coming, because I'm going to ridicule that all day long. This, I may make my profile photo. She threw Jesus in a dumpster, and I am never going to forget that. I'm just never going to forget that. Of course, it's a First Amendment right to right was violated. It doesn't matter now. We live in very dangerous times. And this is what this case is about. It's about tyranny. It's about resisting tyranny. It's about fighting back against tyranny. And what we have right now, we have people from January 6th who are still sitting in jail 2 years later without a trial. You think that's not tyranny for trespassing? I don't even care what they did. I don't even care if it was murder. You can't sit in jail for two years without a trial. We have due process rights all over the place. And if I'm going to be told it's too far to ridicule these people, oh, that's too far. We can't, that's too low, that we can't make jokes. We can't ridicule people who violate our civil rights, who put our very liberty in danger. No. It's ludicrous. And ridicule is our greatest weapon against this. When you don't have power and you're going up against people with massive power, like Johns Hopkins All Children's and the state. What do you mean you have no video on YouTube? Refresh. What happened? Is something happened to YouTube? You have a spinny thing? Huh. I'm getting nothing. Can you hear? It's not me, guys. It's not me. Everything here is working good. I would suggest you close out your YouTube and go back in. And Rumble, how's Rumble doing? Can you guys see and hear me? It is, you've got another think coming. It's not thing, it's think. If you think this, you've got another think coming. Isn't that weird? I think I often say thing, though, just out of habit, but it is think. You've got another think coming. All right, so Rumble is working fine tonight, guys. So let me drop the Rumble link in the YouTube stream in case YouTube is crapping out. And here you go, in case you want to go over to Rumble. But all right. So the point is, I don't agree with anybody who says that we have to be, just be nice. Just everyone was just doing their jobs. Because that kind of thinking is going to lead to more tyranny. No, you have to get up, you have to be loud, and you have to start ridiculing bad actors. And ridicule works, that's all I'm saying. So go ahead, ridicule away. There won't be any moderators in my chat keeping you from doing it. Just, it's what we do here. Until they throw me in jail, that's what I'll be doing. So I don't feel bad about it at all. All right. I will say, though, there were a couple people on the stand, at least that one doctor from Chicago, who I thought was, I don't know how he helps the defense. The defense put him up there, but I thought everything I heard from him, nothing conflicted with what the plaintiff has been telling me. And he even gave some really good information about conversion disorder that I didn't know before, that I think we should learn about. Because conversion disorder is not Munchausen by proxy, which is what the hospital accused Beata of having. Now, I wanted to start, I'm not going to go through, let's see. I don't want to start at the very beginning, but I did miss some of these things. All right, we're going to speed through some of this and see if any of it is interesting.
Agreement by stipulation. The court's going to receive 3029. 3050 pages 1 to 16, 3055 pages 1 to 15, 3124. Looks like, is that all of the agreements?
Yeah, so.
Okay. Well, Ms. Crow, what's next?
Judge, I'm going to address one that needs to be in before we play the video deposition. That would be 31352. They say it's already in evidence, but we checked, and these are photos that were taken by Dr. Major, and they did put in some, but we didn't think this particular photo was in. And it's the one that's used on the video with the doctor.
Madam Clerk, is 3135-0002 in? So it is not in? Any objection to 3135-002?
No.
Court receives into evidence 3135-0002.
Thank you. And then the next one that we would want in. I thought I marked it. Just give me a second, please.
Yeah, I got a screenshot of his own, of the plaintiff's munchie bunch.
Thank you. 3233.
They had the same idea I did. Thanks for the super chat, Wonderland. On today's episode of Harpies and Hags,
Your Honor, these are the WordPress blogs authored by the Kowalski.
let the ridicule begin.
Yeah, we're not admitting all 257 pages. We've selected just the pages of the blogs. Not some of them follow what people can comment online. We're not seeking to admit the comments, just the words of Mrs. Kowalski.
Was this the exhibit that there was a disagreement on authenticity?
Yes. Well, I did ask Mr. Kowalski during his direct examination whether his wife authored WordPress blogs, and he said yes.
There's a deposition of Georgia Kimball, who set up this WordPress blog, and her testimony is all over the place. She offered some of it. She doesn't know which part she authored. She doesn't know parts Beata offered. Jack was never involved. I think his testimony was he knows nothing about the blog. He never seen the blog.
the answer is you're going to have to, with evidence, demonstrate the authenticity of whatever you're trying to get in.
Through, can I say deposition testimony to the court?
Well, it's got to be sworn evidence.
Yeah,
Deposition.
Yeah, we'll I guess we'll have to make a proper one. Yeah, you have the sworn deposition testimony of Ms. Kimball, and respectfully, it says something different than what plaintiff says, but we'll have to make the proffer on Monday then. I understand.
It's just, I mean, I remember this one being, I recall plaintiff saying that they were objecting to the authenticity, so that's been a well-known issue.
All right, we will put together a legal memorandum and give you page line citation.
Right, and you're going to have to, since it looks like you're going for selected pages, I'm going to need to see that those pages were, that you're going to have to prove the authenticity of those. Because if it's somebody other than Maya Kowalski or Beata Kowalski or Jack Kowalski, or conceivably possibly Kyle Kowalski, then you've got a hearsay problem with probably no exception.
I understand, and the inverse, I assume would be true, that if we could show that it was one before, it would be received as a statement. I understand, but we'll put together
If it's authentic and you can show that it's, you know, a statement against interest by, you know, party, then certainly that might be a different story. What's next?
Okay, moving on, Judge. We'll go to page 1, 30191-14. The J Hatch Interdisciplinary Clinic Practice Manual, Medical Legal Policy, Images and Recordings. Their objective is unfair surprise. This was listed on our exhibit list of 9/1. It was also produced to them on 9/3. They never filed
Which year?
objection. And it was
Of what year?
of 2023.
Okay, so after the discovery cutoff date.
It was also produced. They sent us a notice to produce a trial, and that's DIN number. I wrote it down. I must have DIN number 3311. They asked us to produce at trial policies and procedures regarding the preservation and retention of videos, photographs, and electronic communications. So I don't know how they're going to say surprise, Judge. It was produced pursuant to their request. It was also listed on our exhibit list. When they filed all their objections to our exhibit list, they did not object to that one. They filed their objections on September 8th, after we filed our list on September 1st. So I don't understand how they're surprised.
Those are produced to us. This is the first time that we've seen it. It might have been mentioned on an exhibit list at DIN 485, going way back to September 30th, 2019. We sent a request specifically for any policies, procedures, etc., concerning the video surveillance of patients. And in their response, again at DIN 485, we were told none. So we've operated for 4 years on the premise that this does not exist. And to say that they produced it at trial when the first time they raised it or even show us a copy is last night, it's not bait stamped. It's unfair surprise, and we don't have to use it in our.
What is this? What is it? I'm trying to look at my big screen here to see what it is. I can't read it. Why are some of these things so blurry? But it just looks like policy. But I can't tell from if it's from Johns Hopkins or from someplace else. Maybe the Child Protection Team. I don't know.
Judge, this is factually incorrect. It was produced on September 3rd when we produced all.
September 3rd, 2023.
That's correct, sir.
And the
But
document request for this issue, specifically number 4.
The response is at 485.
Okay, then 485, which is November 30th, 2019. So four years before.
Judge, it wasn't located until they did their notice to produce at trial in August. And
No, too late. I mean, look, if
had
you had a 2019 request with a response of none, and then on the eve of trial saying, oh, here it is, that's too late. What's next?
Too late.
3023, I'm confused by their comment. I don't recall withdrawing the criminal admission of 4916. I don't believe that's.
I think what you said was that we discuss it later.
Oh, that's right. Thank you. That's right. Because we're going to have the testimony of Dr. Alexander.
There's
about
a
the
fruit
issue.
fly in here.
Okay. 3030.
Well, are we dealing with 3023 at this point?
No, sir. I think you said you need a predicate laid for the history, and that would be through the testimony of Dr. Alexander.
Thank you. What's next?
3030.
Oh my God, this fruit fly is going to drive me crazy.
What is this?
This is Dr. Hannah's ketamine standing orders.
For Mike Kowalski, or just like a form that he uses in his office?
This is the form that he uses in his office.
Here's my new compilation
It's
of the
not
Munchie
dated form,
Bunch.
It's not signed by the Kowalskis. It's not evidence is represented the Kowalskis.
I added the
There's no
cop.
evidence if it was created 2016 or
From
2016,
today.
treating this patient or afterwards. So we object to relevance, authenticity, hearsay.
Was this form used with Mike Kowalski?
Not that we're aware.
Yeah, I mean, these are the standing orders that were in effect at the time.
We have one person argue.
These are the standing orders that were in fact, this was produced to us through Dr. Hannah's office, Judge, when we subpoenaed the records.
Well, I understand it certainly is a hearsay document, but let's talk about if it was used with Maya Kowalski, I can see the relevance. But if it's just here's a form in his office without any connection with the Kowalski family, then why is this coming in?
Well, it's a standing order and it was used with.
We see a standing order. it's not a standing order in the Kowalski case. It's a form that he uses in his office.
For ketamine patients.
But, and again, I go back to, did he use it in the Kowalski file?
Yes, that's my understanding.
So you'll have this form annotated with Dr. Is it Hannah's handwritten notes with respect to Maya Kowalski, right?
Let's revisit it, Judge.
Or are we all here?
Two missing accident on the interstate.
I know you're not. Okay, please, somebody
Oh,
else-
the accident on the interstate. I heard that caused a lot of
Judge, we'll
problems.
revisit this with Dr. Hannah.
Okay, but look, if Dr. Hannah's records has that form filled out in the Maya Kowalski, it's one thing. But if it is just a piece of paper in his office, then no.
I understand it, but if it's a form that was in the file when we said, give us your records regarding Maya Kowalski, even if it's not filled out. If it's part of the record, he produced a response to a subpoena for your records regarding Maya Kowalski.
If it's filled out with Maya Kowalski's information, then I think it's materially different than a blank form that's used in his office.
Correct.
What's next?
3044.
Oh, I forgot to say this. I do separate the lawyers, though, from their clients. We like to make fun of Shapiro and Elton Brederhoft or Elaine John, but I think that's all good-natured. I think they're all decent attorneys. Obviously, they're very smart, especially Altenburn. And I think Shapiro's doing a great job. I have not heard anyone raking him over the coals in any way. He's just doing, the lawyers are definitely doing their jobs. It's still fun to razz them a little, but I mean, they're doing a good job for their client, I think. I would hate to be making this dick defense though. Really.
3044.
And 3045 are going to be some of the conversations.
3044, pages 1 to 3.
So this is Dr. Sally Smith's preliminary medical evaluation report of 10/13/16.
Okay. This is what I wanted to see. Oh, these are the documents that we get from Sally Smith and DCF and whatever. This is part of her report. Dang it. I thought it was going to be clearer than this. Oh, I can't read this very well. Let's see. Allegations. Remedy. Mom brought Maya to the hospital. Mom. Something. Oh God, blogs? I think it looks like it says vaginal blogs. That can't be right. What's a vaginal blog? Allie, you have a clearer one you can send to me? All right, well, send it to my email. Do you have my email? Here, I'll put it up. Listen, anything that you guys have that you want me to point out, send it to my email. Okay, I will put it up on the screen. And if you have timestamps you want me to look at, if you have evidence you want me to look at, if you have clearer pictures of some of this stuff you want me to look at, send it to my email, and that will make this go faster, probably. Change quality of the video on settings to advanced. Okay. Oh, how do I do that? Oh, quality. Oh, I've never done this. I can only go as far as 780, whatever that means. It still looks like it says vaginal. Now it looks like it says vaginal blaze. That's not a word. Mom stated she wanted Maya to get, pain medicine. Mom has taken Maya to several doctors to different something in different countries. Maya, countries? Wait a minute. Different states and countries. Well, that's a lie, because she only did it in one country. Well, two countries, America and Mexico. So you don't say states and countries, states and Mexico. So that's a lie. Maya woke up and said she is feeling good and hungry. Mom heard Maya and was angry. Maya said she wanted a donut. Oh, here's the donut again. Mom is believed to have mental issues. Oh, by who? Who told her? Who told Dr. Sally Smith that mom has mental issues? That's interesting. There are concerns for Maya's safety and well-being. Mom is giving Maya's IV medication at home. It was stated that Maya is not in pain. Mom insists that Maya is in pain. Mom is case manager at CVS. Dad is retired. Maya is a 10-year-old girl who has been admitted to Johns Hopkins All Children's Hospital Pediatric ICU. Her mother reports that she's been diagnosed with reflex sympathetic dystrophy, RSD, also known as complex regional pain syndrome. She reports that the child has the generalized severe form of that disease. She reports that Maya has such severe disease that she has required unconventional treatments as a last-ditch effort to treat her condition, which she portrays as terminal. Oh, they always get you on that. If they can ever get you to say that you feared your child would die, they tell people that you said they were terminal. And has no hope for cure. Well, there is no hope. There is no cure for CRPS. These treatments have included repeated intravenous infusions of the dissociative anesthetic ketamine. She has taken her to treatment centers where she has been given high-dose infusions over multiple days and has taken her to Monterrey, Mexico, where a physician gave her high-dose ketamine, put her into a coma for a week. The treatment was sought in Mexico because it is not approved for use in adults, let alone children, in the United States. Well, not approved by the FDA, but it certainly is used off-label. Maya's mother portrays that Maya has advanced severe disease resulting in dystonia and deformity of her lower extremities and inability to stand or walk, which she reports started abruptly during the first week of July 2015. There are specific diagnostic criteria used to diagnose CRPS, and Maya does not meet those diagnostic criteria. And then that's just the first page. It's a very long report.
No, Your Honor.
No,
No, not coming in.
but to be clear, we listed it because we wanted to make sure our understanding was that Chapter 39 immunity also applied to this report by Dr. Sally Smith.
If this report went to the dependency court and was not part of the medical records, then unless there's some explanation, it's Chapter 39 immunity.
All right, so then the next
Well,
one.
if I may, to be clear, I think that's kind of shot across the bow, a suggestion that we're not going to be able to cross-examine her, or that's not evidence, but we'll be able to explore this with her if they call her in their case.
Well, I understood exactly that was the reason, but the reality is right now we're talking about whether that document is admissible. Whether you can use it to refresh a recollection or some other purpose, that's a different conversation.
Thank you.
3045.
No, Kathleen, I think you're right. I think she did make it worse, but why should a mother advocating for her child in a serious, she obviously has something wrong with her. Why is it that the professionals weren't able to use their bedside manner to help her come to an understanding and not fight against her so hard? I think they could have without doing what they did. And I think the only way they thought they could control her was by taking away her child, which just made it worse. And I just don't see that it's the anxious mother's fault. I think it's the professionals who are supposed to be trained to handle anxious people and help them through a good bedside manner to come to some kind of conclusion. And let's say that the hospital was right. Let's say they were completely right that it's a conversion disorder and that it's not CRPS, and mom is insistent that it is, but she's got these other physicians, some of whom have really good qualifications. It's not on the hospital to decide that you must take their pathway instead. And that's another thing we learned from one of the people on the stand today, was that there are many different pathways to treat pain disorders. And some places go with a really holistic approach, and other places go with a anesthetic approach, and other places go with like a psychological approach. And it's not any of their business or ability to force on you the approach you want to take, that you should take, which I think is what they were doing to her. And I don't think that's right. I don't think it's right at all.
3045.
3045.
Also, here, just rank your say, I think it's 45 to 53 pages.
This is her report that was used in the dependency?
Yes, sir.
This is the report that is not part of the electronic medical records, but was put in the hospital paper chart, if you will, but not in electronic medical records, so that everybody could access it. This is the one that I believe Dr. Criticized heavily the hospital for having this in the hospital chart.
Yeah,
All right, I heard this part. They lose this argument, and this report does not come in. And I like what the judge has to say about it, though. If I can get to the judge's comments.
Yeah.
They want to put Sally's whole report. Dr. They want to put in it, but I wanted to see these screenshots of the report because I wanted to see what lies she was telling. Here's another one. Here's like another page. He wants to know if there's diagnosis. The judge wants to know, is there a diagnosis in this report or is it simply an investigation? Because if it's an investigation, then that's the immunity chapter 39 issue. And so he ends up throwing it out because it's not a diagnostic. Okay, she's calling it dangerous treatments, hospital and doctor shopping, refusal to pursue less invasive, more conventional interventions. Again, that's your right as a patient to pursue any kind of interventions you want. I mean, if they're legal, which it's legal because Dr. Kirkpatrick is doing it. Believe me, if it wasn't legal, they'd be all over him. Maya's mother specifically sought physicians who routinely make diagnosis of CRPS in patients who do not fit the Budapest criteria through internet research and discuss. How does she know that? Did she call Dr. Kirkpatrick? Did Sally call him and find out how he diagnoses his patients? Why is she saying he diagnoses them through people who do Google searches? This is terrible. She never spoke to him. She spoke to him one time and refused to take. Didn't take his records that he offered her. So how would she know about that? How would she know anything about what he does? She has steadfastly refused to consider alternative diagnosis provided to her repeatedly that Maya has a childhood conversion reaction. There is also extensive evidence of actual physical trauma to Maya by her mother. Who has personally stuck needles into her child numerous times to draw blood and administer IV solutions and medications, most of all of which were actually unnecessary. She was routinely giving Maya IV ketamine, see that's a lie, through the Metaport over a 6-month time period, despite reporting the IV solution dispensed was only being given by mouth. Where does she come up with this? The plaintiff has denied this repeatedly, and the judge pointed out that the defense has never shown any evidence of this. They have yet to show the judge any evidence. This is why he wouldn't let it in. Not just this report, but other things that mentioned the ketamine IV at home. The judge has said, where is your evidence for this? And he goes, well, until you have somebody testify about it, it's not coming in. And they still have yet to bring someone to the stand to say that this is true. You like that thumbnail, Emily? Here, I'll let you see it close up while I keep reading. Wait. This is my project for today. No cake or Jesus for sick kids at All Children's Hospital. They threw Jesus in a dumpster, and I'm not going to forget it, and I'm not going to let you forget it either. I'm going to keep reading from this while we look at that. Maya's parents have repeatedly signed permission for physicians to administer life-threatening, dangerous medications with serious side effects to their child, despite minimal benefit. If you're just tuning in, I'm reading from Dr. Sally Smith's report that she made, and so far we've found several lies. There is often a pursuit of attention from medical providers attributed to the perpetrator of medical child abuse, and there has been tremendous attention to Maya and her mother from that perspective. However, it also appears that there is a dogged pursuit of attention on the internet for Maya's condition and her fundraising needs. CRPS in children is widely recognized to be different from CRPS in adults in that it is less common and a high percentage, over 90%, have resolution of all manifestations within 1 year. Oh, that has nothing to do at all with Maya. You don't know what her personal situation is or how her body responds. That's ridiculous. She could be part of the 10% that doesn't get resolved and that gets worse. Considering the very favorable prognosis recommendations from treatment of CRPS have emphasized conservative management with a combination of physical therapy and biobehaviors, and psychological treatments. Medications have been studied alternatively in adults, and multiple case studies are published regarding blah, 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 medication in children, blah, blah, blah. This is boring. Local anesthetics, blah, blah, blah. So she's basically saying other things that other places do. Evidence is inconclusive or mixed in most studies of these medications. So the standard evidence-based approach of treatment for CRPS remains a multidisciplinary rehabilitation approach, which of course they tried. They tried this in 2015 and with Bonnie Rice, and it failed for her. There is no published report of efficacy of the repeated high-dose ketamine infusions, blah, blah, blah. She probably got this on YouTube and Google, by the way. She admitted to getting some of her information on YouTube. Maya has shown no significant or, what does this say? Sustained improvement in response to those treatments. Indeed, she has suffered repeated serious side effects after her high-dose ketamine infusions, including severe abdominal pain, nausea and vomiting, hallucinations, and fairly psychometric effects, serious memory loss, and a loss of time-based cognitive skills, weight loss, linear growth failure, hepatic injury, abnormal lipid metabolic. Do you guys remember any of this being part of ketamine withdrawals? Listen to all the stuff she's listing. And anemia as a result of her mother's chosen treatments. Well, of course, they're not her mother's chosen treatments. They were chosen by the specialist that she was seeing. So that's another falsification here. Despite her poor response and serious side effects of Maya's parents have continued to pursue and insist on high-dose IV ketamine treatment and other dangerous test treatments, such as intrathecal clonidine infusions that are experimental at best. Okay, moving on. So what do you mean Sally has been struck off? I don't think so. Aren't they calling her? Did something happen today? Because I haven't watched the whole trial. I don't know yet. I haven't watched the whole day. So let's keep going.
There's
Oh, is this from the report too? Okay, so this is what they were probably looking for. Where's the diagnosis? Medical child abuse, Munchausen syndrome by proxy, is characterized by a parent or other caregiver fabricates an illness. 2, the child is presented persistently for medical assessment, often resulting in multiple procedures. God, that's terrifying for people with chronically ill kids, right? The perpetrator denies the cause of the child's illness, and acute symptoms and signs of the illness stop when the child and perpetrator are separated. The caregiver often has training in the medical field and appears very involved in the child's medical care, and in this case is demanding, aggressive, intimidating, and threatening with medical providers. Deception of medical providers is an integral part of the process, resulting in incorrect diagnosis, unnecessary and often invasive testing and treatment, and futile pursuits of underlying abnormalities and effective treatments. There is extensive evidence that this case meets criteria for the diagnosis of medical child abuse, including lying to medical providers. All right.
Mr. Hunter addressed. He's more familiar with the document.
What's on the next page?
All right, let's see. I think we read this part. Yep. I just want to say too, if you ever find yourself in a situation where you have a child in the hospital and you're disagreeing with the doctors, I highly suggest, unless it's a life or death issue and you're sure they're going to kill your child, I suggest swallowing your pride and agreeing with them totally, and telling them that they're right and they're so brilliant and smart, and then getting the hell out of there as soon as possible and never going back and just going somewhere else. because it ain't worth this. Skipping ahead. We already read
There's
this.
no diagnosis. It's speculation with no foundation, no predicate, based on rank hearsay. If you look at the previous page, she never reached a diagnosis. She made an assertion that there's extensive evidence to support, but she never actually reaches a diagnosis. Then she goes on to complex regional pain syndrome. She has no expertise in, admittedly. The hospitals noted that. DCF's noted that. And she attempts to refute the diagnosis of CRPS. This was not in the hospital medical record, not produced to us. And although there's this assertion that it was part of the paper chart, there were other paper reports, such as that of Dr. Lewis, that were scanned into the hospital medical record. This was never done. This was never produced to us in that fashion. It was specifically used in the Chapter 39 proceeding, and there is no diagnosis.
The DCF statement that she does not have background training experience or somewhere.
I'm a little confused. Help me out, defense.
I love this part.
For years, you've been wanting me to not talk about the dependency action, and now you're asking for the chief prosecutor's report to be put into evidence in dependency action. So I'm unclear as to whether you're now asking this court to open up the dependency action.
No, sir, we're not. If I may be heard.
I will allow it.
This goes to a fundamental problem of contradiction in this case. We are being sued for vicarious liability for the conduct of Sally Smith on a parent agency basis. We are defending that allegation on two grounds. One is that she's not our parent agent and never has been. And we have no vicarious liability for her. But in the alternative, that what she did was appropriate and within the standards.
But you would agree with me that this report has nothing to do with her treatment or lack of treatment of Maya Kowalski.
I would agree with you, Your Honor, that it doesn't have to do with the treatment of Maya Kowalski. However, that's our position. That's not the position of the plaintiffs. What we have heard from the plaintiff's expert, Dr. Neuberger, as well as others, is a criticism of this report, of Dr. Smith's conduct, of her investigation, and of her alleged involvement as a result of what she found in this in Maya Kowalski's treatment. It's all wrapped up together. Now, this report was prepared, make no mistake about it, I want to be very clear about this. As far as we are concerned, this report was prepared in the force and scope of Dr. Sally Smith's role as the medical director of the child protection team for Pinellas County. We believe that this report was prepared as a result and part and parcel of the child abuse investigation, and that she, as well as we, are entitled to Chapter 39 immunity with respect to it. But if the plaintiffs are going to criticize her care, or her consultation, or her involvement, and attempt to hold us vicariously liable, therefore, based in part on this, we are entitled to introduce it. It was in the custody of all children, in the scanned paper documents portion of our records, not the legal medical record, just like Dr. Lewis's report.
Can I ask a dumb question? What's the hearsay exception that would allow this in?
This is a business record that was created by Sally Smith in the course and scope of her ordinary business practice.
For
the Chapter 39 investigation.
Judge,
this document is hearsay. This document was prepared.
It's all hearsay
for the dependency action, which the defense has been seeking to.
Welcome to real court, DCF people. Welcome to a real courtroom. This is a courtroom you've never been in before. You've only been in a family courtroom where hearsay on hearsay on hearsay is all the evidence you need to put any parent on the list to have their parental rights taken away. Welcome to a real court of law where hearsay is not evidence. It's not. but this is why these people, this is how they write reports. We just read that report with all the freaking lies and omissions and exaggerations and embellishments. It can't come in this court because this court is a real court. But in family court, this is what was used to take away their child. Yeah, I'll roll it back. I'll roll it back a little bit so you can hear the judge.
Continue to have prepared document is hearsay. This document was prepared for the dependency action, which the defense has been seeking to continue to have excluded. This document, in addition to being hearsay with no hearsay exception to which it would apply, also, even if it did, has a substantial 403 problem. This is not diagnosis or treatment of Maya Kowalski. So there is nothing that this report can do to salvage itself from a hearsay problem, not alone the Chapter 39 immunity, which also exists, and I've been hopefully very consistent on. At the end of the day, what the jury is going to be instructed has to do with medical malpractice. And there is evidence that Sally Smith went well beyond her role, taking off the hat of child abuse investigator and went into the role of treating physician. And that is the conduct to which all children's hospitals, or Johns Hopkins All Children's Hospital, depending on the apparent agency issue, may or may not be responsible for.
Hunter doesn't like this at all. He's about to make a record for the appeal that he doesn't appreciate the judge's characterization of what Sally Smith did. But you know the judge is right.
Not the role of her as the child abuse investigator. So this document is not coming in. 3045 is not coming in.
Judge, let me just note two things if I could for the record. One is that we take issue with the court's comments regarding her participation in care and treatment. The other is that
we take issue with her participation in the care and treatment too, Hunter. Attorney Hunter. We take big issue with Sally Smith's involvement also.
Be placed as a result of your ruling in a position of both defending conduct and having this document, as well as other activities on her part, used as both a shield and sword by plaintiff. And we will have to revisit this when Dr. Smith appears to testify. And the foundation, we may again attempt to lay the foundation. I'm just telling Your Honor, this contradiction goes to the heart of the problem we've had with the entire case as far as.
The problem with this entire case is immunity for bad actors. If you want to blame the state, Attorney Hunter, if you want to say that this is the state's fault, that the state drove this mother to suicide, that the state is at fault for falsely imprisoning Maya, well, then you should be the one fighting against the immunity order. Now, shouldn't you? You should be the one calling your Florida representatives and telling them to strip immunity from all of these court actors, from all of these DCF people, so that they can be held accountable. But since they can't be held accountable, who else do we have to hold accountable besides the hospital that let them operate there like they had total authority? You wanted this to happen. You wanted this immunity protection, and now you want to have it the other way around? You want to introduce documents from the dependency hearing, which you kept out of this case from the very beginning? Nah, brah. That ain't going to happen. You know what is going to happen? You know what's going to happen instead? Wait, I made this today. I made this morning, laying in bed. Before my day started. This is what I was doing. I have to show it to you because it's so funny. Wait. Oh, wait for it. I hope I don't get a copyright for this.
I understand. You're moving for a mistrial when you got additional time and you can call the same witnesses to address whatever issues. Is that what you're saying?
Yes, Your Honor. Because
can we go to exhibits, please?
Denied. What do you think about Judge Carroll as gangsta life? Thug life. This is what I was doing when lying in bed this morning when the alarm went off. I was like, you know what I need? I need a thug life meme for Judge Carroll. Denied. Finger guns blazing. Denied. Let's get to a couple super chats here. Chaos Coordinator, thank you for the super chat. Says, thank you for all you do, Megan. Cheers from Poland in the UK. Well, I'm so glad that you're here. And if the chats are not showing up on the screen, that's StreamYard acting up again. And Sarah Dawn, thank you so much for the $5 super chat. Says, thank you so much. Or pounds? I think that's pounds. Thank you so much, Megan. Truly love your coverage and the fact that you speak the truth. Well, I try to speak the truth. At least, the truth that I know, that I have seen with my own eyes. You like my meme line? If you like that meme and you want to tweet it out, it's on my Twitter page at Megan Fox Writer. Megan Fox Writer. Megan no H. MEGANFOX Writer. Yeah, I'll put the link to the tweet. Here you go. Oh my God. Do you think Judge Carroll would laugh? I think he would. Especially since we found out that he's a huge nerd after what was it that he was talking about? Lost in Space? I love that. Finger guns. Denied. And denied. I think that's going to happen here. It already did.
Yeah, very nice. Thank you.
What's next?
3046. Yes, court removal in 20 18th of my calls.
Our objection here is that this insinuates to the jury that this was a medical decision made by the Kowalski family in the absence of the material context, which is that the hospital argued strongly in the defense proceeding that she should not be allowed to receive ketamine anymore. And so to put this document in and suggest that the Kowalskis realized that ketamine was no longer helpful and they were under, in their minds, a court order prohibiting them from using ketamine would be prejudicial. So we object on 403, we object on Chapter 39 involvement, we object on relevance to this document.
Judge, this is 2018. This is long after the defense court has been dismissed. They went in and removed the report to the medical record.
I'm going to allow it, and there was also testimony and questions as to whether the port was removed at Johns Hopkins All Children's Hospital in 2016. So this would perhaps answer that issue. So 2046 pages. Is it
Why is my full screen all of a sudden not
And
working?
we would like some instruction on whether we need to approach before we cross-examine. When they bring this up, whoever they bring this up through, we cross-examine on the reasons underlying the sport removal. We need to approach, or can we explore those issues?
Well, I don't know what you mean by explore those issues.
All right, you guys, StreamYard's acting up on me again. So I'm going to refresh. So just hold on for a few seconds. I'll be back in about 30 seconds. While I'm gone, hit that like button and make sure you subscribe if you're not already subscribed. We hit 20,000 yesterday or whenever it was, and I'm headed towards 30. So we need some more subscribers around here. I'll be right back. All right, now it's working again. I decided to make my light setup match my t-shirt today. What do you think? Do you like the yellow lights today? I decided I didn't like how it looked with the other light setup. I was like, I'm clashing with this. I need different, the lights now have to match my outfit. All right, share screen. Here we go. Yeah, Shapiro was hilarious yesterday when they had that lost in space conversation, and the judge said, "What are you watching on Netflix?" And Shapiro goes, "Take Care of Maya." That was a mic drop moment. That was a good joke. It was a good joke. I'm sure he's really stressed out. Like, I don't dislike Shapiro. I just don't like their defense. I don't like the defense they've gone with here. Although what other choice did they have? But I don't dislike him. And I don't dislike any of the attorneys on their side, but I think it's perfectly fair game to gently rib them for their silly defense.
Haven't we previously talked about that the Kowalski?
You sure it was Whitney? I thought it was Shapiro who said that, which was really funny. That actually makes more sense that it was Whitney, but I thought it was Shapiro. That's funny. That's funny.
Kowalski family's understanding was allowed to come in as to whether ketamine treatment was allowed to come in the future or allowed to occur in the future.
I'm sorry, I didn't recall it. Thank you.
Wonderland.
Am I misremembering that? Because I thought we had a discussion before the trial started as to
This is a hilarious comment, by the way.
the meaning of the legal effect of the continued vitality of the dependency court order after the shelter proceeding had been dismissed. And I think I wasn't going to go there, but I think we did have a discussion that the Kowalski family's understanding was, that goes to their state of mind.
Yes, I think we tried to tread a very thin line with Mr. Kowalski on the stand. We didn't specifically mention the position taken by Johns Hopkins to prohibit ketamine. The testimony was rather that they had this general fear and concern that if they went back to ketamine, the process might repeat. That was kind of the nature of the testimony. We didn't go perhaps as far as we were allowed to go, which is the reason that this was done. The reason that they weren't doing this because this court order entered based on Johns Hopkins' argument, and we would like to be able to go there.
But am I misremembering that conversation?
No, Judge, you're not. But here's the essential thing that the plaintiffs keep trying to do. They just said twice that the ketamine infusion wasn't allowed because of Johns Hopkins, when we all know it was because of a court order. And they just again said the ketamine wasn't allowed because Johns Hopkins' recommendations to the court. They keep trying to deviate from this court's rulings with respect to that.
Well, obviously there's no jury in front of us right this second. The issue that Mr. Whitney wanted to do is, does he need to come forward? I don't know what issues you're going to attempt to address with respect to this document.
Judge, it's a medical procedure she underwent in 2018. It's relevant. She didn't have a relapse afterwards. It's relevant it's being a medical record for Maya Kowalski.
I think I already said I'm letting it.
Okay, sorry.
But I was going to Mr. Whitney's. He wants to approach. I don't understand what we would be approaching on.
So we'll wait till the time.
But in this case, better safe than sorry. So if you think it's going to be close, please come forward. push.
Never approach so much in my lecture. We're trying to abide by that.
Like a jack in the box here.
Yes. Right, moving on. Good. 3051. This is the report by Jack Kowalski regarding the fact that his wife the gun is missing.
Huh?
This is the report by Jack
Is that
Kowalski.
the judge? Huh?
It was the day before the suicide or the day of the suicide. I believe this is relevant to their irresistible impulse argument, Judge.
Didn't Mr. Kowalski already testify to this? We normally don't put in police reports. So, I think there's already testimony on this issue, and it's a hearsay document, so that's not.
Did Jack?
Right, Judge. The next one, I'm not understanding their objection.
Did Jack
already-
report the gun missing? Wait. Jack, did he report it? Was this from Jack? Wife lost small black Ruger handgun on beach. Handgun is loaded. Wife was sitting on bench at beach, returning to area with flashlight, and wife left the beach. So she lost it. It didn't go missing. They reported that she lost a gun. What? Jack Kowalski stated that his wife believes that she was at a Venice beach and lost a small black Ruger. Stated she was unsure if it was left at the beach, in her car, or at home. That's different. That's different than that's different than it went missing. He knew where. What? This doesn't come in.
So, I say document, so let's not put it in.
All right, Judge. The next one, I'm not understanding their objection. It's 3054. They say objection, page 609. Maybe that's a typo.
Which one are we on again?
Can you put a 3054, please?
I don't think there's a page 609.
Yeah, that's a mistake, obviously.
Yeah. So I got the wrong page.
Well, there's a Bates number down at the bottom.
Oh, maybe that's it. Thank you, Judge.
All right. Curly was way ahead of all.
Yeah. Just too clever, of course. So 609. Can you go to base 609?
Page 10, I think.
On this document on the right, you see Bates number. Can you go to 609, please? It's probably.
All right, what's
Is it the
this?
toll page that you're objecting to?
What is this? Health notes. Yeah, this is nothing.
It looks to be, and I'm just reviewing it now for the first time, but there's a.
We're skipping past this because this is nothing. I remember this. It's nothing. We got to get moving or we'll never get through.
This first, it begins with Council Wolf called and
Oh,
recorded.
this is the with the pictures. Wait.
This first, it begins with Council Wolf called and recorded. So.
Oh, we still have to get past this.
Positions of.
This made me laugh out loud, though. Here comes the Munchie Bunch. The plaintiff's Munchie Bunch.
I don't really see how. And from. I don't think we can say that. I'm not artists.
Hold on. Here it is.
Detective Graham, how are you going to.
Look at it's the plaintiff's version of the Munchie Bunch. Check it out. The plaintiffs want to give this to the jury. Great minds think alike, folks. I mean, look at what this was my idea. I've been working on this for days. I could have just sent them mine. I mean, I personally think that the jury would appreciate my rendition of it more. Don't you? All I need to do is label them with their names, but they could take care of that for me. I think Whitney could throw their names on there. I like my screenshots better. I love this.
Detective Graham talk to each and every one of these
No,
people?
I'm just I want to make sure the jury understands Detective Graham does not work for All Children. She's not one of the employees.
No.
I can't.
I mean.
I think it's important. Well, I plan on bringing an illustration like this to be able to show as witnesses come in front of the jury who works for who, because there's mass confusion.
You're asking me to use this with Detective Graham to show to the jury.
Well, the same way.
And that answer is no. Detective Graham, you just said didn't talk to all these people, so why are we showing pictures of all these people to Detective Graham?
Well, I was going to show it to the jury just as if I had more, but I'll just currently not that. I guess I can bring it that way.
I guess I'm fundamentally misunderstanding. You want to show all of these pictures to the jury during your conversation with Detective Graham when Detective Graham didn't talk to these people.
Right, just so I
So
know. Okay.
why?
Because I wanted to make sure the jury understood that Detective Graham is not one of the people on the All Children's team.
So you're going to ask if she was a member of the Sarasota County Sheriff's Office and you think you need a picture to say that she's not part of Johns Hopkins?
I'll put this into a bigger trial illustration. We'll use it a different time.
I mean,
there's rampant confusion with this jury about who works for who and at what time people work for people. And what I was trying to build as people come to testify to make sure the jury understands these are the All Children's people, these are the Safe Children's Coalition people, these are the DCF people. So we have a running tally.
Perhaps that's part of your closing argument, perhaps, but I don't see why you start putting up pictures of other people that Detective Graham didn't talk to.
I understand.
Oh, it was the defenses? I thought it was plaintiffs.
I'm going to briefly excuse myself because I think Detective Graham is here for Mr. Anderson's request.
What was the objection? I'm sorry, I was talking to my kid. What was the objection? So it was the defense. The defense made it? Darn it. You mean I'm thinking like the Dick defense? Maybe I should reconsider my life choices. What did they make it for? And what was the objection? What did I miss? Shapiro made it. Maybe they're watching my coverage. That would be funny. Oh, God. Well, if they are watching my coverage, Attorney Shapiro, you can't help how off-putting you are. And I feel truly bad for you because this defense is, well, you're doing the best you can. And I'm sure you're doing it for your clients, but it sucks. Dragging a dead woman through the mud is just not a good look. Jessica says he totally stole the idea to do pics from you. Yes, JSF, that's the pic that you sent me on Locals. Thank you for doing that. The one of the cop. But what was the point of him doing that, and what was the objection? I don't know why that's objectionable. Oh, I see. The defense wants to make it so the jury could see it, but they added colors to help subliminally show that SS isn't part of J Hatch, which is BS. Yeah, they're totally connected. We should volunteer to make the exhibits for them. I have one. Wait, I've got an exhibit for the jury in case they wanted to know what happened to Jesus. This is what happened to Jesus. Can we give this to the jury? Now, that was a joke. I am not attempting any jury tampering. No one try to contact any of the jurors. That would be wrong. The jurors are not paying attention to the media, and we have no desire for them to do so. It's just a joke. I think the jury's behaving themselves just fine.
Display video, why can talk about what's permissible and not permissible to talk about.
Okay, apparently a couple of jurors just got here because of the crash that was on the interstate. So I want to give them a few minutes. So see if they'll be ready to go in about 5 to 10 minutes, or do they need more time?
He's driving the last one.
Okay, so they're not physically in the building yet. So it's still going to be another 10 minutes or so.
You're on before Mr. Shapiro excuses himself. I think we need to address the motion that we filed yesterday. I think Mr. Anderson's going to take it.
Okay, but understand if you don't file something after like 5 o'clock, the clerk won't docket it until probably lunchtime today. So
I have a copy for you, Your Honor.
Thank you.
All right.
Yes, Your Honor.
There was one filed on October 8th. However, the recordings and the actual clips that they seek to introduce have nothing to do with the criminal investigation. They have to do with pursuing on behalf of Sally Smith and the CPT team some information that they will need. So the clips that they want to show are, did you consider leaving your wife? Things like that. They're not going to anything that 934.04 to 0.09 requires, and the purpose of such interception is to obtain evidence of a criminal act.
Well, let me stop you.
Yes, sir.
My recollection was we were going to deal with each specific statement differently, but generally speaking, there was a criminal investigation into Beata Kowalski and potentially Jack Kowalski at that particular time. And therefore, and I've already ruled on it, and I'm not changing my mind on it, is Florida law would allow the detective to record unilaterally that investigation.
And if it was indeed a criminal investigation, and that is the basis, then there was a requirement that the witness state that she had a reasonable suspicion, which I asked in deposition. She said she had not formed any, or she had probable cause, which I asked in the deposition, and she said she did not have any. And so if it was a criminal investigation, she had
she should have had those
under these
things.
circumstances to Mirandize or otherwise allow representational counsel, which she also admitted in her deposition that she knew the Kowalskis had. So in terms of violation of fundamental rights here, we've got the 4th, 5th, and 6th that, by your own admission, have been violated. And you got
I hate to inform you, though, that the judge is going to let all of this shit in.
The problem here of her recording this and taking quote evidence testimony without even complying with 934.03. Our point is, it's a trick. It's
All right, so we don't need to listen to the arguments because most of it comes in. Although there are some. Do we want to look? I'm just going to tell you this because we have to get to the testimony, or I'm not going to make it very far tonight because I really only have like 2, maybe 3 hours. So let's skip ahead to the testimony. A lot of the detectives' questioning of Jack comes in. Some of it stays out. If you want to know what stays out, you can go back and watch that part because they're going to play some audio and stuff. And now we're going to look at yeah, he keeps some of it out. Some of it. And if you want to see all that, just go back and watch it on your own later. But this is a doctor at I don't remember.
I'll have you state your name and your professional address for the record, please.
Zachary Pittsenberger, 225 East Chicago Avenue, Chicago, Illinois.
And where are you presently employed?
At Ridicule Children's Hospital in Chicago.
And my understanding is you are a pediatric emergency room physician. Is that correct?
That's correct.
Can you please start off by giving me the benefit of your education and training?
Okay, we don't need to hear that. He's very qualified, but he's an emergency room pediatrician. So we're gonna fast forward to where he starts talking about his experience with Maya and her family. All right, here we go.
2016, 15, sorry, 2015.
Okay. And that was a July 21, 2015 visit at Lurie Children's Hospital in Chicago?
That's correct.
Where were the services that you rendered in July 21 of 2015?
The emergency department at Lurie Children's Hospital.
Okay. I also saw on your CV here that you have a publication, Pittsenberger ZE, entitled Trends in Pediatric Visits to the Emergency Department for Psychiatric Illness in the Academy of Emergency Medicine for 2014. Can you tell me a little bit about that publication, please?
That was a research project I completed during fellowship in which we looked using a national database, just looked to see what trends were happening with visits to the emergency department for psychiatric illness in children.
As part of your training as a pediatric emergency room physician, is part of your training consist of psychiatry?
We don't do any specific rotations in psychiatry, but we see many patients with psychiatric conditions who come in for those concerns and treat them.
I have to tell you that the men in this case, the male doctors in this case, are so much more likable than the female doctors in this case. They're just more objective, and they don't inject their like emotions or feelings into it. And I didn't have any problem with this witness or the other doctor, the other male doctor that they talked to. I mean, he just gives you the facts. And notice that none of these doctors, I don't know how this is good for the defense. None of these doctors thought Munchausen was a possibility. They thought conversion disorder in the child might have been a possibility. But that's not about mom. It's about the child. And it's also, and we'll learn more about it. I can't like expound on it right now. But I feel like the right way to have treated this family, it's sped up, you guys. I'm speeding it up. Obviously, he's a fast talker anyway. He's like Ben Shapiro on but he sounds like Ben Shapiro on speed right now. It's the reason why you think he's nervous is because he's on 1.5 speed or 1.25. We probably don't need to hear this entire thing. I mean, he talks about, yes, he has experience with psychiatric illnesses in children. And he doesn't remember her being there. He remembers that she all he has is the notes, and that he saw her. She came in an ambulance, and I'm trying to think of what was interesting about this. So let me look at the transcript here because there was something interesting about it. He doesn't have any memory of Beata Kowalski being a problem or aggressive. There was never any. He doesn't have any of that in his notes. He suggested that she get, psychological counseling too. He thought it might be conversion. He did not think CRPS, but he doesn't have any experience with CRPS. She had what at the time steroid-induced myopathy is what they thought, which is why the weakness in the legs. So obviously, I mean, they're trying to get to the bottom of what's wrong with her. And so steroid-induced myopathy was the first diagnosis, inflammation. And he's trying to get to the bottom of it. Seems like a good doctor. Seriously, seems like a good doctor. No problem. I don't know how this helps them. I really don't know how this helps them because there wasn't anything here except for that they're trying all these different things. Tylenol, acetaminophen, she'd had some morphine for pain given to her by doctors. Mom requested a discharge and a transfer to a different hospital because they're not getting to the bottom of it, I guess. But he had no notes about Beata being a problem. Respiratory complaints, we know she had asthma. I'm trying to get to the important part. Past medical history. He didn't have a ton of that, he said. Pain and weakness, we know this. So he's just trying to get to the bottom of what it was. He was doing a workup on her, an assessment of her. And nothing huge happened. Yeah, he believed, and it turns out, Jesse, that conversion disorder does not necessarily mean you have a psychological problem. It could be a neuropathic problem where the brain is sending pain signals for no reason. And so in order to get to the bottom of that, they have to treat the brain and they have to do psychotherapy and all this other stuff. It's interesting. We'll find out more about it when the other doctor comes in, but we don't really learn anything. If you feel like watching his testimony, you can. They go into okay, so I do want you to hear Anderson's cross of him because I thought it was really good. He's very honest, forthright. He doesn't appear to be hiding anything, and his cross brings out some good things.
Being the Gloria hospital records, I did not see a notation anywhere that the mom was acting in any unusual or concerning manner. Do you?
I do not see that, no.
And given a background in spotting child abuse, if a parent was acting in an abnormal or unusual manner in relation to the care and treatment of their child, that would be something that would be incorporated into the record, would it not?
It depends a lot on the presentation. Sometimes we would include it, sometimes we would not want to include it, as that could be inflammatory to the patient down the road if it was not found in fact to be true.
Define conversion disorder for the jury.
Conversion disorder is a presentation of a physical complaint or pathologic sort of disease state process that's not necessarily founded in the underlying pathophysiology and more based on patient's psychiatric or psychological condition.
And so it is a diagnosis of, in this instance, it would be a diagnosis, if it were true, of the child, not of the mother, correct?
Correct.
Do you understand?
Yeah, conversion disorder has nothing to do with the parents, you guys. It is not Munchausen. It is not factitious disorder. It has to do with the child. And if that were true, that she has conversion disorder or a form of a conversion disorder, Johns Hopkins still treated her completely wrong. If Bonnie Rice is correct, the defense's own witness, that you never confront a patient with conversion disorder with their disorder because it makes it worse. She said they dig in their heels and they will do anything to prove you wrong. So if that's true, then Johns Hopkins doesn't even know how to treat conversion disorder. They treated her in exactly the opposite way that you should treat someone with conversion disorder. Furthermore, conversion disorder is not evidence of child abuse, as this man, who is an expert in child abuse and has a child abuse background, had concerns about conversion disorder, but never linked it to any child abuse because it's not synonymous. Isn't that interesting? And then the next doctor has even more information on conversion disorder. He said that what we knew in 2015 about conversion disorder should be all thrown in the trash. It's not even relevant anymore, considering what we know about it now. Yeah, a physical manifestation of pain without a clear physiological explanation. Well, that could be a lot of things, because there's a lot of things doctors don't know. And there's a lot of conditions that people have that are yet to be diagnosed, that are yet to be able to be treated. And just you can put a label of conversion disorder on anything that you just don't know yet. And I don't know enough about conversion disorder, but it sounds to me like it's a really complicated thing. So if she had it, they would still be going to a million doctors to try and figure it out. And so they were actually taking away Beata's and the entire family's ability to go to more specialists by labeling Beata with Munchausen and doctor shopping. They took away the family's ability to seek help for whatever this disorder is that she has, whether it's CRPS or conversion disorder. It's so wrong how they treated them. There's obviously something wrong with her.
Understand what happened in this case generally?
I am not aware of anything outside of the ER visit with the patient.
Okay. You have nothing in your, strike it. Although it's called by a different name right now, are you aware of a condition formerly known as Munchausen by proxy and now known as factitious disorder by proxy, or a term similar?
I'm aware of that condition, yes.
I didn't see anywhere in these records where you made any such diagnosis. Is that true?
I did not make that diagnosis, no.
Nor did you recommend over for a psychological or psychiatric evaluation Maya with any indication that that was a concern, correct?
That was not indicative of that, no.
And did you have the opportunity to review any of the records, prior records of Maya? That is, from prior hospitalizations, prior treatments, things of that nature.
I did not know.
Have you treated children with complex regional pain syndrome, previously known, some people still do, as reflex sympathetic dystrophy?
I have, yes.
I'm not asking you for a definitive diagnosis, but insofar as her
quote.
extreme reactions to imminent belief of pain or touching, in your experience, could this be an indicator of complex regional pain syndrome?
Complex regional pain syndrome is not a diagnosis I typically make, so I would defer to the specialists in that area.
What is a hyperesthesia?
Hyperesthesia would be an increased sensitivity to different sort of stimulation in the area of the body that's referring to.
Well, how can you say a neck is supple if you haven't had a chance to touch it?
So she's actively ranging her neck through the full range of motion. That would be indicative of a neck that is supple.
Isn't it true, doctor, that there were certain areas, such as the top of the feet, where if you touched her, she would scream in pain? In other areas, if you brushed up against them, lightly touched them, she did not.
Again, I don't recall anything beyond what's documented in the note, but the definitely had intense pain with the touching of the light touch to the dorsum of the foot.
Statement here,
I felt
patient
this way,
kicking
Joe.
this
It's
provider
funny.
with both legs and pushing herself up and into her mother's arms with her arms. You would agree that this
He's like, not my monkeys, not my circus.
is somewhat unusual behavior, is it not?
That would be atypical behavior for that age patient, yes.
Right. But it's not atypical behavior at all for a child with complex regional pain syndrome, is it?
I would defer to specialists regarding that.
You note that on several instances that she could be distractible from her pain. Is that not also an indication of CRPS?
Again, I would defer to the specialist regarding the specifics about the diagnosis.
Did you use any of the following examination tools in examining Maya? A pen to test skin sensitivity?
I don't see any documentation of that, no.
All right. Temperature tape.
Sorry, what was that?
Temperature tape or an infrared thermometer.
We did take a temperature. I'm not sure of the measurement device they used for that, though.
Okay. Was the temperature simple, normal bodily temperature, or was there any attempt to check temperature in different portions of Maya's body? Extremities, abdomen, things like that.
We would typically only check it in one portion of the body.
Okay. Was there a von Frey test or Frey test?
I don't believe so.
Was there a weighted pin test?
Again, I'm not familiar with what that test is.
An algometer. Was that used?
I'm not familiar with that testing device either.
goniometer. Was that used?
Again, I'm not familiar with that testing device.
Skin. Have you ever seen photographs of what CRPS lesions look like?
I can't say that I have, no.
Okay. And do you know whether they appear in parts of the body that are sometimes difficult to see with a basic examination? Under the armpit, the back of the forearms, things like that.
I'm aware that sometimes those kind of lesions are difficult to detect on physical examination.
And so I take it that you continued with the diagnosis of myopathy and myositis and possible neuropathy pain that she entered with?
We had no evidence against those diagnoses, so we presume they were accurate in our evaluation of the patient.
Everything went to hell when we quit testing for witches, says FFS. Who knew that pin testing used to be used for testing witches? That's a new one that I haven't heard. Maybe we should use it on the Munchie Bunch.
And did it come to your attention that this was these diagnoses came from Johns Hopkins All Children's Hospital in Florida?
That was our assumption, yes.
All right, Anderson, speed it up. I want to get to the part that I liked, and this was not it.
Do we need to pause?
Yes.
So long. I think there's just a pause before.
Oh, this is the part where he's
yeah,
so good at sitting still that they think that it's frozen.
You yourself are not an anesthesiologist, as I understand your training?
I'm not an anesthesiologist, no.
And I gather you have not been involved in the actual treatment of patients with CRPS?
I have not, no.
Finally, were any other tests such as MRIs, nerve conduction studies, EEGs, EKGs, anything like that done towards a diagnosis with Maya?
Not during the time in the emergency department, no.
I think you testified in response to Mr. Anderson's questioning that you do have some experience with complex regional pain syndrome. Did I hear that correctly?
I've treated a handful of patients that have come in with that diagnosis, yes.
Have there been occasions in the past, doctor, where you've placed CRPS on the differential diagnosis for a pediatric patient?
Yes.
And was complex regional pain syndrome on your differential diagnosis for Maya Kowalski?
It was not.
Why not?
The diffuseness of her pain.
Your Honor, we would like to bring in a scale and a duck for the defense's witnesses. This jury, probably. Oh my God, I'm seeing the meme. I'm seeing the meme. Will someone please make a meme with all of the defense's witnesses on one side of the scale and a duck on the other? Please, someone. Please, Monty Python this for me. We need that meme. We need it.
Involving almost her entire body.
Not this guy. He's fine. He's fine.
Body would be typical for complex regional pain syndrome.
Can you name for me the 5 different symptoms?
Okay, and he can't name the symptoms because he's. I'm going to defer to the specialist. Let's go forward. He can't do the 5 sample signs. He can't do any of that. And he's fine. He's like, I'm not an expert. I said I'm not an expert. So I don't know. I will defer to the experts. Yep. I would defer to them. Yep. I'm trying to think if there was something else. I felt like there was something else. Oh, maybe this is it.
Numerous diagnoses on every patient. We don't always document all the things we consider in their evaluation.
Oh, no. Okay. I might have been thinking of the next one. Okay, so let's move ahead. And now you're going to get angry because this is the detective. Oh, look at that face that I just ended up on. That was a gift from above. That's a gift from above. I'm taking a screenshot. That might have to go on the Munchie Bunch. Although the one that I was sent was very good as well. But come on, look at that screenshot. My pause game is unbelievable. That's really good.
Would you introduce yourself to the jury, please?
Hi.
I'm a detective that violated his 5th and 4th and 6th Amendment rights, I think. How many more? What else did Anderson quote there? 5th, 6th, 4th, 14th, probably. I mean, are there any civil rights that you haven't violated, ma'am? Are you? Are there any civil rights that you haven't violated?
Hi, I'm Stephanie
Did you have anything to do with putting Jesus in the dumpster?
Graham.
Okay. Ms. Graham, will you give this jury the benefit of your background and well, let me just set the table first. We're going to talk to you about some involvement in this case, in the Kowalski case, in October, November of 2016. Okay.
Yes.
Can you tell the jury what was your occupation at that time?
I was a detective with the Sarasota County Sheriff's Office.
Okay.
Who violates the rights of people in front of me constantly by recording them and not telling them and not offering them a lawyer and not reading them their Miranda rights. Oh, what else? Threatening them with jail time when they haven't committed any crimes. That's me. That's what I do.
Now we're going to work backwards. Okay. Can you tell the jury, starting with college, where did you go to school?
I graduated from University of South Florida with a Bachelor in Arts in Criminology. From there, I went to the Sarasota Criminal Justice Academy, where I graduated first in my class in 1998 and subsequently was hired by the Sarasota County Sheriff's Office.
Okay. Did you go to the Sarasota County Sheriff's Office right out of, I think you said it was a detective school or officer school? Criminal Justice.
Criminal Justice Academy. Within about a couple weeks, my hiring process, I believe, had started prior to my graduation from the academy. And then I was hired April 30th of 1998 because I just retired this past May.
So we're bringing you
Thank
back.
God.
We're going to put you through a little.
The people of South Florida are safe from the constitutional violations that this woman was just handing out all over town willy-nilly, just all over the place with her fuckery and her civil rights violations, just handing them out to everybody she came across, apparently.
Memory contest. But so once you finished the academy, and
My 25 years,
I don't care about
a
the
court
background.
deputy, so victims unit detective.
you became assigned to what the.
If you guys
unit, I
want to hear
believe,
about
in
her background,
child victims that might be child abuse, neglect, also vulnerable adults.
Okay.
Were you in that role in October and November of 2016?
I was.
Okay. Now I understand that you recently retired.
I did in May of this year.
Okay. Congratulations.
Thank you.
So let me ask you a little bit about your involvement in the Kowalski case. Okay.
Now she
how
for sure
does
works for an HOA,
maybe I
Irish
can just
Rover.
sort of streamline this? When a call is made to the
Yes,
abuse and
please
neglect
streamline
hotline,
it, Shapiro.
is there a track that involves law enforcement?
Yes, generally there.
Yep.
Oh, objection. Objection. We have a Chapter 39 problem. Oh, Jack looks so dapper today, by the way. Look at this. Look at this suit he's wearing. I mean, this man knows how to dress. Why? What is that tie holder? It's not a tie clip. It's like a tie chain. Jack looks like a boss today. No, I'm not ignoring super chats. I just didn't get. Let's do it while they're on the sidebar here. All right, let's see. Kilada Smith, thanks for the super chat, says defense is so grimy that they try to pull out anything. Unhung Hero, thanks for the super chat, says it would only be fitting if the star witness was Munch from the Anderson trial. The Anderson trial. Oh, was that the snitch? Was that the jailhouse snitch? You're gonna have to remind me. I didn't watch that entire trial.
Mr. Shapiro asked a question. Okay. Let me
Did
just try to
I
streamline
didn't miss
this so
any
we
other
can get to
super
the reason
chats,
we
did I?
called you. Once the call is made, the law. If I understand what your testimony would be, the law enforcement angle of this would get assigned from your sergeant to you. Is that right?
Yes, generally my sergeant would assign the cases that came in through DCF to investigators within our unit.
Okay. And then the reason why you decided you wanted to meet with Jack Kowalski would be in pursuant of that investigation. Is that right?
Yes.
Okay. There was a date, and I'll reference to you that it was November 17th, 2016, that you had the opportunity to meet with Jack Kowalski. Is that right?
I don't remember the date specifically, but if that was noted, yes.
Okay. Why did you want to meet with Mr. Kowalski?
Well, at that point, I had been in contact with the Department of Children and Families about the progress of their case, and I was told that.
Okay, I'll lead. Okay. Were you, well, let me just lead you through there. You met with Jack Kowalski at All Children's Hospital.
I did.
Okay. And you met with him in order to get his understanding of the situation that you were investigating. Is that true?
Yes.
Okay. And just to be clear, when you met with him, you're not affiliated with All Children's. You're meeting with him totally separate as a member of the Sarasota County Sheriff's
Totally
Department.
separate.
Correct. Okay.
It's not totally separate when you got the
where
call
did
from
you-
Sally Smith.
At All Children's Hospital, we were given a private room. I believe it was like a family waiting room where we had an opportunity to speak privately.
How are you attired when you met him?
Fairly the way I would be today, slacks, a blouse. I would be wearing a badge and my gun.
Okay. And how would you introduce yourself to Mr. Kowalski?
I would introduce myself then as Detective Graham with Sarasota County Sheriff's Office.
Would you have given him your card?
Of course, if as a general rule, either before or after, I would supply someone my card.
All right, the chat wants to know, I don't understand why the cops ever got involved. I'll tell you, this is pure intimidation of the parents. Sally Smith called the police to start a criminal investigation on Beata to get rid of her. They didn't want her in the ICU anymore. They didn't want her in the hospital. They wanted to get rid of her. She was too demanding, too aggressive with them. She was not taking their advice. And so they treated her like a criminal. This is pure intimidation. They wanted her gone. And we have not found any grounds yet for child abuse. And I would like to address that there are people out there who are saying that those of us who are on, think that Maya deserves justice here are not giving any consideration to children who are truly abused by their mothers through medical abuse. I say false, ridiculous. I have dedicated my life to bringing about awareness to child abuse. And I've seen mothers and fathers commit this abuse. But the court system is really bad at discovering who's doing it. And they consistently give the children to the abuser and they alienate the protective parent. That's something that I've been covering. You can read my Missouri coverage on it. It's horrific. It's horrific. So please don't ever come here and accuse me of not caring about abused children. My entire career, I have been covering stories of abused children and what the system does to them. Foster care abuses children. And yes, I'm sure there are children out there who have been abused by their mothers in this very specific and rare way. I just don't believe that it's something called Munchausen syndrome by proxy. I think it's just your average child abuse by a sicko who needs to be imprisoned and jailed. But don't call it a psychological disorder if you're not going to offer any psychological help for it, because this is what they do. They call the cops. This is their way. If they really wanted to help Beata because they thought she had a psychological disorder, wouldn't they have called the police to put her on the 72-hour hold? I think this woman is suicidal. She needs psychological help. No, they called the police to have her to threaten arrest and jail. So no, this is nuts. It can't be a psychological disorder if there's no treatment for it other than jail. What other type of psychological disorders do we cure with jail? None. It doesn't make any sense. And if Maya was suffering from a psychological disorder, the cure, according to Johns Hopkins, was to give her more psychological pain by separating her from her parents? Yeah, absolutely not. No.
Okay. Did you tell Mr. Kowalski that his interview with you was completely voluntary?
I did.
Okay. And did he agree to sit down and talk with you?
Yes.
Do you remember approximately how long the conversation was?
How voluntary do you think you would feel if a cop with a gun on her waist walked in and said she wanted to have a conversation with you, especially when the hospital is already threatening to have you thrown out of the hospital and removed from your daughter? How voluntary do you think he felt?
I don't. I know that it was long. I don't have it was over an hour, well over an hour.
Did you tell him at least twice that he was free to leave the conversation at any time?
I know that later in the conversation, I did tell him and reminded him that I'd already told him this was voluntary. The door was unlocked. He was free to leave if he wanted.
Okay. Did you record the conversation?
I did record the conversations.
Okay. And why do you record conversations?
Recording a conversation during an investigation is the most accurate way to determine what was said during an interview.
You had a chance to listen to the audio.
parts of it.
Right. Are you able to tell the jury whether your recorder was by phone, on the table? What's your best recollection of this?
My best recollection that it was likely my iPhone is what we would use, our work issued phone.
And is that a phone that you would have put on the table, most likely? Do you know?
Probably. Pardon.
Let me ask you about some of the conversation that you had with Mr. Kowalski. When you met with Mr. Kowalski, did he talk to you about any meetings that he had at the hospital regarding his consent for treatment there?
Yes, he did describe a conversation that had taken place where he had expressed his consent for the child to be treated.
Your Honor, I'd like to publish to the jury what's been previously marked into identification as Defense Exhibit 3121A.
Yes.
I mean, when we were in the meeting with the doctors one day, and the other one saying, Maya, I'll sign her out. And I said, hold on, time out. And if this wasn't in the, wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you're talking about? And they explained, I said, that's doable. And was my wife happy with what I said? No, absolutely not. But, so you have to, there's times I'm going to go the other way.
Okay. And thanks for sharing that. I
don't know why they didn't write that down.
Was this a theme of your conversation with Mr. Kowalski where he was expressing to you that he was supportive of having Maya treated at Al Schultz?
Yes, that did come up.
We're beyond reading. On that question, let's sustain the.
Do you recall during your...
Okay, Marta, I missed it then. You wanted me to pay attention to what she said she was wearing? Oh, what she was wearing. I thought you were talking about Maya. Yeah, she said she was wearing plain clothes. That's important that she's wearing. She said slacks, normal attire, similar to what she's wearing today. Marta says what she described what she was wearing is important when it comes to the jury question. So we should remember that, what she was wearing. Okay. She did say she was wearing plain clothes, like slacks, normal attire, similar to what she's wearing today, with a gun on her hip. All right, moving on.
Conversations with Mr. Kowalski, whether he made other statements to you regarding his either consent or lack of consent at keeping Maya at Al Schultz.
That's my recollection, but I might need to. That's my recollection, but I would probably need to refer to the transcript to know specifically what those statements were when they occurred in the conversation.
Okay. Your Honor, I'd like to publish into evidence, publish to the jury what's been previously marked as 3121B.
What I hate about this so much is that every time I hear him on this recording, all I can think is, oh my God, Jack, did no one tell you about Shut the Fuck Up Friday? When a police officer wants to talk to you, shut the fuck up. I don't answer any questions. Although, if you're in that situation, though, and he's feeling desperate, but the very first thing he should have done is say, I'm happy to talk to you as soon as my attorney gets here. In this case, you can't be as aggressive as you can with with the Shut the Fuck Up Friday guys. But you can say, I cannot speak to you without my attorney present. I need my attorney. And just say, are you willing to wait here while I get my attorney on the phone so she can get over here, or at least be on the phone while we talk? Because you have a right to an attorney, and you have a right. I could understand why he wanted to talk to them, because he feels they've done nothing wrong. But you never, ever, ever, ever talk to police, because what she does to him in this is just absolutely heinous.
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, all it would have taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
Talk to another doctor? They talk to so many doctors. This one wants him to go talk to more doctors? I thought they were doctor shopping. You can't win with these people. If they went and talked to other doctors, they'd still be accused of doctor shopping. And why is she yelling at him? Sorry, I'll back that up so we can hear his response.
Something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
Detective Graham, having heard that audio, does that refresh your recollection as to the conversation that you were having with Mr. Kowalski?
Yes, it does.
Was there a time during the conversation that you had with Mr. Kowalski where he indicated to you any concerns with Mrs. Kowalski's behavior?
Yes.
Okay, and what types of concerns was he expressing to you?
She wasn't being cooperative with the things that were being requested. He stated he was appalled by some of her behavior.
Your Honor, I'd like to publish to the jury what's in evidence as 3121C.
Hey, you know what? My husband is sometimes appalled at my behavior too. I am sure that there are moments when my husband is pretty appalled at my behavior, like at the car dealership, for one. Although he kind of laughed at that, but he was like, I told you not to go over, I told you not to make a big deal. Husbands and wives have arguments about the things that the other one does. And I don't think that there's anything incriminating about Jack saying that he thought some of her behavior was not good. You can tell that Jack and Beata are very different people. Jack is not confrontational. He wants to calm the situation down. And Beata's like, no, fuck you. I know what's wrong. I know what's going on. And maybe she did overdo it. Maybe she did. She's anxious. She's super upset. Her kid is screaming in pain. And, you know, people are different. People are different. And I think using his words against him, trying to use like a very average argument between husband and wife about, I thought her behavior was out of line. Do you know how many times my husband has probably thought that or said that about me? He doesn't generally say it to my face, but he will if he thinks that I'm out of line. If he's there and a witness, he will be like, stop, stop, stop now. Let me handle it. But I mean, this is very usual between married people. It's not evidence that Beata did anything.
It's just your wife's behavior is very concerning to me.
Sure, and it's getting worse right now. Just, she don't want to cooperate.
Yeah, it's getting worse. He's saying her behavior is getting worse now because everybody is setting this up to be a war. And my wife is not he should have said, my wife is not the kind of woman that you want to pick a fight with. No, like some women are like that. You're looking at one. You ain't never met a bitch like me when I get mad. Never. Like, I guarantee it. I could give Beata a run for her money.
Along those lines, Detective Graham, did Mr. Kowalski discuss with you during this time that any concerns he had with Mrs. Kowalski following the rules?
He'd expressed there had been some interference on her part with him trying to communicate with Maya. Yes.
Okay. Your Honor, I would like to publish to the jury what's been received into evidence as 3121D.
Yes.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was falling off.
She could.
And then she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you doing it?
Why can't she control her? If her daughter is her main priority and why can't she follow the rules and do what she's being told?
Why can't she do what she's being told? I'm sorry, is this a free country or not? Are we free people or are we slaves? I didn't know that doctors had the right to tell me what to do. Nobody told me they had the power or color of law over my life. Nobody told me that. I had no idea that doctors had the right to tell me what to do. Follow the rules, follow the orders. Who's ordering me around? Some doctor? Just because your name is doctor? Doctor, 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 doctor. If you know, you know. What who says that doctors at a hospital lay down laws and rules that I have to follow? The hell is that about? I object to this drivel. Un-American, liberty-stealing wretch.
During your conversation with Mr. Kowalski, do you remember any conversations with him about him noticing any differences in Maya's behavior, whether he was present or Mom was present?
Yes, he expressed that there were times he would be home alone and there would be no complaints of pain or discomfort. And when the mother would come home, the child would immediately be in pain.
Your Honor, I'd like to publish to the jury what's been received into evidence One moment. As 3121I.
Okay.
When nobody else was in the room but Maya and the staff, she acted completely normal. When mom would walk in the room, she's instantly.
I heard that many times.
There's no other explanation for that.
Yeah, I noticed it too with myself being home, and then mom comes home from work.
And all of a sudden she's back.
So these changes.
So you're at home, your guys are doing well, and playing.
No complaints about me.
No complaints
But
about
then when
that.
mom gets home,
She's
maybe-
okay.
Okay, that is strange. If that's true, that's a little strange. Jack saying, I see it happen with me too when I'm home and everything's fine, no complaints, then mom gets home and then she's complaining. Or it's what I said. Kids feel like they want to be babied by mom when they're sick. And I told you, my kids don't act the same way in front of my husband when they're sick as they do to me. They want more, especially my son, the little one. He always turns it on for me. He exaggerates his pain for me. And I know he's doing it. Maybe Beata didn't know she was doing it. Who knows? Or maybe, who knows? Kids are kids. That's still not evidence of abuse. And I feel it's terrible that they're gaslighting him into like making some kind of admission of guilt, that, trying to trick him into thinking his wife is a child abuser. And also, I do think there's an element of Jack telling her what she wants to hear so he can get out of there. Hostage negotiation, absolutely. So that he can get out of there as being the one who gets custody of Maya instead of a foster care family.
During your conversation with Mr. Kowalski, did he express to you any of his intentions in terms of his home living situation with his wife if Maya were to come home?
Yes, he had offered to me that given the opportunity to bring Maya home, that he would have Beata move out.
That's the only answer.
What's been received into evidence.
That's the only answer you give these people. I would have given the same answer. If they said, if we give your daughter back to you, will you make your husband move out? I'd be like, yep, tomorrow, today. I'll go kick him out now. You want him out now? Yep, absolutely. And I would expect he would do the same thing if it was me. Yep, whatever I have to do, give her back. Whatever I have to do, I do it. Damn straight. I don't know what they think this proves, other than the state being a tyrannical, jackbooted
I thought you were gonna answer the
monster.
question, if Maya was released from here and she was going to be brought back home, I would have had my wife move out.
That's my next question.
That would be absolutely on our feet.
One moment.
Wheezy Bob says it puts the lotion on its back or it gets the hose again. That's exactly what the government is like in this situation. Terrible.
Thank you. I don't have any other questions this time around.
Yeah, he answered exactly correctly. He can't give any other answer, Emily says. He's putting his child above his wife, as he should, as all parents should.
There is a there is a technique that and were you a detective at this time?
I said I was, yes.
And how long
What do you need,
after
honey?
that were you a detective before you moved to another
No, are
position?
you cold?
I became
Oh, are
a
you
member
doing
of the
fever?
civil unit, I believe, in November of 2017.
So what, about a month after this?
Oh, you have a
No,
fever. Did you
November of
take any
2017.
Tylenol or
A
ibuprofen?
year after this?
Yes.
You were
Take
no longer a detective.
ibuprofen and Tylenol
No, I had chosen to
together.
leave that unit.
Take 2 Tylenol,
There-
the
but
500
at this
mil.
point, you were a detective. Now, there's a technique that
and
detectives use when they're
bottle-
trying to get a confession or something
my
out
bathroom.
of
And ibuprofen.
someone, and that's
Take
called
4 of those.
flipping the accomplice.
No.
Is that not true?
2 Tylenol.
I
and
would assume
4
so, yes.
ibuprofen.
I've not
Really?
heard that term referred to
What do you refer to it as?
as doing an interview.
Well, it's a little more than an interview, is it not?
I'm not sure I understand your question.
Is it not for the purpose of getting one person that you perceive as part of the crime to testify against the other?
That can be, yes.
Right. And to do that, what you do usually is use threats of prosecution of the person you want to talk, right?
That could be possible, yes.
All right. So now, for instance, like here, like threatening Jack to let him know that you had put a father away for 10 years before, right?
I told him that, but I think that was out of context.
Sorry, guys. I thought I
Wasn't
was muted. I didn't mean to have that unmuted while I was giving directions on what the doctor told her. That's what the doctor said, not me. I just want to make it clear that that's what the doctor told us to give her. She's an adult, almost 18. She can have that. She's really sick. She just woke up with a fever now. So she was sleeping, so I couldn't give her the ibuprofen and stuff before. So I thought I was muted. I'm sorry, guys. Do I need to go back? Did you miss that?
In that, the way you're referring to it as.
Just how far out of context can it be to tell someone in Jack Kowalski's position, with you there in that room with a badge and a gun, that you would put somebody else away for 10 years impliedly for this?
My recollection of explaining that circumstance to him was that the parents thought they were doing the correct thing at the time they committed the crime and loved their child and had the outcome was not necessarily what they intended, but that there was a punishment for that. That is my recollection of the reasoning why I brought that case up.
You were reminding him that even though he loved his child, he was doing the right thing, he might in fact end up spending 10 years behind bars. That was the purpose.
I was explaining to him that even a loving parent thinking they're doing the right thing, not knowing what the end result could be punished for their actions. Yes.
What? There's no crime there. You just described something with no crime. No, what? You put loving parents in jail? What? Yeah, and I mean, I know this is true. They did it to Cindy Absug. They put her in jail. She's a loving parent. She never did anything. She followed doctor's instructions. She deferred to the specialists every time. In fact, she was the one who wanted to wean him off the medication they finally started taking him off of. And then CPS comes in, takes him away, and says that he's healed now because he's away from her, when it turns out they just continued the weaning that she wanted off the medication that was giving him side effects. But does that come in to evidence? No.
I noticed that you used a couple times the phrase, the opportunity to, as in the opportunity to meet. Do you recall that? Your testimony right here in front of the jury just a couple minutes ago.
If you're saying that's what I said, I don't remember using those exact words, but
Right,
if you're saying, that's fine.
They're taking notes. And also the opportunity to speak privately, right?
Yes.
Okay. But that's not exactly the way it went down, is it?
Is that a question?
Okay. That wasn't the way it went down, was it?
I asked if we could speak privately. We
You
were
know
given a private
damn
room.
well that was a
to sit
question.
down.
You know damn well that was a question. You're an interrogator, ma'am. You're a police woman. You know that's a question. I bet that Anderson is having a lot of fun interrogating her. Now the shoe's on the other foot. How do you like it? Let's put a big spotlight in her face.
Down and speak.
You were given a private room because the hospital knew you were coming, obviously, right?
Oh, we're sidebarring now. Yeah, and she is thoroughly unlikable. I'm glad that she's retired because she should not have a badge. There are a lot of cops who should not have a badge, and people who violate civil rights they're definitely on my list of people who should not have badges. Oh, this is going to be a long one, huh? How long are we going to sidebar? Oh, not much longer.
Thank you. So you had discussed coming over there before with Sally Smith, had you not?
I missed that, but I saw it the first time when he says, "Don't worry, they're taking notes about the jury." Oh yeah, you can believe when she says, "I don't think I said that." Don't worry, they're taking notes. Let's go, jury. This jury really is great.
I don't recall talking to Sally. I don't recall talking to Sally Smith specifically about coming to the hospital.
Was she or was she not the main source of your information about this?
I'm okay if you want to go there.
That question you can ask, but
Dr. Sally Smith was the main source for the medical information I was receiving. The custody and DCF side and family court side was through the Department of Children and Families and supervised visitation.
Right. So now, relying heavily on Sally Smith's information, you went to the hospital, and who did you meet there?
just to clarify, the information I received from DCF and Sally Smith was why I went to the hospital. I probably had contacted someone with the hospital to facilitate getting us a room where we could speak privately.
Okay. And then Kathy Beatty met you at some point from the time you came into the lobby to the time you got on the elevator to go up to the PICU, correct?
That's my recollection, is that she's the one who facilitated getting the room.
All right. So you and Miss Beatty rode up in the elevator, right?
I would assume so, yeah.
Yeah. And were you in uniform at that time? No, you were plain clothes.
Plain clothes.
But you did have your badge displayed.
I did.
And you had a gun.
Likely,
displayed.
yes.
Well, what kind of gun? Glock? What was it?
A 6-hour.
A 6-hour. Okay. And so when the doors opened, were Jack and Maya standing there?
I
as
don't
you came
specifically
off?
recall that.
And in fact, the first time then, whether they were standing right there or close there too, the first time that they saw you would be with Miss Beatty, correct?
That's possible.
All right. And you got some information about this situation from Miss Beatty too. Is that true?
I had been in contact with Ms. Beatty as again, facilitating some information about.
And you've worked with Ms. Smith, Sally Smith, Dr. Smith, excuse me, previous.
All right, more sidebars. I missed that. Again, I was helping my daughter. Did she say anything interesting? Is Anderson in trouble? Did he get in trouble? Dang it, you guys, StreamYard is slowing down again. Is it because we have a lot of people in the chat? Hold on, I'm going to refresh. I know. I'll be right back. All right. What did he do? What did Anderson do that got him in trouble there? What was the objection? I missed it. I was talking to my kid. Poor thing feels really bad. She thinks she has strep throat. We got the test, but the rapid one came back negative. She has a really bad sore throat. No COVID though, which is good. And now I think she has a fever. Sucks. All right, what was the objection? What was the objection, you guys? What did I miss? Look at that screenshot. Look at that face. She's cooling her heels. How do you like it? How do you like being under the spotlight, detective? She doesn't like it so much. She does kind of look like the GameStop "It's Ma'am" person. I hate to be mean. No, I don't. This is a cop who violates people's rights. I mean to be mean to her.
With Miss Beatty. When we left off, you were getting off the elevator with Miss Beatty, were you not?
That sounds reasonable, yes.
Yeah. And then the hospital or someone provided a room for you. Is that right?
Yes.
And you sat down on one side of a table, a relatively small table, was it not?
I don't recall, but there was a table, yes.
Like it wasn't a gigantic conference room table. This was...
No. My recollection is like a small family waiting room.
Okay, small family waiting.
Or not small, but
And were you positioned such that Jack went in first and then you sat down between Mr. Kowalski and the door?
Uh-oh.
I don't recall where I sat specifically.
Okay.
Mm-hmm.
Then you had a badge and a gun sitting with Mr. Kowalski in a visitor room, right?
Yes.
And you told him you were going to ask him some questions, did you not?
I asked if we could talk, yes.
Mm-hmm. And one thing you did not say at the start was, oh, and I'm going to be recording you.
No, I did not.
And in fact, your phone that you recorded it on was on your purse, kind of half in and half out of your purse sitting next to you?
Generally, if I've done hundreds of recorded interviews. It is either on the table, and sometimes, yes, it might be in my bag. That specific day, based on the recording's clarity, I had reason to believe that it was on the table.
Okay. And so Jack Kowalski, for the most of this conversation, did not know you were recording him.
He didn't.
The
And-
recording states that there was some conversation prior to the recording starting.
Mhm.
I don't recall telling him, but there is no right to privacy when you're talking to the police. I can record conversations.
That's
as part
right.
of
That's
any
why
criminal
it's Shut the Fuck
investigation.
Up Friday.
Well, you knew he was represented by counsel, did you not?
I was not aware he was represented in any criminal matter.
Well, you knew he was being represented in the matter involving his daughter there at Johns Hopkins, did you not?
He talked about being represented. We actually discussed his attorney. He never specified that he wanted to speak to his attorney, but that was the attorney representing him in family court.
Did you ever then tell him he had the right to counsel at that point?
I'm not required to.
See, because you don't believe you had him in custody yet?
I know I did not have him in custody.
And at that point, you hadn't even found a reasonable suspicion. Is that right?
I had a DCF report. I had a medical staff with child protection team voicing concerns about the health and well-being of this child, with the concerns focused on the mother and her inappropriate behavior. And yes, I did have a reasonable suspicion to go and speak to him to find out what his opinion or basis was in this matter. That's what an investigation entails.
Wait a minute. Hold on. Reasonable suspicion. Let's see if that's accurate, shall we? Florida. Reasonable suspicion of a crime. Let's get the definition of that. All right. Reasonable suspicion is what is required by law enforcement officers in Florida to temporarily detain a person for purposes of determining whether a crime has been committed. It arises most often out of the context of traffic stops, yeah, we know that, or when police make contact after receiving a tip, anonymous or otherwise. So this would be her receiving a tip, I guess, about a potential crime. Reasonable suspicion must be determined by the totality of both facts and circumstances. People often confuse reasonable suspicion with probable cause. They are interrelated, but they aren't the same thing. As our Fort Lauderdale criminal defense lawyers can explain, reasonable suspicion, sometimes formally referred to as a reasonable, articulable suspicion, is the standard by which a person who is both reasonable and objective would suspect another of committing or intending to commit a crime. How could Jack be the maybe she would have reasonable suspicion to talk to Beata? Articulable, though? I don't know. Let me keep reading here. It must rely on known and specific information, although that's a vague definition. What does that even mean? Known and specific. Although the proof burden for reasonable suspicion is fairly low, it must go beyond a mere gut feeling or hunch. For a law enforcement officer to successfully assert reasonable suspicion, they must be able to articulate clear, common sense facts that led to their suspicion. Even then, reasonable suspicion alone isn't enough to initiate an involuntary search of one's car, home, or person. The authority granted to an officer with reasonable suspicion is intentionally limited in scope. It's not unless or until they develop probable cause that they are lawfully allowed to conduct, we know this, involuntary searches, seizures, or arrest, which I would argue the seizing of Maya was an illegal seizure because they didn't have probable cause. I don't think they had probable cause. And they have to have, DFS by law has to have probable cause to seize your child. It is a Fourth Amendment seizure issue. And if they don't have probable cause and a warrant, they did it illegally and it should be overturned. I don't know if they did get a court order in this case, so that's the same thing as a warrant. But I want to know what their articulable evidence was to make that. I wonder what their probable cause actually was in that case, but we won't know because we don't get those files. With probable cause, the assertion is there's a good reason. Okay, that we're looking for reasonable suspicion. All right, here we go. When does the question of reasonable suspicion arise? Well, they're talking about traffic stops. That is not related to this. We need Steve Gosney. Let's see. Once the stop is initiated, no. Okay, it is my understanding that reasonable suspicion cannot be made on hearsay. I just watched Bruce, the criminal lawyer. Isn't that his name? Bruce Rivers, the criminal lawyer. No, Cindy, they cannot just use rubber bracelets. Exactly, like they did in your case. Rubber bracelets are not reasonable suspicion. It's a long story, folks. You should read my coverage of Cindy's case. It is my understanding that reasonable suspicion must be what a police officer notices themselves, that the officer has to see it themselves. An officer cannot rely on on hearsay unless it's witness report. Like, so it can't be an anonymous tip because that's not articulable evidence. It can be an eyewitness. So I guess Sally Smith, I guess that's the gray area, because if Sally Smith is the eyewitness and willing to put her name on it, which obviously she was, then perhaps. But I don't know. Let's hear her answer to that again. Let's hear her answer to, did she have reasonable suspicion? Because I don't think she did.
Voicing concern.
And found a reasonable suspicion. Is that right?
I had a DCF report. I had a medical.
Okay, so that's the question. Is a DCF report reasonable? Is that reasonable suspicion if the DCF report is full of lies? I don't know.
Staff with child protection team voicing concerns about the health and well-being of this child.
I mean, legally, it probably is. With the medical staff jumping on board, I guess it probably is.
Concerns focused on the mother and her inappropriate behavior. And yes, I did have a reasonable suspicion to go and speak to him to find out what his opinion or basis was in this matter. That's what an investigation entails.
Well, would it be true that you at this point were not comfortable saying there's hang on one second. I need to find this.
All right, he's lost. That's not good.
To that.
Come on, Anderson.
Under these circumstances, with a detective, with a gun and a badge sitting across from him, that he wouldn't feel just a little bit intimidated?
Sustained.
And in asking your questions, you used what we term leading questions, did you not?
I did ask him some leading questions, but he was very forthcoming with offering his own information that I did not ask for.
And your voice that we heard here was fairly aggressive.
Wow, that was a lot of facial expressions right there. Did you see that? Let's see. Wait, I didn't catch him in these 5 second. Dang.
And in
the tongue in the cheek.
asking your questions, you used what we term leading questions, did you not?
Wait, I have to slow this down. I have to see all these faces. There's a lot of faces here.
I did ask him some leading questions, but he was very forthcoming with offering his own information that I
That's a face too. Yeah.
did not ask for.
I would like to see body language experts on this one too. She's got a very expressive face that I think is showing some things. I don't know what, but
Your voice that we
she definitely seems upset by it. This is she's got some contempt there, and she doesn't like being questioned.
heard here was fairly aggressive about challenging him. Is that right?
There was probably a point later in the conversation where I started to pressure him a little more as far as why this was occurring. I was questioning as far as why wasn't he asking more questions? Yes.
The point was, for virtually every single one of those recordings, you suggested or told him the answer to the question you wanted.
That is incorrect.
True?
I would disagree.
Did you not bring up in every one of those, isn't it true that, or why didn't you do this?
You would have to refer to the entire recording, but that is not my recollection.
And so then
All these women with the downturned lips. Let's take a look at the Munchie Bunch again. I'm taking a screenshot of those downturned lips. This appears to be there's something similar about all these ladies. And a lot of them, like Sally Smith, has the downturned mouth. So does the DCF investigator or whoever she, pink shirt lady. So does the DCF caseworker with the black L'Oreal box dye hair. This one, Bonnie Rice had it, but she smiles more, so you don't see it as much. But this officer has got that downturned mouth as well. They also like to eat their lips when they're talking. All their lips disappear. The lips get tighter and tighter as they talk. They all have a similar look to them, which I find weird. What is it? I wish I knew.
Having done this, did you really expect Jack Kowalski to disagree with you?
During the interview, I told him right at the beginning, if he was not comfortable answering a question, he didn't have to. I explained to him that if I spoke anything incorrect, that he should correct me, and he did, and I thanked him for that. It was not a conversation that I was, just giving him question after question. We were having a conversation. I thanked him for sharing information with me. I explained to him that, my position, and then he would explain back what his position was.
Mm-hmm. And you did this, of course, before you went on record and recorded, did you not?
FFS. Imagine how much suffering could be avoided if simply these chicks were popular in high school. It does have that feel to it. Like, did no one give you enough attention as a kid? Do you not feel loved or, important enough because you have to impose your power on others to feel good about yourself? And it's a DCF requirement. Would you consider box dyeing your hair black? Yes. Well, congratulations. You've got the job, ma'am. I wonder if it's a DCF requirement. Oh, Lord. I know Clink's in the Munchie Bunch. You didn't see? She's there. Look. I put her in there. She's in the second row over to the right. One of our viewers got that screenshot. I thought it was hilarious. So she's in there. Don't worry.
No.
That would not be true.
You did not put it in the first part of the recording, did you?
The first part of the recording was maybe a few minutes. I went to double check to make sure. I'm sure there's nothing worse than doing an entire recorded interview and finding out your recorder didn't work or wasn't activated. So that,
go ahead, sorry.
I'm sorry, but I refer later into the interview that I had told him he was there voluntarily. The door was unlocked. He was free to leave. That was expressed because I had told him that prior to the recording beginning.
So he just stayed there because he wanted to.
I've done hundreds of interviews of all different types of parties, and cooperation is not unusual.
And in this, by a husband against a wife, that's been your experience?
I worked child abuse investigations for 5.5 years, and parents are always involved in these investigations.
Well, this is a little different investigation, was it not? This wasn't one where Maya Kowalski had bruises on her, was it?
No, this was a very complicated
Right.
investigation.
And at that point, you had no evidence that Beata Kowalski had any psychological or psychiatric problems.
Mr. Anderson, why don't you welcome?
All right. I was texting my mommy. She's back from the doctor and resting. Poor thing. I miss her. I wish they didn't live so far away. So hard to get from New York to Arizona. So stinking expensive.
I need to approach him a little more.
What's that face? She appears to be mocking Anderson there for having to go back to the judge. How's my mom doing? Not good, guys. Not good. Pray for my mom. She's just having all kinds of problems that nobody can figure out. And it's scary when you lose control of stuff, having absence seizures is really weird. And she doesn't have the pleasure of not remembering them. She remembers, she's aware as it's happening, which is really weird. Because most people are not, they say. They've never seen anything like it. It's really strange.
As a general rule, we do not interview the child. That is for the child protection team to do.
And you never met Beata Kowalski?
I did not.
Really? Now that's interesting. If this was an investigation into criminal activity, why wouldn't you meet with the source of the crime, right? You never talked to Beata? Well, Beata probably wouldn't have consented. Beata would have been like, no way, man. It's Shut the Fuck Up Friday. Get me a lawyer. But why wouldn't, if this really was a criminal investigation, why wouldn't she have tried to interview Beata? This is so, Cynthia Absug wanted to be interviewed as well by the police, and they wouldn't interview. They never talked to her. Never. But they sure as shit brought charges. That should be illegal. Like, No, she said she never talked to Maya or Beata. Listen, she just says it.
Interview the child. That is for the child protection team to do.
And you never met Beata Kowalski?
I did not.
She never met Beata. She never interviewed the child. She just intimidated Jack into trying to gaslight him into believing that his wife is an abuser and talking him into leaving her and threatening him with prison if he didn't. That does not seem, no, Jingleberry, that does not seem like a complete investigation. Does that seem like a complete investigation to you? What the hell even was her purpose in talking to Jack? Yeah, that sure makes it sound like the goal here was not to find a crime, but to intimidate Jack and turn Jack against Beata. What the hell is this? What kind of investigation is this? This is really distasteful.
For the jury's benefit, can you tell them whether you told Mr. Kowalski whether he was free to leave at any time?
I did.
Did you actually remind Mr. Kowalski that you were out of your jurisdiction?
Several times, yes.
And what does that mean to the jury when you're out of your jurisdiction?
I only have arrest powers within the jurisdiction of Sarasota County, and
Oh, so you told him, though, that you had arrest powers. You made him believe that you could put him in handcuffs, but you couldn't?
He was a fireman. They also deal with jurisdiction, so I think he probably understood that meaning.
You were asking questions about whether you were leading him into answers. The jury heard one of the clips about Mr. Kowalski having his wife with that. Was that something that you asked, or did he volunteer that to you?
He volunteered that, amongst other information, yes.
At the end of the interview, do you recall if Mr. Kowalski actually gave you his cell phone number?
He did, and he also offered to let me come to his home if I wanted to talk to him further.
Mr. Anderson. And if you decided to arrest, first, do you think Jack Kowalski understood exactly where your ability to arrest or not arrest was?
Speculation.
I told him I was out of my jurisdiction, and I believe I told him he was not under arrest.
That is not exactly my question. My question is, he would not know, unless he was a police officer or in law enforcement, where you could arrest or where you could not arrest. True?
Actually, speculation.
Sustained on that one. She doesn't have to answer that.
And if Jack Kowalski was not there, something happened to him, and Beata Kowalski, something happened to her, the child would then go into what?
That's not
Sustained.
Nothing.
Further, Mr. Asker?
No, thank you, Your Honor.
Members of the jury, are there any questions?
All right, jury questions, my favorite. American Dreamer, they played portions of the recording, but a lot of it got kept out of court. It was really not good for her, I don't think. She sounds super intimidating and screamy and awful.
I do.
All right, here comes the jury with their questions. All right, I guess they're going to be there for a little while. Let's fast forward quickly. They're still there. Here we go. Oh, okay. Here comes the jury.
And questions from the jury for you. And just as a reminder, you will have all of what's actually in evidence with you, but you won't have what is not in evidence. Did you show Jack that you were carrying a gun?
It would be normal for me to be wearing my badge and my gun on a daily basis when I'm at work, yes.
The next part of that question, was he aware you had your gun with you?
It would have been holstered on my hip as part of my uniform that I wear every day during every investigation.
Do you remember if you gave Jack your business card before or after you met with him?
At the very beginning of the conversation, he requested my card and I offered it to him, and that was recorded.
When you say this conversation was voluntary, did you tell Jack there would be consequences if he did not speak to you?
No, I would not tell someone that he was.
Oh, bullshit. I don't believe you. Yeah, Spirit Matter, thanks for pointing this out. Law and Lumber notes the jury speaks of itself in the third person. They do, and I've said that. They are speaking as one almost. It's like, which is funny because I think they send these questions individually, but the individuals have decided to call themselves this jury. And I think they have been acting like a second plaintiff's attorney, like a second prosecutor. It's incredible. The way they phrase things, I've never heard of before. Are you telling this jury? Is it your testimony to this jury? And yeah, Rob's killing me with this jury because that's what he's calling them now. And I agree, we should call them this jury because this jury is so different than any other jury I've ever seen. I'm proud of them for paying such close attention.
Was under no obligation whatsoever to talk to me.
If you were out of your jurisdiction, why were you interviewing him?
Because we were contacted by the DCF office in Sarasota County, and a family lived within Sarasota County jurisdiction, and that's why I was instructed and got involved. It would not be unusual for me to go to All Children's Hospital if the child was transported there and something had occurred in Sarasota County.
Did Jack inform you of his service? I assume that means of his fire department service.
He told me he was retired. I don't recall exactly retired from what, but he made a comment that he was a medic.
Did he demonstrate from that service that he...
Joe Kelly, they had me at different voices and wigs. Totally. We may have some LawTube viewers on the jury. Not right now. I'm just saying previously, before this jury, I have no reason to believe that anybody on the jury is watching anything, because I believe that juries, I think especially this jury, because they are so paying attention to everything, I don't think that they're violating any rules. But it's possible that before this case that some of them were LawTube watchers because they seem very educated pretty educated in the legal process and the language, which is interesting, isn't it?
Possessed a knowledge of his rights. Did he demonstrate from that service that he possessed a knowledge of his rights as they pertain to your interview and his lack of requirement to participate?
There was no discussion about that.
I'm sorry.
I just want to say he appeared willing to converse with me.
Did he mention his legal counsel?
He mentioned hiring Deborah Salisbury, and that would have been part of the family court process, which is a separate process from my criminal investigation.
I'm sorry, Flabbergast, where did you hear this audio? I have not heard this. During a review of jury questions, Shapiro calls them a hostile jury. He says one juror is asking all the questions. Are there rules for a hostile jury? I wonder if he can get a retrial or something based on that, if he can prove that well, I don't know if they're hostile. They may be a little hostile to the defense, but isn't that the risk you run with a jury trial, that they're going to side with somebody? They're going to side with somebody. I mean, can you complain if it's not you?
In your experiences, do leaders of, quote, police parallel services, end quote, paramedics/firefighters usually have more or less knowledge of their civic rights than average citizens?
I would not have an answer to that.
Did Jack demonstrate any non-verbal behaviors that made you feel the discussion was not wanted?
No.
Were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
Can I expound on that answer?
I think you
No.
should answer the question that was actually asked.
Could you repeat the question?
Were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
I was conducting an investigation to get to the truth and matter of the fact.
Did you inform Jack the reason?
I think it's very strange that she wanted to expound on that and she had to think really long and hard about that question. If you were really trying to get to the truth, wouldn't you have just said, I was trying to get to the truth? Can we see that long pause again after the judge reads
You should
that?
answer the question that was actually asked.
Can I expound on?
Quote, to see, were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
Can I expound on that answer?
I think you should answer the question that was actually asked.
Could you repeat the question?
Were you there?
That's a time waster. I don't know why that's a hard question to answer. Were you there to get the truth or were you there to push your agenda?
Jack the reason for the Did you inform Jack the reason for the interview?
I don't recall the exact verbiage, but I would have expressed there were some concerns. We'd received reports from Department of Children and Family, and I was following up those reports.
You said it was probably your iPhone that you recorded your interrogation of Jack. Where was your phone during the interrogation?
Like I said, during my first the initial testimony, because of the clarity, it very well, I mean, it sounded clear. It was on the table. Obviously, I sounded louder in it. I've been sitting next to me. But I don't have, right at this moment, that was many, many years ago, I don't have a clear recollection. That's would not be unusual for that to happen.
Was Jack given the notice the meeting was being recorded or to refuse the recording of the interrogation?
Well, it wasn't an interrogation, it was an interview. And no, there's no right to privacy
Everybody
when you're talking
knows.
to the police, whether that's in the back.
Everybody knows that was an interrogation. You cannot fool this jury. When the cops put you in a room and they start asking you questions and berating you the way this woman berated Jack, that was obviously an interrogation, and this jury is not falling for this.
Patrol car in the hospital, at their house, it would be common for me to record an investigatory interview.
In a yes or no, does the recording of the interrogation have a recorded opening with names, date, location, and consent to record?
It did not.
If not, then is it your usual modus operandi to record interrogations without the knowledge of the interviewee?
Yep, she
It
just
would not
said
be
it
unusual
was.
to do that, no.
And members of the jury, those are the questions.
This
I'm
is a
gonna
good
be able
time to remind
ask.
you.
I cannot.
It's a good time to remind you that cops are allowed to lie to you. So this is why you never talk to police. Never, ever, ever talk to police. Nope.
Ask the other questions. Defense, is there any follow-up?
Detective Graham, why do you make a recording?
It is the most accurate account of what is being said.
By the way, she does have a right to do this. As a police officer, she does not have to inform you if she's recording. She can lie to you. She can lie about it. She can say she's not recording and then actually be recording, and that's admissible in court. She can lie. Cops can lie to you. Now, you cannot lie to cops. If you lie to the cops and they catch you, you end up in jail. Look at the people that's how the feds get people. They interview them for days on end and then catch them in a inconsistency, call it a lie, and throw them in a federal prison with no trial for 2 years. But they can lie to you.
For
Doesn't
both
compare.
myself and for the person I'm interviewing.
Thank you.
Any further follow-up?
All right. You have shamed me. And so it's time for some Nick Recated fat shaming. We have been here for 2 hours and 38 minutes and 42 seconds, and we have done no squats. That is unacceptable. I can feel the blood pooling in my legs. Come on, get up. 1 minute and 22 seconds. If you're new here, we have to get up and move. And Nick will walk you through it if you don't understand. But just listen to Nick. He'll tell you what to do.
You impose fatness on you. You did it by going, oh, I want the butter on the popcorn. Oh, I want the butter on the ice cream. Oh, I want the butter on the sandwich. Oh, I want the butter on the salad. Stop eating butter. Can you just get up, walk 1 mile? Do squat! Walk farther. And if you can't walk, crawl, roll, get dragged by a goddamn forklift. Whatever is wrong with you, just move. Ever. Get off the chair. Get off the couch. No one is coming to service you while you sink into that furniture, while you become one with the pleather your poor ass got on that Walmart couch. Can you try not floating into sadness? Stop eating, stop drinking, start walking, start doing anything that you haven't been doing, you fat piece of shit.
Oh, okay. All right. All right. All right. The movement part of the program is now over for now. Every time I play that, everyone is like, leave the butter alone. Butter's good for you. You just have to understand Nick's sense of humor. Eat the butter if you want, but move, okay? But I don't recommend butter on salad or on ice cream.
I found a passage. I got up.
Wonderland, this is so true. Wonderland says, this is why Megan gets demonetized. Shaming a month, shaming fat. It's true. It's true. YouTube does not like that. All right. We're on a sidebar. God, I was sitting so long that my pants made marks in my legs. And like now my legs hurt because I moved. That's terrible. This is why I should be doing it every hour. I got to move around.
Do you tell Jack Kowalski that you don't care, that you would put he and his wife in jail tomorrow if it means Maya gets better?
If you're saying that's what the quote is, then yes.
Oh boy.
And did you remind him of what good it would do to Maya or Kyle if both their parents were put in jail?
Objection. Argumentative misconception.
Overruled.
Could you repeat the question, please?
Did you tell them or ask Jack what good it would do if Maya or Kyle, if both their parents were put in jail?
I'd have to look at the. If you're telling me that was the transcript, but I'd have to see the transcript itself. Yes.
We always lose people when I play that clip. Why is that? You can't do squats for 1 minute and 22 seconds. Maybe they went to the bathroom. We always lose a bunch of people after that. I don't know why.
Yes, this was at the very end of the conversation. I see where the quote is. Yes.
And so, what did you tell him?
Do you want me to read the blue highlighted area?
You don't have to read it, but let me just ask you again. You were telling Jack Kowalski, you were giving him an opportunity because, and you ask him again, what good does it do if Maya or Kyle have both their parents put in jail?
That was what was said in the transcript. I was.
Just say I did.
I forget what was the question. If you could go back.
You answered it.
I did. Okay.
You say it.
Anything further?
Yes, briefly, Ron. He showed you, Mr. Anderson showed you a page from what looks to be page 168 of the transcript.
Yes.
That conversation that he's referring to came after all of the statements that you and Jack had that we published to this jury, correct?
Yes, I recall this was at the very end, and that I was expressing to him, because he had expressed to me during this conversation that he was protective, he was encouraging, he was being the protective parent.
He's going to tell you anything that you want to hear. Nick, thank you so much for the super chat. Says, cops are like YouTube. They both Asshole. Why am I not using Cash App? I'm so bad at this. I don't know, but you can use Cash App. And the Cash App address is rolling across the bottom of the screen. And that way, Google doesn't get their filthy little evil hands on your money. It just goes straight to me. And we don't have to pay the middleman that way. So Super Chats are fine. But if you have Cash App or Venmo, you can use that as well. And I won't read your full name. I'll read like, your first initial or whatever, or your just first names. Rosalind, thanks for the super chat. The butter rant is my wake-up alarm. It makes me so happy. Did you download it with the music that I put with it, or is it just Nick ranting? It is a funny rant.
And I was just expressing it doesn't do any good for both parents to be in jail. It doesn't do any good.
Well, let's explore that really briefly since you brought it up. Were those comments made as encouragement to Mr. Kowalski to be protective of Maya?
Yes, because that is what he had conveyed to me during the course of our entire interview.
And
he would do anything, and even said he would go to jail tomorrow if he was responsible.
Right. In the comment.
Oh, because it's really loud. That's why we lose people. Oh, you know why? I always forget that I have the court volume boosted, and I need to turn it off before I play Nick, because yeah, it is loud, and it's because of the volume boost. Dang it.
That you made was not about your desire to separate them. It was Mr. Kowalski telling you he's protected and that he wanted to have Maya home.
Yes, that was his ultimate goal. Was Maya.
At no time in your interview did you ever threaten to arrest him, did you?
No.
I object to that characterization because I heard her threatening to arrest him. You don't have to say, I'm going to arrest you if you don't A, B, or C. She said, she intimidated him by that, saying, basically, I put somebody else in jail for this for 10 years. You could be next.
You can answer.
No, in fact, at some point during the conversation, I think I said, you're not under arrest.
And you reiterated to Mr. Kowalski at least twice during the interview that he was not under arrest and he was free to leave.
Yes.
Thank you.
So you think it's encouraging to say, frankly, I don't care. I'll put you and your wife in jail tomorrow if it meant Maya gets better? That was encouraging to him. Is that right?
I was stating that my ultimate focus is the safety and well-being of the child. That is my goal as an investigator. And if that meant that I had to take action to protect the child from her parents, that is exactly what I would do.
Or it meant to let him know that if he had anything to add, he better add it right now, or you would consider taking him to jail, right?
I would disagree.
And didn't he say throughout he did not believe that Beata would ever harm her children?
I believe he said that he believed she would take the child back to get more dangerous treatments that we were trying to protect the child from.
That's not my question, ma'am.
Well, that told me that he believed that she might.
Ma'am, answer the question
Oh,
he asked,
boy.
the question he asked.
Yes, sir. Okay, could you repeat the question, please?
Didn't he tell you at least twice that he did not believe Beata would do anything to harm their children?
Yes.
Nothing further. Members of the jury. Seeing none, you may this witness speak. Oh. Okay, members of the jury.
Rosalind, what are the chances that we both picked out that rant to use? Out of all the fat rants he's ever done. Hilarious that we both decided to choose that one. Rosalind says, just Nick, but I'd love the music version for parties. Thank you for the super chat. I appreciate it. All right, let's see. 2 hours and what are we at? We are at $39 for almost 3 hours. That's less than minimum wage. Oh no, it's a less than minimum wage night. That's okay. You guys have been super generous all week. Let's take Friday off from caring. I just don't anymore.
The question is, did you talk to him, being Jack Kowalski, again over the next few months?
No.
Members of the jury, that's the only question of this second round of questions that you submit that I'm able to ask. So is there any fault based on that one question?
No, Your Honor.
Okay, and may she be excused?
Yeah, yes.
Mr. Anderson?
Yes, Your Honor.
Okay. Man, thank you very much.
Boy, all of
Members
these
of the jury,
witnesses cannot
given
wait
the
to
time, I think
leave
it's a good
this
time for us to break for
courtroom,
lunch.
and it's
Please do not discuss this case
hilarious.
amongst yourselves. Do not do
All right, so they're going on their lunch break. Let's skip past that. Now, I'm going to skip past if there's any motions or whatever right now because I don't have time for that. Ain't nobody got time for that. Oh, thank you, Wonderland. I appreciate the Cash App. Was it Cash App? I just got a notification and now I can't find it. But Wonderland sent me a Cash App for $20. I appreciate that. I didn't even do any shaming. I decided to take a night off from the mom shaming. Thank you. For what does this say? For oh Lord mom shaming. Thank you, Wonderland Alice. I appreciate that. And it looks like, oh, I forgot yesterday. So yesterday I missed a Cash App at the end of the stream. So Joby, thanks for sending the Cash App, and it said thank you for your coverage, and it was $20. So thank you for that. I appreciate that. All right, we're skipped past the whatchamacallit, the lunch, and now we're here. They're proffering
Lindsay
something.
Massaca and Attorney Westmoreland, if you could. Your Zoom, thank you.
Oh, here we go. Now this one, instead of the black box die from L'Oreal, this one has the red box die from L'Oreal. I'm assuming that I think this is a DCF witness. But look at the split down the middle, straggly hair down the sides. I mean, seriously, put this woman in the lineup with the other boil, toil, and trouble. What is that Shakespeare line? Boil, toil, and trouble, something like that. You could put all these women around a big boiling cauldron and they'd fit right in, wouldn't they? Which one is better, Venmo or Cash App? Whichever one you want. Either one works for me. I got both. All right.
Your Honor, my name is actually Deanne Fields. I'm an attorney with DCF. Miss Westmoreland is under the weather today, so I'm subbing in for her.
Yeah, can you tell me your name again?
Deanne, DEANNE, Fields, FIELDS.
And
I'm also an attorney for DCF.
And Miss Fields, is Deanne, is the A capital or is it just lowercase a?
It's just lowercase a.
And did I do that properly? If you look, did I get it properly?
That's correct.
Okay.
That was impressive.
Here it is. Double, double toil and trouble, fire burn and cauldron bubble, fillet of a fenny snake in the cauldron boil and bake, eye of newt and toe of frog, wool of bat and tongue of dog, adder's fork and blind worm's sting, lizard's leg and howlet's wing, for a charm of powerful trouble, like a hell broth boil and bubble, double, double toil and trouble, fire burn and cauldron bubble, cool it with a baboon's blood, then the charm is firm and good to steal all the little children from all the parents. It's always a good time to read Shakespeare. But can't you just see it? Can't you just see these ladies dancing around a cauldron? It's perfect for October. It's very seasonal.
This is, and just so the transcript's clear, this is a proffer. Ms. Massaca, are you currently in the state of Florida?
Yes, sir.
Please raise your right hand to be sworn as a witness. Do you solemnly swear or affirm the testimony you give is the truth?
I do.
Thank you. Please lower your hand. Miss, or who's starting the proffer?
Can I just explain to Ms. Massaca, because I didn't,
Sure.
about whether, so Ms. Massaca, the jury is not in the room, but we're just going to do a proffer of what your testimony is going to be. And then when the jury comes in, I'm going to have to ask you the same questions again. Okay?
Okay.
All right. Okay. So I'm going to skip background. But Ms. Massaca, back in October of 2016, you were working as a CPI supervisor, correct?
Correct.
All right. And you had some involvement in the Kowalski matter, correct?
Correct.
Okay. Was it the situation, or do you recall the situation where Maya Kowalski was sheltered at Johns Hopkins All Children's Hospital at that time?
I do.
I want to run into that office and grab all those files behind her and rescue all the children that she has taken. Those files all represent some poor family that she's got under her claws. And I guarantee you out of those, however many files are back there, there's several because they're all stacked up in front of each other. Let's say there's 25 files in there. If national statistics hold, 80% of those 25 files will be found unfounded. And 80% of those families will have been dragged through this hell for no reason.
At the time, since Maya Kowalski was sheltered, was it required that any visitors, before they could visit Maya, have a background check run by DCF?
That is correct.
In addition to being involved in background checks, do you also recall a situation where Mr. Kowalski was visiting Maya in October, get the date here, October 24th of 2016, and you were requested to advise on what items could or could not be brought into the room?
I do.
And was that in your role as a supervisor for DCF?
Yes.
And did you specifically not allow in the razors?
That is correct.
And did you specifically not allow in the communion?
That is correct.
And was it your
you threw Jesus, you ordered Jesus to be thrown in a dumpster. Where's my meme? You ordered this woman, you ordered this handsome gentleman here to throw Jesus in the dumpster and chocolate cake. It was this one. She was the ringleader of throwing Jesus in the dumpster. Look at her. Look at her face. Not remorseful at all, are you?
Comment to
I gotta hear that again.
Not allow in the for DCF?
Yes.
And did you specifically not allow in the razors?
That is correct.
And did you specifically not allow in the communion?
That is correct.
And was it your comment?
No, it wasn't just the communion, ma'am. It was the consecrated host, the consecrated body of Christ. It was Jesus. You threw Jesus in a dumpster.
To was it your concern with regard to the communion and your comment, therefore, that there was a concern there could be liquid ketamine on the communion?
That is correct.
Do these people even Catholic? No, of course not. Of course they don't. Because they're anti-Catholics and they're anti-Christian and they're anti-everything that's good. And they're anti-religion and they're anti-freedom and anti-liberty. But to assert, yeah, okay, thank you. Thank you, night owl. That's something we haven't even touched on. Has anybody seen a communion wafer? They're made out of, like, I think rice. They're very thin. And the second you put one on your tongue, it dissolves. If someone had dropped ketamine on it enough where it would have actually helped her, I would imagine you'd have to put quite a bit, it would have disappeared. It would have melted. What a ridiculous assertion. It's absurd. Jojo, welcome as a new member. Thanks for doing that. Welcome to the Fox Den. Enchiladas Unbreaded, thanks for the 20. Prayers and love for your mama. Aw, she appreciates that. Thank you so much. I sent her some photographs today of school pictures of the kids, and I'm hoping it will cheer her up. I sent them in the mail, and I'm hoping that that will make her feel better. But man, this is so dumb. Are we to believe that? Thank you, honey. Are we to believe that they baked them? They baked the ketamine in? Because if you put liquid ketamine, oh, look at this pizza. Check it out. It's pizza night in my house. Mr. Fox just got done making Chicago-style pizza, and he just delivered me some. I mean, does that look good or what? Oh, it is so good. So good. I'm so happy. Yay. All right. I'm about to chow down.
At one point in time, was there an attempt or interest in transferring Maya to a medical foster home?
There was.
Okay. Can you explain what a medical foster home is?
Yes, that is a placement for a child to go where
They get
there
more
is higher
money.
level of training in the medical field to be.
And they get more money for that. If you can be a medical foster home, you get more money from the state, and the state gets more money for taking kids with medical problems. Seems like a bad idea to monetize taking medically fragile kids from their parents.
Placed after a child is taken out of custody of their parents.
Okay. And is it your understanding, for whatever reason, that did not occur?
Yeah, that did not occur.
All right. That would be it, Judge.
Any questions from the plaintiff?
Just very briefly. Ms. Massaca, my name is Nick Whitney. I represent the Kowalski family. I have a couple of emails of yours from October 24th and November 29th, 2016. Do you have emails with you this afternoon?
I had some things forwarded over to me, but not everything from the case prior of the deposition.
So let me ask you just specifically about these emails. I have an email from October 24th, 2016 from yourself to Cynthia Zangari, CC, and Kathy Beatty. Do you have access to that email as you sit there today?
No, I do not.
And secondly, I have an email here from yourself to Kathy Beatty from November 29th, 2016 at 10:59 p.m. Do you have access to that email as you sit there today?
No, I do not.
Thank you. Thank you.
You're welcome.
Okay, Ms. Massaca, what I'm going to do is I'm going to place you into the waiting room. I'm going to let Attorney Fields remain, but I'm going to put you out of our presence, okay?
Okay.
The transcript should reflect that Ms. Massaca is out of our presence.
So Your Honor, I have two issues. First is my questions are directed at, I want to refresh the witness's recollection, but without access to her emails, I'm left not able to do so. So on that basis, we'd like to either give some time to get these emails over to her or postpone her testimony to another day.
Well, Judge, I'm sorry.
Go ahead.
Well, can I hear the?
And then secondly, I don't have a problem with the questions regarding the razors, the community wafers. I do think the questions about transfer to medical foster care and that not occurring wades into the Chapter 39 issues in this case.
On the second aspect, the medical foster home issue.
Well, the reason I bring that up, Judge, is because the accusation against Ms. Beatty in her deposition was that she wanted to just put Maya in a foster care like it was some negative type thing. So I just wanted her to explain what a medical foster home is. It's not like
No,
because of this person.
that's in Chapter 39.
That's your opinion. Foster care is terrible. Statistically speaking, foster care is where kids get abused. 60% of kids rescued in sex trafficking come from the foster care system. If foster care is so great, and that's from our own State Department's numbers, if foster care is so great, then why are they ending up in sex trafficking and homeless? By the way, also, she said she wanted to prove that that they weren't putting her in just some random foster care. Why were they putting a girl in a medical foster care facility or home when they said she was faking? When they didn't believe she was sick? That should make you really question. But I thought her mother was making her sick. Why would they put her in a medical foster care home?
Discussions about medical foster care will be not allowed.
Okay.
Good.
Now, were there any other aspects of the
Oh, Mark,
proposed
you're
testimony?
having my
Substance of the
favorite
testimony,
pizza.
I don't think it's problematic.
Oh,
so long as I have an
Aurelio's?
opportunity to refresh a recollection, and that's
well.
I thought that
Mark, you're having my favorite pizza. If it's pepperoni, I'm going to be so jealous. Although Mr. Fox's pizza is very good, but that sauce at Aurelio's, the sweet sauce, is my absolute. That's my favorite. With that, the crust, how it's so crunchy on the outside. Oh, the best. You're killing me. Killing me, Smalls.
Can we do that right now outside the presence of the jury?
Well, and Judge, because I think one of the emails he wants to refresh her memory about is about a situation that the court has already ruled is not admissible. So,
Well, the question of refreshing the recollection is a different question of whether the testimony is relevant. So I'm just asking from a, can we just put up on the screen right now those emails and she can read them? outside the presence of the jury? And then she'll go first?
Sure.
Okay, so do either Mr. Reyes or Mr. Is it Cottrell? Have the ability to put those up, and let me bring in the witness.
You need to enable screen share.
I do, huh?
Can I see what you're gonna show?
Yeah.
Try that.
Judge, I think if we show the court what he wants to refresh your memory with, we can have an order on it, because I don't think it's appropriate.
Okay, well, bring the pieces of paper up first.
I got another Cash App here. Shayla, thank you for the $20 Cash App. It says for being awesome. Oh, you're awesome too. Thank you, Shayla. Appreciate that.
And Mr. Whitney, what is the topic or topics that you seek to go into?
That the source of information for Ms. Massaca is
Mr. Reyes?
Yes, Your
I'm hearing feedback, and I think you were the most recent one to sign on, so.
I fixed that before I logged in.
Okay.
You still hear it?
Right this second, I do not.
Yes.
Mr. Whitney.
Yes, Your Honor. I want to, there's another one in front of you there, Your Honor, behind the screen. So with 2123, 610, and 611, it's that the source of information for Ms. Massaca's interactions with the hospital was Ms. Beatty. That, having refreshed her recollection, Ms. Beatty characterized phone calls as damaging for the child. And that Ms. Beatty suggested to Lindsay Massaca that Beata could not discuss pain or pain medications with her daughter, and point out that the shelter order retained medical decision-making with the parents. That's the basis of my questions to 610, 611.
Okay, on those questions, don't go to the issue that I have previously said is the issue that's going to be going to the jury. So I don't see how those questions are relevant.
Which issue, Your Honor? I'm sorry.
As to whether there was a delegation. The fact that Ms. Beatty was talking to DCF is besides the point. That was the process for the Chapter 39. So that's not any problem, and I'm pretty consistent with that. So let's move on to your questions with respect to 2123-032.
I thought the issues with the phone calls were related to the intentional infliction claim.
Tell me the specific question you want to ask.
That Ms. Beatty was listening in on the phone calls and characterizing them to Ms. Massaca as damaging for the child.
The question of whether she was listening on the phone call is relevant. The characterization damaging to the child is not.
And so
then I would alter my questioning with respect to that 610.
Perhaps we can ask her in proffer whether she has a recollection of whether Ms. Beatty was listening on the phone calls.
Well, Judge, I think it has to be very careful. This is not the same phone call the jury heard. That was November 15th, 2016. And I don't want this to be confused. And the jury thinks that this is referring to the November 15th call that we've had so much testimony about. This is a November 29th, 2016 call.
So be very specific as to the date. And then in proffer, we'll ask her, and if she needs to be refreshed as to whether it was that day or not, then we can show this email. But I don't want the substance of the email being discussed as part of an answer.
Understand.
So let's move on to the other exhibit.
Is Whitney going to do this cross?
Yes, Your Honor. Now, this is an email exchange between Lindsay Massaca.
Oops. Whoops.
And Kathy Beatty. And my questions are going to center around.
First off, who is Cynthia Zangari?
Great question.
Zangari.
She was the CPI. One of the CPIs was referencing Ms. Nita's testimony earlier.
And you have Ms. Beatty CC'd here on this email. So defense counsel's questions centered around the decision to not allow the razors, but you'll see at the bottom of this email, there's a whole host of things that were being provided.
Oh,
So-
I was going to get into what was, I'm sorry if I left that out. I was going to ask her what was provided, what was allowed in. If that's the question.
And so then I was going to ask her a question about who you can see there in the primary paragraph, who was she deferring to at the hospital to weigh in on these decisions? And she's asking directly Kathy Beatty.
So she's seeking input of Kathy Beatty before making any decisions. And then I was going to ask her, based on this, who is Jen? I don't know who Jen is, but there's authorization here from Jen to let the communion wafers in. So I wanted to ask her that question.
Judge, first of all, the email that asked Kathy Beatty is from Cynthia Zangari, not from Lindsay Massaca. And then it goes up the chain, and Lindsay Massaca is the one, do you have all the email there? Because Lindsay Massaca then is the one that says,
I'll
no.
be right back. I gotta
What if
get
they
a
put
beer.
ketamine on
I
the,
think I'm gonna get
on
more
the
pizza.
communion? And she's the one that decides it can't come in. They're trying to imply that Ms. Beatty had some decision-making about this, and this was DCF all the way.
I mean, it says here, Kathy, are these items okay? I want to ask this question if they were deferring to Kathy Beatty.
That line of questioning, I don't think is appropriate. So no. So we'll bring back in Ms. Massaca, and you can ask her in proffer about, was it November 29th question? Whether Kathy Beatty was on that phone call or whether Kathy Beatty said she was on the phone call, or whatever you're going to ask her. For purposes of the proffer.
Then for purposes of the proffer, outside of these emails, I'd like to ask a line of questions about other items that were taken away from Mike Kowalski and whether she had any involvement.
That's fine, but you know, those other issues are not going to go into the jury. But if you want to do that within proffer, that's fine. But let's do it now, so we don't have the jury waiting. Okay, I'm going to bring Ms. Massaca back in.
So when we're going to be able to show her this email.
Well, let's see if she needs it first. Hi, Ms. Massaca. This is Judge Carroll again. We're going to have a few more questions. The jury is still not in our presence, okay? Mr. Whitney is going to ask you some questions.
Okay.
Hi again.
Hello.
My first question is, do you recall email correspondence between yourself and Catherine Beatty and others on November 29th, 2016 regarding a phone call between Beata and Maya?
I recall having emails between everyone. I just wouldn't be able to say the specific dates without it in front of me.
Would it refresh your recollection if I showed you that email?
Sure.
Judge, I think the ultimate question was going to be asked as opposed to.
We're in proffer. Let's just
Okay.
put up the email and let's move on. Okay, let's put up the 2123-610.
Yeah, I wasn't saying put it up in front of the jury. Ms. Massaca, if you would take a moment and review your email back at the top and then Ms. Beatty's email, at least the first part of it below, and let us know when you're done.
Okay.
What did I miss? She's refreshing her memory or something with this. What does this say? This is very disheartening to hear that this is still occurring. I hope the hospital's request can be honored. It's probably going to be difficult considering what the judge ordered. Other than this, how has she been doing? That was from Monica Lewinsky? What does it say? Something Lindsay? Lindsay? I don't know. Good evening. I wanted to let you know the phone call with mother today was damaging for the child. Oh, we read this already. This is the damaging for the child one from Kathy Beatty. If you guys want Mr. Fox's pizza recipe, you need to be a member on my locals channel because we did an entire stream there of him making it and giving his recipe, showing you how to do it.
Ms. Massaca, was it apparent to you that Ms. Beatty was monitoring the phone calls between Beata and Maya?
Objection.
mayandfox.locals.com.
Yes.
Other questions you might have in proffer.
Ms. Massaca, there were certain items that you approved and certain others that you disapproved. Those were discussed with Johns Hopkins counsel a moment ago. For example, you disapproved the razors and ultimately the communion wafers. Do you recall approving things like deodorant, body wash, nail polish remover, nail file, earrings, chapstick?
Yes, I do.
As a general rule, did you allow toiletries and items for Maya's care in the hospital in?
Yes.
Was there ever a point where you disallowed shampoo?
Not to my recollection, no.
Was there ever a point where you became involved in disallowing a Tommy Hilfiger Christmas dress?
No, sir.
Was there ever a point you became involved in disallowing chocolate cake?
No, sir.
Was there ever a point you became involved that you disallowed rosary beads from Mike Kowalski?
No, sir.
Did you ever disallow a prayer book from Maya Kowalski?
No.
That ends the proffer.
Anything else, Ms. Gross?
Not the proper, just Martin.
Okay, ma'am, I'm going to put you back into the waiting room. We'll call you back in just a couple minutes.
Okay, thank you.
Okay, the transcript should reflect Ms. Massaca is out of our presence.
Judge, sorry.
Go ahead.
Judge, despite the court telling counsel that it to be specific on the time, he's again trying to blur the lines. And he just said, are you aware of Kathy Beatty monitoring the phone calls? It has to be date specific. They're going to try and imply that that's a November 15th call.
No.
I'm confident Mr. Whitney is going to use the specific date when he asks the question.
Well, he didn't on the proper, that's why.
She had the email in front of her, but I will triple check. I'm circling it. I'm starring it. I will use the date.
Anything else?
No.
Now,
I'm excited for his
on the
cross.
last bit of questions about the rosary beads and all that, any further statements about?
Well, the point of this testimony from defense counsel's perspective is to shift the blame for items that were kept away from Maya Kowalski to DCF. So we need to be allowed to explore and highlight for the jury that, yes, that may be true of some items, but that's not true for the items I just went through there with Ms. Massaca.
Yep.
Ms. Gross, that I'm telling you that the questions that Mr. Whitney just asked and that explanation is gaining traction with me. So why shouldn't he, being Mr. Whitney, be able to ask those
I'm
questions?
not objecting to this.
Okay, you can ask them.
Yeah, he's showing that it was the hospital keeping things away from her. DCF wanted certain things, but they never said take the cake. Who said take the cake? Kathy Beatty, maybe?
Questions. Thank you. Anything else before we bring the jury in and Ms. Massaca?
One second, Judge.
Your Honor, you've cleared your own problems too.
I would like to stop sharing, but it appears that that's not even an option for me. I was able to share the document or share my screen, but now I can't unshare it.
Well, I'll tell you what, let me do this.
I'm spilling pepperoni on myself.
Did that do it?
All right, let's
Exit
get
the meeting
past
then.
the technical
Doc-
problems.
I'm sorry, but put her under oath. Who are under oath.
We're back.
Welcome, everyone. Please be seated. So, did you have a good lunch on Friday? I want to confirm while you're away on lunch, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct?
Correct.
And that you did not observe any sort of media accounts about this case. Is that correct?
Correct.
And that no one approached you about this case. Is that correct?
Correct.
Okay. Our next witness is going to be by Zoom. I have already administered the oath to her, so she will be testifying under oath. Ms. Crowells, if you could please call your next witness.
Yes, defense will call Lindsay Massaca.
Okay, and you may proceed when ready, Ms. Crowells.
Thank you. Good afternoon. Can you hear me?
Hello. Yes, I can. Can you hear me?
Yes. Would you go ahead and state your name for the record, please?
Yes, it's Lindsay Massaca.
I've said your name wrong. I'm so sorry. Massaca.
That's okay.
Ms. Massaca, what is your current employment?
I am a therapist.
Okay. Prior to being a therapist back in 2016, did you work for DCF as a CPI investigators or CPI supervisor?
Yes, I did.
And what does CPI stand for?
Child
Yet another one who's left her job. So now we know that all of the risk management team fled the state and somewhat the country. And Joseph, Megan, I love you, but have some self-respect and don't be shoving pizza down your throat when you're hosting a podcast. Why not? Well, I've been on here for 3 hours and it's dinner time. Am I supposed to wait and let my pizza get cold? I think not. I'm going to eat my pizza. Thanks. What was I saying? You derailed me. Gosh darn it. So maybe I'll remind myself.
Detective investigator.
Okay.
Oh,
and how long?
So yeah, risk management fled the state. And this woman no longer is in her job. And Miss Nias is no longer in her job. She works at the post office. And a bunch of the doctors no longer work at Johns Hopkins. Like, so what is the deal? they didn't get fired, or they just decided to leave because they realized that this case is so effed up? I don't know. But at least those files behind her head aren't kids she took away from their parents. They're just, she's a therapist now.
How long did you work for CPI?
Approximately 6 to 7 years.
Okay. And was that back in 2013 until 2019?
Yes.
Okay. So back in 2016, you were a supervisor for CPI.
Correct.
And that's part of DCF.
Correct.
All right. And at that point in time, did you have some involvement with the Kowalski matter, the Maya Kowalski matter?
I did.
Okay. And with respect to that, you understood back in October of 2016, when you were involved, that Maya Kowalski was sheltered under DCF custody, but remained at Johns Hopkins All Children's Hospital.
That is correct.
Okay. And as a result of Maya being sheltered, was it required by DCF that any visitors had to have background checks be conducted before they could visit Maya?
That is correct.
Okay. And were you involved in communicating with Mr. Kowalski about that?
Yes.
And did you, in fact, did you do the background check, or was that assigned to someone else?
That could have been a combined effort. Once we get the individuals, we submit the request.
Okay. And the individuals names would have to be submitted to you by Mr. Kowalski, correct?
Correct. Yes.
And regardless of their position in life, whether they were a teacher, a priest, a baker, whatever they were, they had to be approved and vetted by DCF before they could see Maya, correct?
Come forward just a second, and I'm going to place my microphone on mute to you, Miss. How do you say your last name again?
Massaca.
Miss Massaca. Okay.
He really said, "Come forth." Come forth, children. Come forth. That was funny. No, I don't understand why people get pissed off at streamers when they eat. When are we supposed to
Staying
eat?
the objection.
If I'm streaming for several hours, I'm gonna have to eat. I haven't had anything to eat all day.
You don't need to answer that question. I think you need to unmute yourself. Thank you. I'm going to sustain the objection. You don't need to answer that question.
All right, Ms. Masca, do you remember back on October 24th, 2016, around the time being involved in determining what items could be brought into Maya Kowalski's room by her father?
Yes, I do.
Okay. And specifically, was it you that made the decision that the razors could not be brought in?
That is correct.
Okay. Was it also your determination that the communion could not be brought in?
That is correct.
And was that because of your stated concern by you that there might be liquid ketamine on the communion?
That is correct.
Okay. And that's on behalf of DCF, correct? That you made
That
that
is
statement.
correct.
All right. You did allow some item in though, correct?
Yes.
Okay. Let me just ask you, do you recall that you allowed in the body wash?
Yes.
The earrings, the nail polish remover, a computer lab workbook,
Yes.
nail file? Yes?
Yes, that is
Sorry.
correct. Yep.
Chapstick and deodorant, correct?
Yes. Yes.
Thank you, ma'am.
Mr. Whitney's going to have some questions now.
Good afternoon. Ms. Massaca, have you had the opportunity to review an email between yourself and Ms. Kathy Beatty from November 29th, 2016?
Yes, just today.
Was Ms. Beatty your point of contact at the hospital?
She was.
Was it apparent to you upon reviewing the email discussing the phone conversation between Beata Kowalski and Maya Kowalski from November 29th, 2016, that Ms. Beatty was monitoring or listening in on the phone calls?
Object to the form, Your Honor.
Overruled, you can answer it.
Yes.
I want to move to those items that you disallowed and that you allowed in your role. To be clear, you excluded from Maya Kowalski the razors, is that right?
That is correct.
And I wanted to clarify on the communion, when communion was discussed, what you excluded were communion wafers, correct?
That is correct.
Generally, and defense counsel just read the list there, you let in things like deodorant, body wash, nail polish remover, chapstick, a nail file. Was it your general policy to allow in items that were for Maya Kowalski's health, well-being, bath needs, etc.?
Yes.
Was there ever a time where you disallowed shampoo for Maya Kowalski?
No.
Was there ever a time that you disallowed chocolate cake for Maya Kowalski?
Oh, my computer froze, sir.
I think we saw that. Yes. I'll repeat my question. Was there ever a time that you disallowed chocolate
She
cake?
has my problems.
No.
Was there ever a time that you became involved in excluding from Maya Kowalski her Tommy Hilfiger Christmas dress?
No.
Did you ever disallow Maya Kowalski to have her prayer book?
No.
Did you ever disallow Maya Kowalski from having her rosary beads?
No.
Thank you, ma'am.
Nobody
you.
put ketamine on the body of
Yes, ma'am.
Christ. That's absurd. Thank you, Night Owl. That's how I feel.
First, the phone call that was referenced in the November 29th email was a phone call on November 29th, 2016, correct? That was.
That, I don't recall. I just read that now.
With respect to outside food, was it also, was DCF also monitoring whether or not outside food could be brought into Maya's room?
Foundation, predicate, speculation.
You can answer that question.
Can you repeat the question for me?
Sure. Was it also a fact that DCF would be monitoring outside food and whether or not outside food could be brought into Maya?
I believe we were monitoring any items that were in and out of the hospital for Maya.
Yana, can we approach briefly?
Yes.
Not only monitoring, but throwing Jesus in the dumpster. That's what they did. You heard it from the horse's mouth. They threw it in the dumpster. They threw Jesus, our Lord, in the dumpster. These bastards. I can't even. I know Jesus can take it, but I feel like I can't. I can't take this kind of heresy. I tell you, it's heresy. It's just rude. It's also extremely rude.
Miss
Throw the
Massaca, can
Lord
you
in
still
the
hear us?
dumpster.
Yes, can you hear me?
Yes, I'm going to give an instruction to the jury.
This is so
Members of the jury, the parties have agreed that the telephone call being referenced just now occurred on November 29th, 2016. Anything further, Ms. Crowells?
No, Your Honor.
Anything further, Mr. Whitney?
Not this time.
Now, don't go anywhere, Ms. Massaca, because the jury might have questions. So just give me a second. And yes, there's going to be jury questions. So
I love the jury questions on this. Absolutely love jury questions on this. Let's
Correct.
see if we can fast forward. Maya looks tired. It must be really hard for her. It must be really hard for her to sit there and listen to them again, say they don't believe her, and listen to all these doctors and whatnot saying that they just didn't believe her. It's just sad. Somebody needs to believe her.
Ms. Massaca, I've got a series of questions from the jury. I'm able to ask all of them but one.
I also have to say this. If what she has is psychosomatic in some way, what she really needs is someone to listen to her. Not to be combative with her, not to be confrontational with her or skeptical of her, but to reach her on a level where, you are being listened to. I'm hearing you. I am going to help you get to the bottom of your pain and try multiple things. I'm sure if they had come at her from a loving attitude, if they had come at these parents with a loving attitude of, you know what, we're going to call her treating physicians. We're going to bring them in. We're going to bring in Dr. Kirkpatrick and put him in the room with the rest of this team here so that we can hear his perspective. We don't agree with his perspective, but he's treating her. So we're going to listen to what he has to say. And we're going to look at his numbers and we're going to look at his charts. And if they had done that, don't you think that Beata would have been so happy that they were bringing in Dr. Hannah, Dr. Kirkpatrick, like the people who treated her? But instead they're like, well, we have rules here, and you have to be apply for credentials in order to be in this hospital as another doctor. But DCF didn't have to have credentials. Their doctor didn't have to have credentials. He just walked in and interviewed Maya. Somebody needs to listen to this kid. Yeah, Femme Natal, she's 17, but she can't, she's terrified of doctors because of what these people did. Instead of starting from a position of, we believe that you're in pain and we're going to try and treat that pain. We just disagree with maybe what that pain is, where it comes from. So let's try to get to the bottom of it. Instead of coming at it from that point of view and being sympathetic and empathetic with the family, they turned on them like they were criminals. And then they tortured her. I mean, if Bonnie Rice is right, and I'd like to believe that she has some redeeming qualities, she seemed like a generally pleasant person. If she's right and it is conversion disorder, she says you don't confront them. You treat them sympathetically and with love and positivity. So what the hell is wrong with Johns Hopkins doctors that they don't know that?
Okay.
Why did you let computer workbook in when you did not let her have her laptop?
I don't recall
question.
there being a specific reason between one or the other.
Next question. Was the communion wine or crackers in a sealed package?
That I don't recall.
Next question. Did
Great
anyone ever
question.
test the outside food for ketamine if they were worried that
Great
ketamine was being
question.
placed in those items?
No.
Not that I'm aware of.
Why wouldn't they do that? Joby, thank you so much for the huge Venmo, $50. Thank you. Thank you for covering my trial, says Joby. I sure appreciate that. You're awesome.
Ms. Crowells, anything in follow-up from the jurors' questions?
No, Your Honor.
Mr. Whitney?
Yes, sir.
Ms. Massaca, please correct me if I'm wrong. Are you in Sarasota as you sit there?
No, I'm in Bradenton.
Bradenton. And is that where your office was in 2016?
No, my office was in Sarasota or Arcadia or Northport.
And at the time of Maya Kowalski's sheltering, did you go to Johns Hopkins All Children's Hospital on any occasion?
No, I did not.
And is that the reason you don't have knowledge as to the status of the communion wafers, whether they were sealed or whether food was tested?
That would make sense, yes.
Thank you.
You're welcome.
There's more questions from Ms. Crowells, and I think the jury as well.
No, Your Honor. Wait.
Okay, so looks like I've got a couple more questions coming from the jury, so I'm going to place you back on mute, okay?
Okay.
Jury's not as spicy today as they were yesterday, though. There aren't like, are you telling this jury? Is it your testimony? I wish they had asked, what did you do with the communion after it was confiscated from her? Where did it go? Maybe they did and they didn't ask it because the relevance, maybe it doesn't have relevance, but here's how I would argue that it's relevant. The whole point here is that they were so inconsiderate to her religious rights and ignorant in lots of areas. Were they ignorant enough to throw Jesus in the dumpster, as I surmise that they did? I did get this security camera footage of them doing it,
Just one sheet this time.
which, proves my point.
Ms. Massaca, can you hear us again?
Yes.
Great.
And of course, StreamYard is.
Did you have an assigned single
not
contact
working.
at Johns Hopkins All Children's Hospital?
It wasn't specifically assigned, but I did speak majority with the social worker, Kathy Beatty.
Did more than one Johns Hopkins All Children's Hospital employee contact you, and who were they?
All right, hold on. StreamYard's freezing on me again. I gotta refresh. Be good. I'll be back. I love that that stayed up there. Did that stay up there the whole time? Oh, man. Oh, that's good. Hold on. Now I got to find it so I can take it down. Okay. Man, if this keeps up, I am going to have to reboot my computer. The good news is my new laptop stand appears to be helping out because I haven't had any unexpected shutdowns. So I have a new laptop stand that has a fan on it. It's fanning my laptop as we speak. It's blowing air on it, which is kind of cool. And then I got a new adapter for all my external hardware. So far we haven't had the spinning wheel and the total shutdown. So maybe I made some progress there.
I don't recall. I could have spoken with nurses, but I can't.
What is
I don't recall.
Hawkins Alter
Social worker Kathy Beatty. It wasn't specifically assigned.
contact at Johns Hopkins All Children's Hospital.
It wasn't specifically assigned, but I did speak majority with the social worker Kathy Beatty.
Did more than one Johns Hopkins All Children's Hospital employee contact you, and who were they?
I don't recall. I could have spoken with nurses, but I can't, without seeing, my notes or files from the investigation, be able to clearly answer that.
Ms. Quarles, anything further?
Just briefly.
Ms. Quarles.
Does your laptop have a fainting sofa?
So
It should.
you testified that you didn't get over to the hospital, but do you recall Ms. Nihas was working and at the hospital assisting with supervised visions with Mr. Kowalski?
Yeah, she was employed by the Safe Children's Coalition. She was doing visitations.
Okay. And do you recall that she was the one on that October 26th date when the question came up with regard to the communion and what could be let in and what could not be let out of the room?
That is correct.
Okay, thank you.
You're welcome.
Nothing further. Anything else from the jury? Seeing none, may Ms. Massaca be released from all subpoenas?
Yes, sir.
Yes, sir. Okay, thank you very much, ma'am. I'm going to go ahead and turn it off for you. You're free to go.
Carlos, you do get the consecrated host out of the church if a priest allows someone to bring it to a person in the hospital, right? They have these little containers usually made of silver, and the consecrated host, like there will be they can put 3 or 4 of them in there to take to someone in the hospital. And that's for them to consume after saying a prayer. And right, to Catholics, it is the body of Christ because it's a consecrated host. It's not just the cracker. It's after the priest has consecrated the host. And no, Carlos, sometimes they don't. In my church, they don't go to the hospital to do it. In certain circumstances, you can request the priest to give you a consecrated host in a little container. It depends. He has to know you and trust you and whatever. Sometimes it'll be a minister of the sacrament. No, it is a thing. Carlos, it is a thing. I mean, I don't know if maybe it's not a thing at your parish, but I know at mine, they will allow a minister or whatever, a minister of the sacrament to go take consecrated host to patients in hospitals. I see them doing it. Like I've seen people doing it. But yeah, I mean, so Wonderland Alice, I wish they would put Traveling Mary into evidence. Me too. How come we didn't get a picture of the Traveling Mary? Yeah, and I think anyone can bring it. I think that's true. You just have to, you have to be a Catholic and know a priest and ask for it. And it depends, and usually Eucharistic ministers can take communion to hospitals and shut-ins. That's true. So I don't know if it has to be just a Eucharistic minister. I don't know. I've never asked. My priest has brought me communion at my house before, but it was the priest that brought it. He didn't do the consecration at my house. It was already consecrated. He just came to administer it. But yeah, so it was though consecrated host is what she had. So they threw Jesus in a dumpster. Like I don't want to hear their excuses. They literally threw the body of our Lord in a dumpster, and it's so offensive. It's so offensive. The question is it more offensive than my meme? Absolutely. It's way more offensive than this meme. They totally threw Jesus in a dumpster. It was wrong. It was offensive. It was offensive to Catholics. They should be more culturally sensitive than that. And at least if they had to take the host out of her room, they should have given it to the priest at the hospital who has a tabernacle in the chapel that he could have stored the host in. Or if priests have to dispose of it, they know how to do that the proper way or whatever. But you give it to a priest. Like you don't throw it in a dumpster. And that's what they did. Because that's called desecration. Desecration of a host.
Thank you.
Did I intentionally pick a male figure? What do you think? What do you think? It was the only it was the only body I could find that looked like hers. Come on, I'm not wrong. Am I wrong though? I wish I could have found someone that had a white belt on.
Yeah.
Ah. Diane, yes, the chapels in the
Lindsay, can I
hospitals
have
are
you-
normally non-denominational, except we found out in this particular hospital, they have a Catholic chapel that has a tabernacle. We found that out a while ago because Kathy Beatty took her to the chapel there, and there was some talk of the tabernacle, and I think that's why, because her lawyers know, like,
Fix that. Thank you.
Can we approach her?
Sure.
All right. Oh, she was smiling at her attorneys. That's nice. She likes them. Flux, I don't understand how they were able to keep the priest out either. Flux, did you see my meme? Did you see my Jesus in the dumpster meme? I'm very proud of this. I worked on it very hard. Appreciate it. This is quite a long sidebar. Can we move it along here? Okay, here's the doctor that I liked. We will skip through
The
his...
strategies used to improve on the patient's function.
Approximately how many times have you involved anesthesiology in the treatment of a pediatric CRPS patient at the Rehab Institute of Chicago?
In that time period?
Ever?
Yeah. Maybe directly handful of times, 5, 6.
In those handful of times, do you ever recall any of those anesthesiologists using ketamine to treat complex regional pain syndrome in a pediatric patient?
No.
So I think it's fair to say, doctor, that within pediatric circles, you do not consider ketamine to be a standard of care medication for the treatment of pediatric CRPS?
Correct.
Okay, and why is it that you have that opinion?
Hasn't borne or proven its efficacy. I'll leave that to the anesthesiologist to utilize based on their clinical acumen and whether or not that makes sense in their domain of treatment.
Did I hear you correctly that you do not refer patients
Legal
to
vices
providers that use ketamine to treat pediatric CRPS?
No, I did not say that. What the anesthesiologist that I work with at Lurie's, that's not in their treatment armamentarium. We've never had that conversation. So
okay, there. I guess the better way to ask the question is, to your knowledge, the anesthesiologist that you work with in terms of pediatric CRPS, to your knowledge, they don't use ketamine to treat pediatric CRPS?
That's correct.
Okay. Why don't you tell me a little bit about the Shirley Ryan Ability Lab, that was formerly known as Rehab Institute of Chicago? What type of services do you guys offer? Why does your organization exist? That type of thing.
So we're a freestanding rehabilitation hospital that provides service to pediatric patients.
All right, we don't need to hear all this. The background. He's a
line of
qualified
work,
doctor. He's a very qualified doctor. We can skip
When we
ahead.
asked her to do so,
Here we go.
obviously, whether it's axial spine or when we asked her to do so, to move anti-gravity motor function, right? So if you're ascribing a muscle grade on her own, at least 3/5 in the upper extremities.
No,
It
he's
was also
not,
noted on our
he's
assessment.
he's not a he's a physiatrist. Yeah, which is a term I had not heard before. A physiatrist.
And
Yeah.
then that she was able to move her lower extremities. However, when we asked her to do so, obviously there's screaming involved.
And then mobility dependent.
I wonder if Maya developed a fear of doctors before, like because of all the doctors that she had seen, and because every time she went to one, they hurt her with these exams, which is why it makes sense to me that she would run from them, and try to push herself into her mom's arms. The mom didn't hurt her, but the doctors were always hurting her with their exams, because they all have the same story, that she would scream and scream when they would try to examine her. And I think maybe she did not trust them, and that the fear of it would make the pain worse or something.
For all mobility
Physiatrist, is that how you say it? Not physiatrist? Physiatrist? Syllables matter, I guess.
I think we discussed that earlier. Is that your recognition that she required assistance with getting around?
Correct.
So we walked through a little bit of your physical examination here, review of systems, et cetera. And then my question was, did you, after your assessment of Maya Kowalski, come up with an impression and recommendation for steps moving forward?
Yes.
What were those?
Well, so the impression is written, is that this patient has a central sensitization problem.
Remember, this was way before she was at Johns Hopkins. This is when it first started happening, and they were looking for answers, and they went to Lurie Children's Hospital. I think he's at Lurie, right?
Process that exacerbates her pain and
In
pain
Chicago.
amplification with behaviors. The fellow had written a decline in function attributed to conversion disorder. She had signs of pain, catastrophizing, anxiety, kinesiophobia. So again, going back to the physical, that's the behavior scene. We know that mood and anxiety are a component of pain and pain management. And then kinesiophobia, so fear of movement because movement causes pain. We determined that she would benefit from physical and occupational therapy, the psychological components, desensitization, and again, cognitive behavioral therapy. So basically said, look, we've been asked and tasked to consult on this patient and are recommending that, a chronic pain program a la ours may help this patient in her functional recovery.
You pointed out the reference to conversion disorder. Do you see that in the impression recommendation?
I do.
What is being described there by use of the term conversion disorder?
So that's an
Okay,
older term and certainly used back. Sorry.
My apologies. Go ahead, Doc.
So that's a a term that is a little more antiquated in DSM-5 and clearly moved to something we attribute to or describe, as functional neurologic disorder or functional symptom FNSD, so functional neurologic symptom disorder. But it's basically a collection of disorders that have a basis in organic, pain pathology with significant overlay of anxiety, mood, and psychiatric. So it's, and the old term of conversion is what is converting?
This
You're
is
getting
interesting.
Psychiatric mediated.
Right. This is the part of the
etiology
testimony that I thought was so interesting.
to and a milieu with organic pathology. So we don't use that term anymore. And granted, we've become more eloquent in our description of patients.
So here's a guy who's saying all this having conversion therapy in her files doesn't even they don't even use that term anymore. The doctors that are studying it. I don't know what this did for the defense. He doesn't support their narrative at all. He seems like a guy, like a doctor that I would totally take my kid to. Look at how he's interested. I can't with you guys and your comments about the stash. Okay, wait, I can't look at it right now because I'm trying to make a point and you're going to distract me. Stop it. It is a strange little chin thing though. Stop distracting me. He seems like a good doctor who's curious. This is the kind of doctor who seems like he did a thorough investigation of Maya's issues and did not come to the conclusion that she had CRPS, but he tried to find every other available answer and he seems really knowledgeable. And I don't know what this does for the defense. I really don't. This is an interesting conversation he has. Yeah, it's a soul patch. That's what it is.
And frankly, what I think is interesting here is, again, this patient presents with whole body pain, which really is more akin to an accurate diagnosis of what we call central sensitization. So knowing that the central nervous system, i.e. vis-a-vis, the brain, the prefrontal, frontal cortices, the amygdala, the brainstem, not only govern, but they manipulate inputs coming from the peripheral nervous system. And basically you're getting the sensitization or neurosignature of pain.
If this is if he's right, remember what Dr. Kirkpatrick said about ketamine? I know he doesn't remember her specifically, but he reviewed his files. Dr. Kirkpatrick said that they needed the ketamine to reset the brain because the brain is continually sending out pain signals and it goes into overdrive. What he's describing would benefit from a reset of the brain also. So if it was that and not CRPS, which I don't know, but I don't think so. Seems like she does with the lesions and everything. Then it would make sense that the ketamine would help her in that situation too. But notice how medically complex this is. Notice how he's trying to figure out, where is this pain coming from? How is that she's showing the centralized pain, and it's not regional, it's centralized, and it's coming from, and he's supposing it's coming from the brain. That's not that far off from Dr. Kirkpatrick's diagnosis, and it certainly isn't far off from the treatment. Now, he doesn't use ketamine treatment, so he's not familiar with that. They use a bunch of different things, but it just goes to show how complex this kid is. There's something wrong, and it can't just be psychological. There's some sort of neuropathic pain coming from the brain. And other doctors, and this guy never had concerns about Munchausen or child abuse. He was trying to figure out, what is this complex pain that she has? And it's amazing to me. You go to a good doctor, you get someone who tries to find out what's wrong with you. You go to a bad doctor, they try to have your mom arrested and take you away from your family. It's just shitty.
We treat patients from a cognitive behavioral standpoint. Many patients that now come in, and if you look at the literature from Kozlowska, might even say that patients who have fibromyalgia, CRPS, patients that have hypermobile spectrum disorder, all have some functional component. Again, that doesn't mean this is psychiatric and factitious, because that's a different whole ball of wax. Are you talking about malingering? Are you talking about Munchausen's? We're not doing that today.
We're not doing that today. Is that interesting? What does he mean by we're not doing that today? Does he mean today specifically in this deposition on this file? Or does he mean we've moved away from that because we know that's not the truth? We were misdiagnosing people by saying they had factitious disorder or Munchausen's, when really they have these complex pain syndromes that we didn't understand several years ago. What do you think he's saying?
I think the issue that we describe in a lot of the patients that we treat is that there is this process of central sensitization, that over time, with the exposure of chronic pain, the brain is changing that neurosignature it's receiving from the peripheral nervous system. And
that's what Dr. Kirkpatrick was saying. That her pain, that she was really rare in her CRPS because it was really rare because her pain was so exacerbated and none of the regular meds were touching it. Is it because of this? I think they need to get this doctor together with Kirkpatrick to figure out what the hell is going on. And it's not a big deal. It's like, really, it's not a crime to get a wrong diagnosis. It's not a crime if you're a doctor to diagnose somebody with something wrong, if your intentions are good and you're trying to get to the bottom of it, right? So Kirkpatrick would not be at fault if he diagnosed her with CRPS, but it was some other pain thing or a combination of things that they still don't know. And this doctor didn't get it wrong by not diagnosing her with CRPS. Because he's trying to come up with an answer for this. Like, look how smart this guy is. I love this doctor. I don't know what this does for the defense, because all it did was raise more questions for me about, well, okay, if she doesn't have CRPS, she still has something really bad, something they need to figure out. And it's funny how similar what he's saying, this thing that's getting Maya with the centralized pain, is to what Dr. Kirkpatrick was talking about with the brain being overwhelmed and needing a reset. Doesn't this sound very similar? I don't know how this person helps the defense. I don't. Rafe, how do you think this helps the defense?
Actually beginning to modulate it. So a patient like this presents with, diffuse pain that she clearly had hyperalgesia.
Listen to him use the words he's using. She clearly had hyperalgesia. She clearly had allodynia. To light, to touch. She clearly had these things. He did not doubt for a second she didn't have these things. He did not think her mother was abusive. He didn't think she was making it up. Yeah, this does not help them. Why did they call him?
She clearly had allodynia to light touch. You know,
This doesn't help here's why it doesn't help the defense's case. Their case is, well, you'll find out at the end of this that the judge doesn't even know what their case is, but their case is that she was either making it up, or her mother was exaggerating it, or her mother was making her sick. We're still not sure what the defense is going with. And she doesn't have CRPS, or maybe she does have it. They don't know. They have no argument. Jessica says the defense's argument is that regardless of the diagnosis, the treatment is the same, physical therapy and normal therapy. But no, this doctor actually points out in his testimony that there's all kinds of therapy out there. His hospital does one type, but there are other places and other doctors and specialists who do different types based on analgesics, or based on holistic healing, or based on biometric therapy. And so there isn't just one treatment. No, that's not true. And this guy proves it. So I don't know how he helps the defense.
is more akin to central sensitization. And you asked me earlier, you know, why isn't the CRPS? And well, couldn't a patient who has whole body pain be CRPS? And absolutely, you know, we've seen patients that have had more than one limb, and that isn't following the textbook. But my experience is pain patients don't follow the textbook. But it's just a continuum of the process, whether the pain is peripheral, right? And it's coming from one, you know, peripheral nerve through the nervous system, getting regulated through the autonomic nervous system. And now you have this upregulation of a signature, a la central sensitization. And so it's just the eloquence in which you use the terminology. You know, so we've moved away from conversion disorder. We don't describe it that way. We talk about functional neurologic disorders. These patients present with motor dysfunction. In this case, this patient, you know, may have difficulty walking or needs total dependence in mobility, although you can see that based on components in the exam, she demonstrates the ability to actively move an upper and lower extremity. We know that patients may present with other pseudo seizures. I've seen patients who've had altered speech. Those are all functional in origin. And the confluence of organic pathology with psychologic components of stressors, anxiety, mood, alteration, et cetera.
But it sounds like we've moved away from using the term conversion disorder in the most recent DSM-5. What about back in 2015, 2016? Was that term being used?
Yes.
Are you critical of anybody in this time frame, 2015, 2016, who uses the term conversion in their medical charting?
No.
And so we talked about your impression and recommendation here in some detail. And I think you said that your recommendation was to do the type of pain program that they could offer at Rehab Institute of Chicago. Did I hear you correctly?
That's correct. That was one of the options. And we also said, obviously, and again, I have no independent recollection of this patient, but clearly she lives out of state. And so, you know, one of the other thoughts was, you know, would she find something that would provide at least the nature of the way we treat our patients with pain, you know, something closer to home in Florida.
And so what, and I know we talked a little bit about the program in general, and some of this may seem repetitious to you, but can you describe the type of program that you were referring Maya Kowalski to in terms of the modalities of treatment that you thought were necessary back in 2015?
So these would be cognitively, behaviorally based. So the core of that is changing the way in which the patient perceives pain, has a relationship with pain, and that's through the cognitive component with the psychologist.
All right. This is the part where I think, is this really what they're doing for pain patients? Changing your relationship with pain? Are they teaching you to love the pain? Oh, I don't know about that. I don't biofeedback skills. I know I've heard about some biofeedback stuff that helps, but mindfulness, like I don't know, meditation, I guess, maybe. Yeah, just pretend you don't hurt. Yeah, it's kind of cruel. It's kind of cruel. Teach you to live with the pain. I mean, all these things he's suggesting, I think are good ideas. I think you should seek out a holistic approach to changing, you know, to helping your pain, but denying pain medication if you're not there yet, or you can't get there, or it doesn't work for you, is really cruel.
Using biofeedback skills, mindfulness, using strategies to start to change that conversation around pain, coupled then with the physical and occupational therapy modalities seen fit by the provider to optimize, you know, return in function while reducing, you know, pain perception. So we talk about it in, you know, in this case where she has evidence of pain to light touch, a desensitization process where you're actually trying to change that perception of what
That sounds excruciating. Desensitization process, so doing it over and over and over again. Oh no.
inputs are causing centrally that central sensitization process.
Any recommendations for any type of analgesic or pain medication?
Not at this visit.
And I think we talked about it, but your recommendations were for PT, OT, psychology, desensitization, and cognitive behavioral therapy?
Correct.
Okay. At a program such as Rehab Institute of Chicago or a similar facility that could provide that similar panoply of service.
I can't even imagine what it would be like to have a 9-year-old, 10-year-old, and I have a 9-year-old, to have him in that kind of pain all the time. I can't even imagine. I really can't. And then for people to be telling me to make him do physical therapy when he can't, put weight on his legs because the pain is excruciating. Like, I can't even imagine what that is like. I can't. It makes me want to cry just thinking about it, and living like that for a year. I mean, I don't particularly I don't think he's right necessarily about how to treat excruciating pain. I don't think you're going to get rid of that right away with meditation. I think it could help. But I think you probably have to get the flare under control first.
Services.
Correct.
And same question for Jennifer Richards. Who is that?
Yeah, so Jennifer Reichert, she was the clinical manager at our Center for Pain Management during this time period.
Okay. And Ms. Reichert was asked some questions about the program at Rehab Institute of Chicago for pediatric CRPS. Have you had a chance to review Ms. Reichert's responses to Beata Kowalski's questions about the program?
Yes.
How do you characterize Ms. Reichert's responses to Ms. Kowalski's questions?
It looks like there were a set of questions that Ms. Kowalski had about, if they're to participate in a program, specifically, what type of service do we offer? And she attempted to go through that process of answering those questions.
Based on your review, it appears if Reichert responded to these questions in an accurate fashion?
Yes.
It doesn't appear in the emails, but I did have a question about it. At the Rehab Institute of Chicago, do you have any experience with treating pediatric CRPS with the surgical implantation of an intrathecal clonidine pump?
No.
Do you recognize intrathecal clonidine pumps as a standard of care modality for the treatment of pediatric complex regional pain syndrome?
I don't.
In this time frame, January of 2017, if you were asked what type of meds or vitamins do you use for your CRPS patients, what would your answer have been?
We'll typically trial the gabapentinoids, so gabapentin, Lyrica.
Have you ever taken gabapentin? It makes you feel so drunk. It's so bad.
And trials using high dose vitamin C. And certainly have a discussion with patients and their tolerance for trialing meds. We'll certainly use tricyclic antidepressants to try to change the neuropathic signature. Potentially go deep into the antiepileptics. But that's probably about as far as we'll go. So really, treatment for me specifically is gabapentin, Lyrica.
What do those of you in pain feel about Lyrica for pain? I was watching the long crime chat when he said that, and people went crazy and said, that's ridiculous. Lyrica doesn't help for pain at all in any way. Oh.
Tricyclics, maybe, trialing some of the antiepileptics. And, certainly there's some debate whether vitamin C makes a difference.
What about ketamine?
No.
And why not?
Look, I don't have experience with it. That's not something that we certainly use. And I've certainly not had any patients that frankly have asked about ketamine.
See, this is not a bad answer. He only doesn't use it because he has no experience with it. He wasn't trained this way. It's not what they use at his clinic, and nobody's asked him for it. The answer is he doesn't know about what ketamine has been doing for people in pain. So I don't think this is a bad answer for the plaintiff.
So, if they do, I refer them to the adult colleagues down at Rush.
I've heard a lot throughout this.
Oh, so if they do ask for ketamine, he refers them to Rush because they use it there. So it's not that doctors don't use it. He just doesn't.
Case that the standard of care therapy for pediatric CRPS is PT, OT, and cognitive behavioral therapy. Is that a statement you would agree with or disagree with?
I treat a subset of these patients. I would not sit here today and tell you that I treat every kid that has contracted or developed CRPS. We have one philosophical viewpoint on how to treat patients with chronic pain, whether it's CRPS or central sensitization or whatever. And that's the way we treat them. I clearly realize we're in the minority. I'm part of a pain listserv. We're unique in that it's truly physiatric based with cognitive behavioral therapy at the core. Clearly, most practitioners of pediatric pain management are anesthesia based. So we're unique in that matter. I would not say that's our standard of care. I'm not going to speak for the field.
And based on your review of these emails, what was your understanding of the plan of action as of January 2017 as set forth in just in these emails?
I'm actually not sure.
I liked his answer for that, though, about how it's not our standard of care, but I'm not going to speak for the whole field. Because he knows that there's other treatments out there and other doctors doing other, what's the word I'm looking for? Why am I not thinking of the word? I hate it when I lose words. Other therapies. Thank you. He knows that there's other doctors out there. He's not bad talking ketamine at all.
It sounds like they were maybe interested in doing the program, and I'm not sure where it got left.
Fair enough. Do you ever recall being contacted by anybody from Johns Hopkins All Children's Hospital to discuss Maya Kowalski, her case, or really anything for that matter?
No, not at all.
Same question for Dr. Sally Smith. She's a pediatric child abuse physician. Do you recall if she ever contacted you?
No.
Okay, what is the Budapest criteria?
So it's a group, and Dr. Norm Harden, who was one of our mentors and colleagues here and director of pain management, provided a construct in which to provide clinicians which a way to better diagnose CRPS. And
All right, let's move forward to the cross because I don't think there's anything. I went past the part that I wanted to hear.
That's both a sensory and a motor. Adults. I have never had a pediatric patient tell me that.
And so some of the pains
in an extremity that are more akin to what we typically see in the traditional patient that presents with a CRPS diagnosis.
And plus the, like you said, the super sensitivity to touch.
Correct.
Allodynia. And then and that's kind of like a fear of being touched, is it not?
Well, the kinesiophobia is really the fear of movement or being touched. I mean, allodynia is, you lightly stroke a portion of the body and you're causing, excruciating pain, where traditionally that's not a painful stimulation.
But they think it might be, and so they overreact.
Sure.
And then of course the lesions eventually.
So
the lesions eventually.
I mean, in my experience, it's patients that have been made, the diagnosis has been made. They're coming with the lesions. They're coming in the cam boot. They're coming in with the altered mobility, as opposed to, seeing them.
I see. So you're not usually the one coming up with the diagnosis. You're the one treating it once it's been diagnosed. Fair enough.
Fair enough. I mean, we're a tertiary center. Chronic pain. These patients traditionally have seen other clinicians, whether the diagnosis is accurate or not. We've had plenty of patients where they state they have CRPS, and then we disagree and say, well, you're on a continuum of that neurologically, but you don't meet all the criteria. Or traditionally, they've seen, 2 or 3 orthopedists. They've been put in a cam boot, and they show up to us, and we're like, yeah, okay, you meet the criteria. Now let's treat you. Now you're asking about suicidal ideation and all these other issues that may be related to pain, but I did treat at some point, begrudgingly, some of the adults in our program just because of staffing. And we had patients that said, hey, I'm going to go home and kill myself. And we had them sent to the emergency room. We called 911 and said, I can't send you home safely.
Sure.
So that's interesting. So here's what good doctors do when people say to them, I'm feeling like I want to die and go to heaven. They put you on a psychiatric hold. Where have we heard this before and it didn't happen that way? Could it be J-Hatch?
You telling me that you have a plan and that you have a means, and those were the adults. I've never had a pediatric patient tell me that.
And so some of the pains with, say, the CRPS, Are they a constant or can they go away and come back, reoccur?
It's very interesting because I have a cohort of a couple girls that, you know, by textbook would be given that definition, but then their symptoms and their signs and symptoms veer from textbook, and they have symptomatic flares and they're doing well with gabapentin. And, you know, whether it's truly CRPS at this point, or do we change the diagnosis to this concept of central sensitization? They clearly, their bodies haven't read the textbook, you know, but yet we're still treating them as if they had allodynia periodically and hyperalgesia. And yeah, it's a very small subset.
Hey, doctor, a couple follow-ups. This is David Hughes again, counsel for Johns Hopkins All Children's Hospital. Can you please list your board certifications?
So I'm board certified when we complete PM&R resident.
Are they did they realize that this wasn't going well for them? So now they're going to go down the board certification track. Okay.
And basically, you know, so
we don't care about that. We don't care about board certification.
There was reference made to hyperbaric.
No. They're still on this
Then certainly
hyperbaric chamber
see.
baloney. All right, listen. I don't think there's anything more in there that's really all that, you know, exciting. I did not watch Dr. Elliott's entire testimony, and I kind of don't want to right now. I don't think we have time for it, unless you guys think that it was something, you know, I have to see. Maybe I'll watch it later on my own. What I do want to watch, if we can, is some of the end when they let the jury go, because there's just stuff coming up at the end of this.
Yes.
Yes.
What's
That
next?
is interesting.
I think we're up to 3090. I don't know if they have an objection. Do you want to see the video, Jeff?
It's a horseback riding on January 16th of 2017. So how long is it?
Got it pulled up here right now. It's
Horse welfare, thanks for the super chat. The terminology that this doctor uses is the terminology utilized in veterinary medicine, central sensitization, hyperalgesia. It's not psychological. Right. I picked up on that, and I thought that was very interesting. What the heck? Why is
Now he's got his ears for.
what the heck?
So perhaps someone filmed it in slow motion.
Perhaps how it got to us, Judge.
Rosalind, thank you for the super chat. I have
Miss
scleroderma.
Lawrence, are you making
Traditional
this argument?
pain meds are crap. Muscle relaxers, wearable TENS
Court will
units, and stem
receive,
cell therapy are the only things that touch my
3090.
pain and still allow me to function. Well, I'm glad you've gotten some relief.
No objection.
Court receives 3094.
3095, another video. Another puppy video. Keep going.
You know what Kyle does? He just lays down and then she comes and jumps down.
The dog is cute.
Come on, please. It's okay. It's okay. It's okay. It's okay. No! No!
Our objection would be it's 2 days from the previous video. It's starting to
Yeah,
get
why is it sped up?
Much more movement.
Why? Oh, it's sped up because I have mine sped up. That's why.
It does. I'll receive 3095. What's next?
3096.
Go.
Yeah, they're trying to suggest that because she could walk around on her knees or move around and move her legs, that she doesn't have, that she's faking or something. It's psychological. But I don't see her walking. I don't see her putting her weight on her feet, which has always been an issue. I'll try and slow this back down to normal and see what it looks like. It looks like they did it in slow motion. So this one was taken in slow motion, I guess. So now we have to speed it up to get through it. What the heck are they doing?
Let me see 3097 as well.
We'll just do 3097.
If I understand Maya correctly, though, she had good days and bad days. She could do stuff. When is
3097's
this?
in.
Is there a date on this?
And did we do 3120?
10/2017,
And then we did a whole bunch of 3121s.
October 20th, 2017.
Okay, I believe
October 20th, 2017. When did her mother die? January 7th of what year?
the 3120 was withdrawn as well as 3096.
Yes, sir. 3124 has already been admitted.
So how could that have been October of the same year? Wasn't she in the hospital? Well, that video was dated October of 2017, but she was in the hospital for 3 months before her mother died. She was in the hospital right up until January. I think she was released a week after her mother died. And she was in the hospital for 3 months before that. What's 3 months before January? She would have been in the hospital in October. So was that before the flare-up that sent her to the hospital? Oh, what? The hospital couldn't have been 2016. She was in the hospital when her mother died. Uh-huh. Yeah, I don't understand this. Oh, her mother, you're saying she was in the hospital in 2016. So her mother died in 2016. Okay, so a year later, she's getting better. So we know she can walk now, so I would imagine that she was getting better.
2 has been admitted.
Ugh.
3135 dash.
Yes, sorry, dash 2 has been admitted. So we have 3137.
Can you
withdraw this, Judge?
Okay, so 3137 is withdrawn.
Yes. 3138 has 9 photos.
And are we going to see all of them?
Yes.
Relevance 403 says these are drawn from People Magazine article, and here clearly the release of the film Take Care of Maya. So unless we're going to explore the context and the reason for these photographs, we think it's irrelevant, prejudicial.
Do I need to respond, Judge?
Yes.
Judge, these are photographs taken in 2023, so they're obviously relevant. They're also given the description by the plaintiffs as to what Maya does and doesn't do. I think it's relevant that she was in New York at the red carpet. The jury all knows about the Take Care of Maya video. We all asked them about it for days, so it's not going to open a door to anything. We all asked them about it, so it's not like we're trying to keep out the fact that that exists.
Well,
They also had one showing her exercising.
can I see the series again?
These are 2023 photos. Not 2015.
What is the relevance of this? They can see her in the courtroom. They can watch her walk in and out of the courtroom. They don't need to show her personal photos and stuff.
Yeah.
Imagine having a defense team using your personal photographs with your boyfriend and stuff against you.
Judge, if we want to pare them down, we can do
Well, we're
that.
going to pare them down, yeah.
Okay, all right.
And the ones we want.
Okay. Yeah.
So, anything else, Mr. Whitney?
I'm curious to see.
Yeah, People Magazine staged those photos. I mean, they did a photo shoot. It's not like those were taken. It's not like they were taken, when no one was looking. It's a photo shoot.
Which ones they want to whittle them down to, and then I'm going to have further objections.
Well, this is not yet a ruling, but I think you're going to have to choose 3 photos, 1 or 2, 4 or 5 or 7 or 9, I think. So why don't you look at those?
1, 2, I'm sorry, 1, 2,
1 or
6.
2.
One or two?
One or two. You're gonna get 3 photos.
Okay. Yeah, we'll take 2.
Take 2. So you're gonna, okay, and then 4 and 5.
We're only getting 3 photos?
Well, one was Maya individually. This is with family. They're both are laughing and smiling. So,
We'll take number 5.
and then the other one is the person I'm assuming is the boyfriend, 7 or 9.
Well, there was one of her on the exercise machine, Judge.
That looks staged.
Okay, all right, we'll take 9.
We object to 9, the Tribeca backdrop. If they need a photograph of her in a relationship, that has maybe become relevant. 7 would suffice. 9 is going to introduce all sorts of issues. Although they're aware of the existence of the film, we're going to want to explore what
She looks like a starlet in that picture, doesn't she? Love the hairstyle.
arrangements were made for her in New York City. How come this was a comfortable experience rather than what she testified to, being out and about and seeing Kathy Beatty or people that look like her. Well, also, if these folks are coming in, want to be able to explore that all of them that are going to be admitted were staged by People Magazine, and they're not truly candid shots. It's a People Magazine photographer.
Judge, this is a valid photo, number 9. That they already talked about the fact they went up there for the Tribeca Film Festival. That came out, I think it was Mr. Kowalski's testimony. It's not opening any door. The jury knows about it, and it is a different view than has been presented with regard to Maya Kowalski's life that she has presented in front of this jury, where she's afraid to go out of the house. She's afraid to do anything. This is a different view, and the defense has the right to put this perspective in front of the jury. So between 7 and 9, we would choose 9.
Well, like I said, it wasn't a rule. To me, the Tribeca Film Festival it's a collateral issue to this lawsuit. And I get what you're saying about she's out and about, but the context is a little bit different. It would seem that 7 would also suffice to help tell that story. And I think I would allow you to do 7, but I've got concerns about going down the road of pictures of the Tribeca Film Festival.
No communion,
Just
no
like I
cake,
didn't want,
no
they wanted to put
smiling.
in the movie, and I said no.
Well, that's, to me, putting in the movie is a whole different kettle of fish. You're talking about.
You don't think I'm getting that
you're saying-
request if we start talking about putting in 9?
Judge, that's
Well, if you don't want the movie coming in, maybe you shouldn't do the movie premiere.
in all seriousness, that's a completely different analysis. This is one photo. They already know they went. If we can.
Grant, I disagree with you. They don't have to allow them all in. The judge has a point, and so does the plaintiff. If they allow in a photograph showing her at a Tribeca Film Festival, it opens up questions to the documentary itself
Block out Tribeca
and the trip.
Film Festival if you want. But it's a completely different view of Maya Kowalski's life that they have failed to present to this jury that the defense believes they have the right to do.
I will receive in 3138 number 2, 5, and 7, and it'll exclude the others.
Can we see 8? Hang on.
You can put up 8.
She can say it's stage, Judge, but I think we should be allowed to put in 8.
She told them she exercises. She gets up every day at 4 a.m. And she told them she has to exercise to keep herself mobile and moving and to get stronger to stay out of pain. I don't think she would object to this photo being in. It's stupid.
2, 5, and 7. What's next?
All right. 3139. This is an email from Dr. Wassenaar to Beata.
September 9th, 2015. Okay.
Yes, September 9th, 2015.
Something's wrong with his email. He doesn't have a recipient.
Yeah, I was just going to say, who is this to? Why does it say from Beata, but it's got Dr. John Wassenaar's name at the bottom? Something's wrong with this.
It says from Dr. John Wassenaar.
But the from at top says from Beata Kowalski. It doesn't have a 2.
Yep.
So it's not, I don't know what this is, but it doesn't seem to be a valid email. I've never
Nope.
seen an email without a 2 address.
Nope, not valid. Good catch.
Yeah, Judge, we'll withdraw it.
Oh, did they just try to put a fraudulent email in the record?
3140. It's 4 pages.
Can you put the first 2 pages up for me, please?
It's from it's October 30th, 20.
What is this? From Beata to Anthony somebody, MD. What's the date? October 20th, 2015. I spoke with Ann NP at Wilsey's office, giving me the go-round. I told her to tell Dr. Wilsey that Maya is sicker each day, waiting for Dr. Wilsey to call Dr. Kirkpatrick. I told her I need to talk with Wilsey ASAP, or he needs to call you ASAP. Oh, this is to Dr. Kirkpatrick. It's been since Tuesday when he saw Maya in the office, and to this day, he didn't order CMP or any hydration. I'm getting so PO'd with his staff and him at this time. His NP told me that Wilsey is uncomfortable ordering IV fluid. What kind of doc is this, I'm wondering? That is strange. If she's dehydrated. I think I'm going to have a stroke soon. I can't stand it. How medical TX, what is TX, is being handled in Florida. Thank you for your help. He says, I will make Tiffany available to take calls from me over the weekend. Maya may need to go to the nearest ER before Monday or Wednesday and have the ER doc call Dr. Wilsey and me. Generally, weekend is a bad time to receive care and treatment. I received a call from the assistant from Dr. Wilsey's office as I was boarding a plane. He told me that it was not an emergency that I speak to him. Okay.
15 email from Fiona Kowalski to Dr. Kirkpatrick.
Well, I guess because it's going backwards. Let me see 3 and 4 first, because so I can read it in.
I think you're right.
This one is from Beata to Kirkpatrick. No surprise to anyone, I bet. No callback from Wilsey's office. I guess I'm done with him. I started Maya's PIV and gave her 500 milliliters of NS. Trying to make it through weekend without going to ER. We'll keep you posted. Okay. What's NS, I wonder? Oh, normal saline. Okay. So for hydration is what you're saying. She gave her an IV.
Can I see pages 1 and 2, please? The timing. So I suspect what probably happened is she took an older email and then responded.
Right.
Yeah, that must have been what had happened.
Position is it's hearsay without exception.
Seems like she's trying to get
Well,
medical care and treatment.
Perhaps some statements from Deanna Kowalski could be for purposes of medical treatment, but certainly not all of them. She's relaying what a nurse practitioner with Dr. Wilsey's office allegedly told her. That's hearsay without exception. Dr. Kirkpatrick's communications are hearsay without exception. The exception for medical treatment is as to statements made by the patient, not emails between doctor and patient.
Because it also goes to state of mind. You've got her saying, I think I'm going to have a stroke soon. I can't
Well-
say it. How medical treatment is being handled in Florida. Just beyond the state of mind.
I don't know how
Is
this helps
the
the defense.
True objection here, the statement, his NP told me that Wilsey is uncomfortable ordering IV fluid. Is that what we're talking about?
That's one of them, Your Honor.
What else?
Yeah, that's what they want.
Within Deanna Kowalski's first
They want to show that she administered IV treatments at
on the top
home.
of page 1.
But if this is all they have, her saying that she administered saline, that's not ketamine.
I mean, a lot of this is, if it's statements for purposes of medical treatment, it would be made directly to the physician. So this is Deanna Kowalski.
All right, let's skip to what the judge decided.
1 through 4 of Exhibit 3140. So the whole thing will come in.
The whole thing is coming in.
3140, pages 1 through 4. Did I miss? Because 3140 is only 4 pages, correct?
She said she
That
administered
exhibit's
it,
only 4
Grant.
pages.
That's correct.
All
Go
right.
3 and 4 first, because it might.
Oh, what's this?
bottom up.
Something else? Quest Diagnostics. That's a testing facility.
Yeah, I'm not sure about the reporters. Can we look at 1 and 2?
Well, hold on a second. Before we go off, let me see what this is. The dates.
This looks like a.
November.
This is not interesting to me. I don't care about this. It's just some test. More emails with Dr.
And you can see
Kirkpatrick.
on, number 1, he specifically, Dr. Kirkpatrick says to file his email and patient's chart.
This is not the interesting part. We got to skip forward to the interesting part. I got to go soon. I've been streaming too long.
We'll withdraw this, Judge.
Flights to Mexico. Medical notes. I want to get to the part where the judge starts reaming the defense.
Coordinated with Dr. Kirkpatrick for all of these.
hearsay without occasion, not involving the Kowalski family, behind the scenes between a pharmacist and a physician.
Judge, you can see that on one of the.
I want to get
Case
to
law we
the other
reviewed are not
stuff.
admissible as party admissions.
So this is from Beata to, oh, she sent emails to herself. Oh, this is the thing people were talking about, that she wrote stuff to herself from Maya's point of view. They were calling it fan fiction. I don't know what the big deal is about that. What's the big deal about an email to herself? Should we hear this argument?
I don't know what he's referring to there, Judge. That doesn't make sense to me. She's clearly
It's a statement being offered against the party.
Yes.
It's the party's own statement.
Yes.
It would seem that there is an exception to the hearsay that would apply. Anything else, Mr. Whitney? That would party. Yes. The party's own statement.
Yes.
I'm just reading through this quickly.
It would seem that there is an exception to the hearsay that would apply. Anything else, Mr. Whitney?
Under Huff versus White Motor Corp.
Is that strange? I don't know, because I've never had a really ill child. And if she's blogging and doing stuff like that, is she doing it from her perspective? I mean, I don't know. People are weird. I don't know. If you really think that your kid is sick and you're trying to get help and let people know about it, could be more like journaling. I mean, it is a little strange writing as your kid. Yeah, baby books is kind of similar. Could be a coping method. I don't know. I mean, I don't think it's evidence of child abuse. I'll tell you that much. She could be writing it for Maya to read in the future. That's true. I don't know. I don't know, but I don't think it's evidence of child abuse. I think it's evidence that her mother is really consumed with this terrible thing that's happening to her daughter. She can't think about anything else because they haven't got any answers and her daughter isn't any better. And I don't think that's a sign of abuse. Is she, yeah, she had stress too. Maybe what did she do with it? Was she writing it as a form of creative writing or journaling for her own record? People have social media accounts for their cats writing from their perspective, and I wouldn't accuse them of MVP. That's a very good point. She did post it on the blog. Is that where it is, on the blog? Okay, well, yeah, people blog in their dogs' voices. I don't think it's evidence of abuse. I think it might be strange or a little cringe, but I don't think it's evidence of abuse.
At 609 Federal 2nd 286, and admittedly, it's a rare situation, but I'm in Earhart's. Statement of decedent is not admissible against the estate as a statement of a party opponent.
We're not admitting this against the estate, Judge. We're admitting this against her.
Against who? Beata?
Well,
She's dead.
Site? It sounded like a federal case.
It is, Your Honor.
609?
609 Federal 2nd 286.
All right, Judge, come on, look it up quickly. Look up the case law. I don't have time for this. I'm getting tired. I want to go watch TV.
Mentally confident when he made the statement, it should have been admitted under the so-called residual exception to the hearsay rule.
I don't believe Florida has the residual exception to the hearsay rule. So I think that piece is applicable.
What? I don't see how this case is. PR was Helen Huff, the wife, the declarant, defendant offered in trial court excluded the testimony of Melvin Miles.
Oh, he
Well,
takes it under advisement? Okay, fine. Then
Tough
we're
gave the
skipping it. I don't want to listen to him argue about that. If he takes it under advisement, then we're moving along. There is more coming up right now that I want.
Experts are correct that this is completely.
Yeah, here it is. This is what I wanted to see.
Was completely normal standard of care, and the people.
Here we go. Here we go.
There was evidence that was presented to the jury about
Plaintiffs have set up.
Bringle, B-R-E-N-G-L-E.
Yes,
All right.
2/3 of the way down, it says admissions against interest made by a person since deceased may be introduced against a person claiming under and succession to the deceased.
All right, we're still on that last one.
185 Southern. Okay, so I conclude that there is an exception to the hearsay rule that would apply for exhibit.
Oh, so he lets it in.
Understand, I want to put one more thing on the record, which is that we'd object on relevance in 403 because this email is not relevant to our medical malpractice claim. There's no claim back against the Fabre against Dr. Cantu. The hospital had no knowledge of this when they did what they did. So it's not relevant to anything that happened inside that hospital for 3.5 months.
Your Honor, they've put central to this case the idea that the hospital had no basis to conclude that there was medical child abuse, that there's no basis for the transfer orders questioning this treatment. It's absolutely false that the hospital did not know about this because part of what the hospital had and saw in its records were specifically treatments of this. Mrs. Polsky was in the ER demanding that, might be put into a ketamine coma. The plaintiffs have set up in front of this jury arguments that, it wasn't really that high risk, it wasn't that big of a deal. This details, frankly, without using hyperbole, the horror of what went on with Maya's coma. So it's highly relevant issues that plaintiff is introducing.
Well, let's go back to the 30,000 foot view. There's evidence before this jury that there was a 50-50 chance of death that was told to the family, including Maya. We had Dr. Cantu said, well, we say that, but he doesn't believe that to be inaccurate. This tells us what happened or could be seen by the jury as what happened during day one of the medical coma. There was evidence that was presented to the jury about the coma. There was videos. There was discussion about some lab work. I think there was some discussion that there was some difficulty during the procedure.
Yes,
So,
recognizing all of that, Your Honor. The only thing that the hospital had knowledge of at the time is what was in their records. And that was a couple of lab results from Dr. Cantu. In order for this to be relevant, there would have to be either a Fabre claim against Dr. Cantu, of which there's no basis for that. They don't have an expert to even opine on causation in that regard. And nothing that the hospital did can be explained by what's contained in this email because they did not know of it until 3 years into this litigation. So what they did in the fall of 2016 is unrelated to an email that's produced to them in 2019, 2020.
what are we doing about Fabre? Because Mr. Altenberg suggested that there was going to be no Fabre or potentially no Fabre request.
That's likely the way this is going, but that's not what we're introducing.
So help me understand what you introduced.
Again, they've represented to this jury that all of the medical treatment that the Kowalski sought was completely normal standard of care, and the people at All Children's, not RSD specialists, they did not understand that what was being requested here was just everyday thing. And of course, there was, I had to push for a 50-50 admission because people were downplaying what this shows as a play-by-play, because the records we requested from Dr. Cantu were either destroyed or lost, or whatever. It shows a couple things. It shows the horror that went on to Maya Kowalski while she was in this coma. It shows that our experts are correct, that this is completely unnecessary and dangerous risk, which just goes directly to the heart of our defense team. It also shows Maya Kowalski writing as if she's Maya, and the plaintiffs have made a big deal about the lack of basis of any Munchausen by proxy diagnoses. This is in the file of Sally Smith as part of her WordPress blogs. It's also, I believe, referenced in Dr. Lewis's report. This goes right to the heart of everything that we're defending against, as the plaintiffs are putting on a case of we were just seeking conventional treatments that you just weren't used to, and the ketamine coma was no big deal. We can't defend our case if we can't show exactly what the auto was writing in real time. It's an admission by a party to the point that's relevant. In order for us to defend.
Well, let's walk through the counts. Doesn't go to false imprisonment.
This is it.
Doesn't go to battery.
Well, it can go to, well, anyway, it would only go to false imprisonment to the extent that it corroborates what our doctors were trying to tell Beata and Jack Kowalski with, look, we'd like to talk to you about staying here because the treatments that you want, there's no question in the record that they were coming into the ER saying, we want to put Maya in a ketamine coma. And our doctors, as they testified, the nurses were shocked by this. And this corroborates what our doctors and our nurses were saying, which was this treatment that you're asking for is insane. So let's sit down, let's talk, let's have a real conversation, let's have you reach the treatment plan. So this email corroborates exactly why our doctors had this on. So it can go to that.
Not sure I agree with the stretch there, but okay. Doesn't go to battery.
Does not go to battery.
I know that DV is under advisement relative to Maya for negligent infliction of emotional distress, but doesn't seem to go there, right? How about medical malpractice?
Yes, it definitely goes to medical malpractice.
Well, let me ask this, because medical malpractice focuses on the acts or omissions that occurred at Johns Hopkins All Children's Hospital.
And whether we were right and whether we were, because their whole claim, but their whole basis, which we think obviously we disagree, but the whole claim is you stopped the standard of care treatment that Maya Kowalski needed. And as a result of this, now Maya Kowalski somehow, because you wouldn't give her the proper treatment, Maya Kowalski somehow is somehow worse off with relapses and remissions going into the future in the 20, 30, 50, $80 million care plan.
Mustang McCracken, I have to say, you said, do they have any professional willing to diagnose Munchausen's? If not, why are they allowed to continue to try and push this crap? No, they don't. And I have never, in all the cases that I have covered that is a Munchausen case, there has never been a professional who actually diagnosed it. It has always only been an accusation, no diagnosis. And when the person accused goes for their psychological exam, they always come out with a clean bill of health. I've never seen a legit diagnosis, and they don't have one either in this case.
Our point is, and as we've said over and over again, the treatment for CRPS is physical therapy, occupational therapy, cognitive behavioral therapy, and time. And you don't do ketamine drips and ketamine infusions at 23 milligrams per kilogram per hour. You don't go for ketamine pills. You don't go for intrathecal pain pumps, which is what they're saying that we prevented them from doing. And this email is the best evidence, and frankly, the only evidence that we have to show exactly why we are the standard of care, and this is risky and dangerous. It comes from God's own words.
But
and we didn't aggravate. They're going to argue in the jury instructions that we aggravated her CRPS by not giving her this.
But it's true, the Johns Hopkins All Children's Hospital did not have access to this email. I'm presuming what's going to follow.
Not true. We had access to it because it was part of Sally Smith's file. Indeed, the WordPress blogs are part of her file.
Well, so now we're adopting Sally Smith as our agent for purposes of treatment and standard of care opinions at the hospital, if we're going there.
Okay,
Sorry.
Go ahead.
None of our experts have testified, none of our standard of care experts testified that the breach of the standard of care was failure to give a ketamine coma. What the Vodovoz heard from Dr. Vodovoz, what she came in asking for was 1,500 milligrams of ketamine, like Dr. Hannah was giving the United States. This reference to 23 milligrams per kilogram per hour is not a reference to this. It's a reference to Dr. Hannah's treatment 2 days before her admission.
Why don't I see, because I'm assuming what I do on day one is going to be what I do on the balance. So let me look at the next few, and then I'll probably take it under advisement and let you know on Monday. But 3145, please.
Same issue, Your Honor.
Okay, let me just read real quick.
Aw, Night Owl, so sweet. Night Owl says, you're the best law channel on YouTube, Megan. So glad I found you. Much love and blessings. Well, I'm a journalist channel, not really a law channel, but I do like watching the trials. But thank you. Appreciate that. I'm law adjacent. That's how I describe myself. Law tube adjacent.
Anything that we haven't already said with respect to day one with this day two email?
Well, again, I also want to point out that Diana Kowalski is writing as if she's Maya, and they have squarely put in front of this jury that we would never agree to these transfer codes because one of the diagnoses is on there, and Dr. Newberger was read into the record saying that diagnosis was medical malpractice. They're going to argue this. This goes directly to the suspicion of Munchausen by proxy as a mother writing as her daughter. So it also goes to that in addition to the prior statements that we used to.
Your Honor, it cannot go to a suspicion of Munchausen by proxy in 2016, October 7th through the 20th of 2016, when it was not in their possession. It wasn't known to them. What she wrote with respect to thank you, God, and appreciate it, Jesus, has nothing to do with a Munchausen by proxy inside that hospital in 2016, because they didn't have it.
We did have it.
Well, you didn't have it for the false imprisonment time period at issue.
But we had it during the time that we were trying to transfer the child.
That before October 17th.
You didn't diagnose it.
When the transfer times were trying to go to the Moors in November, and the plaintiffs keep saying,
Time out. You said it goes to false imprisonment. You got the picture taking and you got the EEG. So the only time the false imprisonment is that first week. So that's the point I think Mr. Whitney was making, that it wasn't available for false imprisonment. It might go to your med-mal, but that's probably the only place that arguably it might go to. So all I want to do at this point is let me see the rest of them. If there's anything unique about the next series, let me know, but let's not have a continued re-argument, because I'm not.
I understand. You're moving for a mistrial when you got additional time and you can call the same witnesses to address whatever issues. Is that what you're saying?
Yes, Your Honor, because we don't. Okay.
Can we go to exhibits, please?
That a regular thing. I just uploaded that to StreamYard. I'm keeping that. I'm keeping that. He actually didn't deny it, but he said he would take it under advisement. But it doesn't look good. So it doesn't look good for Shapiro. The judge is leaning away from him. I'm keeping that video. Thug judge. I called it Thug Judge. Denied. All right, what is this? What are we looking at? Another email from herself to herself. Oh, Lord. Can't even send yourself emails without it ending up in court. This is what makes me feel creepy about this, is that this is a dead woman's thoughts, you know? Like, there's something really just bad about it.
Let's go.
I mean, this is a pretty terrible thing to say. I have a very high tolerance for drugs. If I was a horse, I would be comatose or dead already. Oh my. Jeez. I mean, is that just her attempt at a bad joke? It's unwise. Write and text like it's going to get read in court, because one day it might be.
Go to the next one, which is 3147.
Which has just now made me feel extremely nervous about Nick's phone getting downloaded. Oh, my text messages to Nick would be a hilarious read. Trust me. At least if they ended up in court, we would all be laughing. Oh, yeah, she may have been severely depressed. I mean, obviously she was I think we can safely say she was severely depressed. I think this is unfair. I think it's prejudicial a lot. I mean, because you don't know why she was writing this. Did she publish all of these on the WordPress, or are some of these on like just her private email? Because I think that makes a difference. If she published it publicly, then I think I would feel differently about it. But if it wasn't public, the Mexican priest visited me again today, and he gave me the holy oils again. He prayed with my mommy for a long time over my body, and it appears that everything just got better after he touched my head with the special oil. Hey, don't knock it. My priest came and prayed for my daughter when she was losing her hair because over COVID for anxiety. Like, she just had really bad anxiety. And he came and anointed her and prayed for her, and her hair grew back. So I don't want to hear anybody saying anything bad about the holy oils, because sometimes they work. Just saying. They worked for us. It was kind of a miracle. This one isn't so bad.
And is 3148 the last one in the series?
I believe so.
And it looks like that's 2 pages.
Yes.
Can you just put up both pages, or make it too small? Let's see. Yeah, just go back to just the one page, please.
I would add one more basis when you're done.
The Ricada Fox files are really just me sending Nick pictures of really obese people at Walmart. And then his responses. I'm fat baiting him. That's mostly my text with Nick. Fat baiting. Fat shame baiting.
The other basis.
It goes to show that
Whenever I need a laugh,
reasons
I
why cutting is not-
just take pictures of super obese people at Walmart and send them to Nick. It's true. You can ask him.
the fact that drug, it's showing, this specific one is showing that Maya is not recovering from these ketamine doses.
That's
We
so
refuse to
mean.
submit to Your Honor just because we
But I never put their faces in the pictures.
believe we did can show that my
You've
clients are
seen
similar
people
to
at
knowledge of
Walmart.
this. But even if we didn't, this would be no different than our doctors. Take a simple case. Someone comes into the emergency room and says, I have a broken arm, and we read the x-ray report as negative, and they go home and then they sue us for failing to diagnose the broken arm. Couldn't we say there's an x-ray from 2 days before the admission that is also negative, it doesn't show a broken arm, and sure, we didn't know about that, but it corroborates your diagnosis is the same as our diagnosis. All of this goes to corroborate exactly why, in defense of a medical malpractice claim, my clients were correct. They were correct to be suspicious of ketamine. They were correct to be scared of having Maya undergo these treatments, and it completely contradicts the narrative that the plaintiffs have put in front of the jury.
I'm sorry, what was the end?
Sorry, it completely contradicts the narrative the plaintiffs have put in front of the jury, and it's especially important because, again, the plaintiffs are saying that we aggravated a condition by not providing this treatment.
Anything else, Mr. Whitney?
Their experts are free to come in and testify about standard of care. They don't need this to do so. This, again, was not in their possession, and I'm not sure how it helps them because the photographic and video evidence is that Maya Kowalski and their records, that Maya Kowalski did progressively better and better following this.
JKD Buck, your priest can regrow hair. That judge would probably be interested in meeting your priest. Turn that hair island into a hair continent. It's so funny. But yes, that really happened. She has a thick, full head of
We
hair
also
now.
challenged the idea that they had possession of this information at any time during the relevant 3.5-month mission, unless they're adopting Sally Smith as their agent.
I'm going to take 3144, sorry, 3144, 3145, 3146, 3147, and 3148 under advisement. What's next?
This is so true, Grant. People of Wegmans would be boring. Upper class white women shopping. Yes, the people of Walmart are way more entertaining. Where else are you going to see trannies in fishnets? This is something I really did see at a Walmart once.
Do you want any additional information for us, Judge, or are you just gonna?
No, well, let me ask this, and this is bleeding over into a different concept.
The grossest thing I ever saw at a Walmart was a guy in bike shorts bending over to get some tinfoil, and he had a hole where his a hole in his shorts, and I swear to God, I think his like one ball was hanging out. It was very bad. My cousin and I were dying laughing. She saw this and pointed it out. Why would you wear bike shorts to go to the Walmart, really?
But since we somewhat referenced it earlier, and it goes to fabric. Because ultimately, well, I mean, if the defense doesn't seek fabric, then there's not an issue. But again, the medical malpractice goes to the acts or omissions at the hospital. So following up what Mr. Shapiro was just talking about, let's say you have a car crash, and maybe there's somebody that's negligent in that. It might be helpful to know, hey, there was a crash and what generally happened. But when a person that was a victim of negligence in the car crash goes to the hospital for care and then the hospital malpractices, you don't really go back and apportion the first crash. And so it would seem like from an evidentiary standpoint, it might be helpful to know what happened, but then you don't try to figure out, well, driver 1 was 18% at fault while driver 2 was 83% at fault, because that wouldn't really matter for the malpractices.
I understand the court saying that typically who caused the car crash doesn't come into the doctor's malpractice at your point when you got into the ER. Yeah, but again, given this is a very unusual case, and given the scenario that the jury's presented, this type of evidence specifically goes to rebut their position that our failure to give her ketamine, which is their position, and we stopped the ketamine protocol, aggravated her TRPS to the tune of a permanent aggravation.
But let's be specific. Ketamine.
No, I don't think that is their argument. Their argument is the maltreatment she suffered at Johns Hopkins, including not managing her pain, holding her down, stripping her naked, taking photographs of her, keeping her away from the toilet, locking her in isolation, not allowing her to see friends, taking her communion, taking her mother away from her, keeping her from visitors. All of those things contributed to her and keeping her from pain medication because they didn't control the pain. At least that's what plaintiff is saying. All of those things together made her life worse. Now, gave her PTSD. She didn't get PTSD because of the not having ketamine. She got PTSD because they tortured her. They held her in a room, they isolated her, they surveilled her with cameras, they stripped her to her underwear, took pictures against her will while she was crying and saying no. Some of you in the chat hadn't heard of that. Yes, they did that. Those pictures never made it into the medical records. They had no medical purpose. We don't even know where the pictures went. They showed the pictures in court. They're on Kathy Beatty's phone. But who else did she send them to? They sent text messages back and forth between themselves talking about how they predicted her mother was going to kill herself, and nobody did anything. These people tortured this family. They tortured her. That's why she has problems, not just the ketamine. It's not the ketamine.
In the amount that was given in Mexico is different than a lesser dose. And this jury's already been told multiple times that the dosage of ketamine in the amount that occurred in Mexico is not available in the United States. So,
because this, let me give you an example. Mr. Trent took the witness stand. This is also why this is relevant. Mr. Trent took the witness stand, and it was memorable. I'm sure you remember because we got into it. She was a freight train heading to college. This ketamine was all working, and because you didn't give her the ketamine, she's now a wreck and can never do X, Y, and Z.
No, that is absolutely not the argument, Shapiro. I wish that the plaintiff would stand up and say, no. That has not been our argument. We're making the case that everything Johns Hopkins did, especially the maltreatment of this little girl, led to her PTSD and all the trouble that she's having and her family and her mother dying.
These records go exactly to my cross-examination of Mr. Trent, and the jury needs to see them because the only picture they've gotten from the plaintiff is, and especially with their expert relying on it, from everything I've seen, Maya Kowalski was happy, healthy, and thriving with ketamine. These words from Beata, a first-hand witness, exactly what's happening to Maya during ketamine is essential for the defense to be able to rebut the information that Mr. Trent is showing that this freight train heading to college was actually near death on a table in Mexico because of the treatments that they put her through then, and they continue to advocate in even higher doses at Dr. Hannah's office. And that's exactly the point. I mean, he was giving 3 to 7 milligrams per kilogram per hour in an intubated session. Dr. Hannah was giving 23 milligrams per kilogram per hour, and we need these records to be able to say that this is what ketamine does to somebody, not this rosy picture of what the plaintiffs are showing. You get a couple doses of ketamine and then you're swimming in the pool. And they're asking for over $5 million in ketamine as a reasonable, as a necessary treatment. And we need these to be able to tell the jury, no, this is what ketamine does to a child. So it goes to damages, it goes to medical malpractice, it goes to aggravation, it goes to state of mind, it goes to a number of relevant issues.
and I said, I will take it under advisement. I continue to struggle. I feel like we're almost on a collateral issue.
I understand where Your Honor says, to us, it's the heart of the case. That's all I can tell you.
Just on this point about this being relevant to Mr. Trent's testimony. Specifically, the $5 million in ketamine that Mr. Shapiro just referenced is not for recurrent ketamine comas. It was for the infusion treatments at Dr. Kirkpatrick's office, the same type of treatments she was receiving in the United States immediately before the hospitalization. So what's relevant is the demand or request of Beata and Jack to have a similar dose that Dr. Hannah was giving. Nothing about a ketamine coma and what transpired there. And again, there's no file break line against Dr. Canty.
Let's move on. What's next?
3149. There's actually 12 of them. It's her advising Dr. Patrick of.
Isn't this similar to the one that we just ruled on?
Yes.
Yes.
I think we're
the terminally ill stuff. You've
No, I don't think this. Oh, it is. Okay. I thought it was. Oh, yes.
We're going to revisit that
This
on
one.
Proffer.
Yeah. 3150. Oh, we must have skipped one, Judge. This is coma day 6. Somehow got.
let me just see it.
Yeah.
Let's not have any argument on it. And
Right.
it'll be taken under advisement.
Yeah, I just think we. Yes, this belongs in that same grouping, Judge.
3151 clip.
No, I think that's day 6. So that's. Is this 3150?
Yeah, there's a few of these that are ordered, 3151, 3152, 3153. There's several more, Your Honor, not to interrupt you, but if we're going to group them all together, we can show you the next ones in the series. There's
Yeah, let me, I finished 3150. Show me the next one.
3151.
What's next?
3152.
Lisa, is this true? That's so funny. I had to pause, so I'm an hour and a half behind. Closed captioning called the therapist Miss Massacre. That's what we're calling her from now on, Miss Massacre. Miss Massacre. So they just want to put in all of these emails she sent to herself, and I really need to know if she published these or if they're just emails to herself, because I feel like emails to yourself, ugh, there's just something so wrong about reading those. You know?
What's next?
3153.
What's WC?
Wheelchair.
I mean, this one doesn't seem to discuss anything about medical, so
We'll agree.
3153 will be out.
3154.
This looks like the same email.
Oh, I apologize. Is it? 3155.
So 3154 is out as well.
Sorry, I think 3153 was the one that I missed. Wait, Clay, we go back to 3153. Oh, sorry, 3153.
Ginger, if you just got here, then you
Yeah,
missed
okay, so
my
3153 and 3154.
missed my
So the
meme.
transcript's clear. 3153 and 3154 are not admitted.
3155.
I made a meme. I did a thing. No cake for Jesus or sick kids at Johns Hopkins. No cake or Jesus for you. All right, let's see. Oh, that one was medical. Yeah, it's just a diary of events and what they're doing.
Do you want hard copies of these?
Yes, please.
Yes.
Yeah, if I can take them home tonight. Okay, just query, how is it possible if Beata Kowalski's in the United States and this is happening in Mexico, how is this possible?
I'm sorry to follow you.
Well, assuming that this is Beata, and I think that's what we were working on, I flew to Monterey Saturday the 19th, and on Sunday the 20th, I got admitted. And it's talking about specifics.
I think that goes to our concern over the reliability of all of these emails.
Well, I think she emailed from Mexico, isn't it?
Well, it says mommy couldn't switch her clients and couldn't get the time off from work. So daddy had to fill in mommy's shoes.
But it's still, there's still statements by the decedent which are chargeable.
So she wasn't in Mexico.
Mom's recollection and statements about what went on with these comas and these boosters, which again.
Well, how
Was anything she's writing even real? If she wasn't in Mexico, how can she describe her coming out of the coma?
how can mom make a statement if she's not there?
Ah,
I mean, just practically, how's that possible?
isn't that what I just said?
The other reason we would admit my dad is I think it goes to the state of mind of the potential Munchausen's diagnosis and criticize with mom logging as if she's not.
What's the next one?
Which one is this one? 3156.
Whatever happens in Mexico stays in Mexico. Oh. Where did my phone go? I dropped my phone.
Well, again, I mean, this refers to mommy being in the United States while all this stuff's happening in Mexico.
I'll just hear this one last time again.
If it's duplicative of what you've already said, then no. If it's something new, then okay. Is it anything new?
I think I've already made the point about the Munchausen diagnosis.
Yeah.
Okay. Now, and for the sake of expediency, there's about 30 of these. You want them all printed out and given to you rather than going through them one by one?
Yeah, that's probably better.
I just don't want to keep you here later than you want to be.
And many of those that are come judge are not in Mexico. They are stateside and monthly updates that provide a foundation of baseline leading up to the 2016 mission.
And so you'll be able to print those out in a few minutes here. Okay, so let's go on to the next one that is not in this series. That
Oh, there's more. Ugh. Distasteful.
Just Clay, will you print them all the way through 3181?
It's just it's distasteful.
Unacceptable. I'm just looking at your list here. It's like 3172 might be different type of thing.
We'll pull it up in this.
That would have been perfect. All right, can we fast forward through some of this? I want to get to the part where the judge says, I don't even know what you're arguing. I don't know what your case is. That's the part I want to. Okay, this is more emails from Kirkpatrick. I really want to get to the part where the judge tells them he doesn't know what their point is. He's like, does she have Munchausen? Does she not? Does she have CRPS? Does she not?
3176 in evidence.
Okay, I have to skip over this.
Can you
'cause
just so
I have to get to
2415?
it.
Let's just tell me 3117 with 31.
I have to get to the end part.
Any objection?
We already read about that. We know about the extraordinary nurse.
This is in March of 2016, Deanna writing to the church requesting this information be put in a flyer for a fundraiser.
Oh yeah, because if you request a fundraiser for your kid, you clearly are a sick child abuser.
I've been unclear as to whether.
Okay, here it is. Here it is. This is the part. This is the part where the judge is like, I'm
Contending.
unclear. I'm unclear what your case
It is
is.
all for financial. So I don't know. Yeah, actions under that. Deanna Kowalski is putting her daughter through all of this because she can make a few $1,000s. The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah, it's expensive, but the reason she's seeking money is because insurance doesn't cover the treatments. So I don't know how you can extract that and then make an accusation against the mother that she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or not?
Ah.
Well, let me ask you this: is the hospital?
Okay, are the plaintiffs making the case that the hospital misdiagnosed Munchausen or no? Is that what he said? This is important that we get this right.
Diagnosed Munchausen or no?
That she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or no?
That we misdiagnosed Munchausen or no?
Well, let me ask you this: is the hospital contending that mom had Munchausen?
Well, the diagnosis.
Oh, are you alleging? Is the hospital alleging that mom had Munchausen? Look at his response. Shapiro's response.
Is the hospital contending that mom had Munchausen?
Well, the diagnosis code that we have to defend says one of the reasons for transfer. It's in the diagnosis. So
Yes.
one of the diagnosis are the plaintiffs.
So yes, are you saying yes? Is that yes then? How come he doesn't want to say yes?
Alleging that that's a misdiagnosis. It's one of the diagnoses. Are the plaintiffs alleging that that's a misdiagnosis?
Because I've been unclear as to whether the defense agrees that whether she does or does not have CRPS.
Me too. Me too. I'm unclear about that too, Your Honor. I don't know if they think she has it or doesn't have it.
The defense of this case, from a medical malpractice standpoint, is that whether this was psychological, RSD, conversion disorder, Munchausen's by proxy, the treatment would be the same: physical therapy, cognitive therapy, occupational therapy.
No, that's not the treatment you gave her, though. You held her down and shoved a tube down her throat. You held her down. You stripped her. You took pictures of her. You stripped her from her family. You turned her parents over to the police. You didn't listen to her. You didn't give her those things. You didn't do those things, though. No.
What I'm asking the plaintiff is the plaintiff alleging
You threw
that the
Jesus in a
Munchausen
dumpster?
diagnosis was wrong, that we committed medical malpractice by having that appear in our record, that we committed medical malpractice by having that on the transfer code, that it goes to that because of that allegation that pushed Beata to some type of intentional infliction of emotional distress. If they are, then we absolutely need not just these that I'm going to hand to court, but these things of fundraising, because it does go to that diagnosis. So the answer to Your Honor's question is, we don't plan on making this case about whether she had, which.
You've done that from the beginning. I'm trying not to shout here. People are sleeping. They've done that from the beginning, though. You have insinuated from the beginning of your defense that this woman had Munchausen syndrome by proxy. You cannot now say, well, we're not doing that unless they say that we misdiagnosed it, and then we're going to drag her through the mud with these Yeah, they can't say they diagnosed her. She wasn't their patient. It was a children's hospital. They can't do that. They can't make a medical diagnosis like that, a psychological diagnosis.
Disorder they had, but we definitely, if the plaintiff is going to allege, which I think they have clearly, that the diagnosis of Munchausen inflicted distress, stopped transfers to the Moors, was a medical malpractice diagnosis, then this would go to our defense to say that that diagnosis was one of the working diagnoses on the district.
Yeah, I'm unclear.
Okay.
Because I go back to opening statement, and Mr. Hunter made a statement to the jury to the effect of, we did not have to be right, we only had to be reasonable.
Correct.
Which I thought was an interesting statement at the time.
Interesting, he says.
But I'm unclear now by what you're saying, whether the hospital agrees that Maya Kowalski has CRPS. Because
I'm unclear about that too. Sometimes they say she does, and sometimes they say she doesn't. Sometimes she has CRPS when it suits them, and other times it's all in her head.
I just heard a whole bunch of depositions today that seems to suggest that the hospital is saying she doesn't have CRPS.
The hospital's position on this, from the defense's point, is very clear.
It's a
the
fluid
diagnosis
defense.
of CRPS is questionable. Whether she has it or
It's a non-binary defense. We don't want to go one way or the other. Hashtag non-binary defense.
not is subject to debate because of CRPS is questionable. Whether she has it or not is subject to debate because there's no test to rule it in. There's no test to rule it out. It's a syndrome. It's not, you can take a blood test and say that, you have CRPS the way you could say you have leukemia. But from all children's point of view, whether she had CRPS, whether she had psychosomatic pain, conversion disorder, or whatever the new language was that you heard from the doctor, the medical treatment for this is the same: cognitive behavioral therapy, physical therapy, occupational therapy, all of which we provided.
You provided that, and you provided a strip search, an isolation room, keeping her away from the toilet, making her soil herself, live in unhygienic conditions, let her hair get so matted that her aunt had to cut it, not help her brush her teeth, took Jesus, threw him in a dumpster, took her rosary, took her prayer book, separated her from her mother, limited her visitors, wouldn't let her see her priest. Did I mention throw Jesus in a dumpster? Because they threw Jesus in a dumpster. You abused her under surveillance. Thank you, Night Owl. No, you didn't give her the decent standard of care. This is nonsense. Continue, Shapiro.
And all of which, to the extent we could not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see in the discharge that if it's on the admission diagnosis, we provided treatment for her
And
if
took
she
her
would have
cake.
had it. It's also on the discharge. CRPS is on the discharge diagnosis as a
And took her cake. How could I forget? And they took her cake. Stole her dress, stole her mail. Isn't tampering with the mail a federal offense?
can't rule out. So the hospital's position on this, I don't think is, should not be unclear to this court or to this
But it is unclear, Shapiro. You've made sure that it was unclear.
jury. We are not taking the position that mine never had CRPS. It was a diagnosis that we considered, we respected, we provided treatment for, just the same as if she had a psychosomatic disorder. And on the discharge diagnosis, it says it can be ruled out. So if that answers the court's specific question about what our position is on CRPS. There's just not a blood test for this that we can say, yes, she had it, or no, she had it.
I heard what you're saying. I'm not sure I think it's a clear answer, but I hear and I appreciate the line you seem to be trying to walk. I'm not sure I totally
It's
understand.
not working.
Yeah,
Clear answer.
I'll try to give it to you in 10 seconds. To the pain management team, it didn't matter. The treatment for, and Dr. Elliott has testified to this, our pain management team testified to it. I think the ICU doctors, I thought, testified to it, but our pain management people will testify to this. The treatment for RSD/CRPS is exactly the same treatment as cognitive behavior, as conversion disorder or any psychosomatic, or I think it was called central sensitization disease. It's cognitive, physical, occupational therapy. And to
The answer is we don't know. We have no freaking clue what's wrong with the kid. We never did, and we still don't. And if we say that she has CRPS, well, then the plaintiff wins points. And if we say that her mother had Munchausen's, then we're on the hook for medical negligence because we didn't have one adult psychologist look at her. Sure.
to the all children's team, it didn't matter whether she had CRPS or not.
Well, then my question back is, does it matter whether mom had Munchausen? Because
Let the judge talk. Sit down and shut up. It is his turn. Did you hear it? Did you see that? What?
Does it matter whether mom had Munchausen? Because one, Johns Hopkins All Children's Hospital has taken the position that it's a children's hospital. It's not an adult hospital. It did not seek to provide any care and treatment. There's certainly evidence that's been adduced that this is a diagnosis that would impact Viata. Frankly, I'm struggling to see how it goes to what type of care for CRPS that the hospital did or did not provide to Maya, and the focus is on Maya for medical malpractice. So that, I'm struggling with why we're spending so much time on it when it doesn't seem to be an actual issue in the case.
Only because the plaintiff has injected this into the case, saying that your diagnosis of Munchausen by proxy or as a reason for the transfer is the reason we couldn't accept the transfer, and it was a negligent diagnosis. Your diagnosis of Munchausen by proxy caused intentional.
Correct me if I'm wrong, but I don't think the basis of medical malpractice is the diagnosis that precluded a transfer. Is that, am I misunderstanding the case?
Oh man.
That specific.
If the judge at this point doesn't know what's going on in this case, we are up Schitt's Creek, man. We are really up Schitt's Creek.
The question whether the listing of Munchausen by proxy on a transfer diagnosis is not the basis for a malpractice claim. That was first an issue raised in this case by the defense when they attempted to claim that effectively Jack and Beata had been unreasonable for not accepting that psychiatric diagnosis in that transfer, and it was on them for not accepting the transfer to Nemours. Then we get testimony that Nemours doesn't in fact have a CRPS inpatient program, and Ms. Beattie lied on the phone to Beata Kowalski, and it was a psychiatric diagnosis they were trying to transfer her for. Let
me stop you because I need to understand. Is the plaintiff saying that there was negligence on the part of the hospital having to do with having that diagnosis, the conversion / Munchausen?
All right, let me tell you what I think the plaintiff should say. Because if the plaintiff says yes, that we're saying that was a negligent diagnosis, then they are going to be allowed to bring in all of that self-journaling stuff to defend against the charge that they made a negligent diagnosis. I think I would go with they should the negligence was in making no, that's kind of the same thing, isn't it? They didn't have the authority to make that diagnosis, so they put it fraudulently on that paperwork. It was not, they never had a diagnosis, right? They didn't. No one diagnosed her. It was just an accusation. I don't know if they can. We'll see what Whitney says here, but I know he's not going to say yes. He's not going to say, because he can't. Because if he does, then all that journal shit is going to come in.
As a medical negligence on failure to transfer.
I just want.
Wait, no. Failure to transfer. They couldn't transfer. Nemours turned them down. Let me hear that question again.
As a diagnosis that having to do with having them a part of the hospital, of saying that there was negligence on the part of the hospital having to do with having them that diagnosis, the conversion / Munchausen, as a medical negligence on failure to transfer.
The judge is confused about something. Conversion disorder and Munchausen are not interchangeable, so that's one problem there. Conversion is something different. Munchausen is the parent. Conversion could be the patient, but it's not Munchausen / conversion.
I just want to rephrase the question, make sure I'm understanding. Is our position that it was a breach of the standard of care to use Munchausen in the transfer diagnosis? Did I understand that correctly?
Are you claiming any sort
Nobody knows what's being asked.
of damages? Let's do it this way.
Sure.
Any sort of damages associated with a non-transfer that occurred on whatever date that was or that time period.
When was the Nemours transfer?
There was two attempts, right?
It was in November, and I would only, in May, Your Honor, I would.
Not even the lawyers know what dates these things happen. Don't feel bad. We don't have a timeline. The lawyers don't have one either.
You can broaden that to ask the plaintiff, are they seeking any damages from this defense for the diagnosis of Munchausen by proxy? If they're not, that may simplify what Your Honor's concern is.
Well, I'm going to try to answer the court's question first. I don't believe we're allowed to seek damages from the transfer attempt in the context of a Chapter 39 proceeding. I think that was a defense theory raised to muddy up the false imprisonment claim. And now I'm hearing that this transfer diagnosis or transfer attempt wasn't even made until the middle of the dependency proceeding when Chapter 39 shelter order was in place. So, I'm sorry.
No, go ahead.
With respect to Munchausen by proxy, I think the court a second ago spotted the issue, which is that's a diagnosis of the mom. So they take a position that's duplicitous. That is in their records.
Very good word to use, duplicitous. It kind of goes with the non-binary defense. Doesn't duplicitous mean two-faced? It's the non-binary duplicitous defense.
Munchausen by proxy, there's no question. But then they retreat and say, well, we're a pediatric hospital, we can't treat or diagnose adults. But yet their records of Maya Kowalski are littered with an adult diagnosis. We have been asking the question for years, and this is what you're hearing. We can't even get a frank admission as to whether or not CRPS was or was not a diagnosis of the hospital they were treating. We've tried innumerable times. They won't commit to what their diagnosis was. And then to take the position that the treatments for all of these conditions are identical. Well, that's preposterous. But secondly, if that's true, our breach of standard of care, Dr. Duncan testified to this. If you're taking the position that all of these conditions, no matter what they are, require cognitive behavioral therapy, and you provide 3 hours of cognitive behavioral therapy over the course of a 3.5-month admission, we can go with that for the moment, and it's a breach of the standard of care no matter what diagnosis they ultimately land on, but they won't land on one.
Well, with respect to the first attempt transfer, the one in October that occurred during the period of time for the claim of false imprisonment, it seems to me whether mom had Munchausen or not is not the issue. Because the evidence, the issue is mom didn't want to sign the form because of that diagnosis. So even if the plaintiffs, or sorry, even if the defense said, well, mom had Munchausen, that doesn't change the fact that mom wasn't going to sign the form. And so that doesn't go to the question of false imprisonment.
Right, the form was.
So how does it go to Maya's medical malpractice claim or any claim that's actually remaining in this case?
Okay, to correct, that transfer temp was in November, but I would just reiterate this.
The first one was October.
The first one was October, but the form was for a November transfer.
Okay.
But all that being said, I think I see exactly what the court's question is, so I would ask it again. Are the plaintiffs seeking damages from my client for any of the counts for what they're alleging is a miss or a false diagnosis of Munchausen by proxy? If they're not, if we have a stipulation from the plaintiff, we're not seeking damages from you for the diagnosis of Munchausen by proxy, then I don't have to put on a case about why that diagnosis was correct. So I turn to the plaintiff and ask him that again.
So you did falsely diagnose someone in a children's hospital, an adult with Munchausen syndrome by proxy? Who did that? There wasn't a psychologist or a psychiatrist practicing anywhere in that hospital that could have given out that diagnosis. You are not allowed to diagnose that. Why is the judge not seeing this? And I understand why the plaintiff can't say, yeah, we're because then it opens up the whole door to them trying to, but they've been insinuating she has it this whole trial. They've been insinuating she's a crazy lunatic this entire trial. How are they going to put that toothpaste back in the tube anyway?
I want the defense team to huddle inclusive of Mr. Hunter and the plaintiff's team to huddle inclusive of Mr. Anderson. I want you all to talk.
Oh, what now? That's it? That's when it ended? Really? That's when the court coverage stopped?
Have time after calling Dr. Mendez, Dr. Katz, and seeing Dr. Elliott. To your question, Your Honor.
Since they're not seeking it, we don't have to deal with it. Seems like a lot of this issue goes away.
I totally agree. Totally agree.
Wait, why is Fat
This
Superman, why is
You
Fat
agree-
Clark Kent clapping?
Exercise, if you're not going to seek it, and you saying that they have a valid claim, but
Wait. We got to go back.
I mean, I hear what you're trying to say, but sitting here, it doesn't seem to come across pretty clear as far as the evidence that you're presenting. If we get to the point where there's an agreement as to the plaintiffs are not seeking damages, and I'm not saying that they have a valid claim, but for this exercise, if they're not going to seek it, and you agree that they're not, since they're not seeking it, we don't have to deal with it. It seems like a lot of this issue goes away.
I totally agree.
I don't like the fact that Fat Clark Kent is clapping. If something the judge says makes the defense team start clapping, then perhaps the plaintiff does not want to go that route. Look at Shapiro's face. He's far too happy about that. I don't like that look.
Totally agree.
Look at that big smile like a Cheshire cat.
So,
okay, we'll huddle.
You need to huddle, and I really want to know on Monday the outcome of it. I also want to know if the hospital has a more clear statement as to whether Maya Kowalski has CRBS.
Okay, I thought I announced it, but I'll try to
Well,
synthesize it.
it might be that you're just going to go with what you went with, and that is what it is.
Okay, thank you, Your Honor.
But let's go back and sharpen our pencils and look at the actual claims that are in this case. And knowing that I've knocked out a whole bunch of claims, both before trial and during this trial.
It goes to the same issue.
Okay, so we're not going to find out until Monday. Well, that's a letdown. I don't care what else happens. So we will We will stop this. That took way too long. And let me look at your comments real quick. Let me get over to Rumble. What are you guys doing over there? What's going on over on Rumble? Did you guys remember to hit the thumbs up button, I hope? And on YouTube, did you hit the like button? All right, I'm ready to go. This has been a 5.5 hour stream already. I can't believe it. I was only going to be here for 2 hours. This trial is something else. I can't look away. You know? Thank you to everybody who sent super chats and make sure that I don't, that I haven't missed any. Let me check the Venmos and the Cash Apps. But make sure that you're following me on meganfox.locals.com because that's where you're going to find all the notifications of where I am and when I'm going to be back, and when the next stream is. Obviously, we'll be streaming on Monday. I need to get into some of the Pennsylvania stuff. We still haven't gone through that. There's a 100-page report coming out of Pennsylvania about the false allegations of child abuse and Munchausen syndrome by proxy with Dr. Deborah Jensen. Oh, and there's an article we got to read. USA Today has launched an investigation into Dr. Sally Smith. Did you know about this? And they are planning on reporting on it all for the next couple of months. So they are doing some good work, some good investigative journalism into Dr. Sally Smith and the number of families that she has terrorized in Florida. So I'll be bringing that to you as well. So I don't think Johns Hopkins is going to get away with it, no matter what happens in this case. Lois says, your live didn't show, looked for it all day today. Okay, well, this is the problem with only subscribing on YouTube. I definitely want you to subscribe here and hit the bell and everything, but YouTube is asshole and they sometimes don't put out the notifications, which is why I tell everybody to follow me on meganfox.locals.com. You can follow me for free. If you want the paid content, it's only $5 a month, and you can use promo code Maya for a free month when you sign up monthly. Yeah, really, YouTube hides my notifications from a lot of my subscribers. I mean, because look there's 300 of you here. I have 20,000 subscribers now. Does that seem right to you? 20,000 subscribers, 300 live viewers. No, that's not right. They're not sending notifications. They hide my channel. So make sure that you are subscribed on Rumble too, because when YouTube finally does decide to get rid of me totally, I'm still over on Rumble. Megan Fox Investigates on Rumble. All right, so that's it for tonight. I'll see you guys again soon. Follow me on Locals. Make sure you pay attention there. Hit the notifications, turn them on. See ya.
I was so lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. Oh, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. No, I don't wanna say. No, I don't wanna say goodbye. No, I don't wanna say goodbye. This time I know my road is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. And my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye.
Johnny's problem is he should come storming in there with a string of garlic and some holy water. May the power of Christ compel you.
No, I don't.
You realized his house was infested with succubuses.
Of what? Yes.
Sucky loaders.
When you arrived in the afternoon. I don't remember saying it now. So while she
No wonder he said drown her before you burn her.
Oh my god.
Your next witness?
Now I know
Witness
why you wanted to drown her.
Laces, and that
Next
is
witness
also
lives in
by
Romania.
video.
Is that correct?
That begins with Ms.